against women, that we do not see any kind of a deterrence approach happening, any kind of decrease in crimes happening. And hence, about 2 months back, there was this RJ World Conference 2020. It was very powerful, in which one of the victims of rape, in fact, Alavi Griffith, and we are both members of a Global Advisory Council on RJI. She was a rape, she's a rape survivor, and she felt that, she needed to ask the offender, why did you do this to me? Why did you rape me? And this was very powerful for her own healing. So when we are dealing with cases, what happens is that the victim's voice is never heard. They never get the chance to raise those questions. It's the state that intervenes. So this movement of restorative justice is applicable to very serious crimes, though initially it started dealing with petty crimes. But the empirical evidence that is finding is that it is most powerful in cases of violent crimes as well. So we will have, in fact, some of the persons who have been victims also. It's important to hear their side of the story as well and understand what their needs are. Compensation is just one of their needs. The other very important, significant issues also need to be considered. And the challenges in implementing the idea of the ideals of restorative justice, the restorative justice outcomes that are there. The challenges lie because it will be the legal framework that will define, and it's in no way, restorative justice does not replace the legal framework, it does not replace the criminal justice system framework. So that's very important to understand also what restorative justice is. And there will be the judiciary and the police, which has a very important, and the prosecution, a very important role to play, since they are the gatekeepers and they are the referral agency for restorative justice. And the United Nations has given basic principles for the use of restorative justice in criminal matters. This conference is going to be dealing with the various issues in terms of also how to deal with the hate crimes, how to deal with sexual violence, violence against children, and whether it is applicable, restorative justice can be applied in those cases, and what are the various key learnings that have taken place in these significant areas. One of the other aspects is also, since time is limited, that this conference will be, of course, no conference is of use unless we have a roadmap and we have a vision of what we want to establish. So the last theme of the conference will also dealing with the roadmap for establishing a more effective justice framework, which will be sensitive to the idea of restorative justice. This is a journey that we are embarking on. It will have many bends and curves. There will be roadblocks, and we need to be aware of what those are, and we need to learn. So we have experts like Professor Brian Steels. In fact, this is the third conference I have called him in the Indian context, where he will be sharing particularly from the indigenous viewpoint, and we have them critiquing the Western criminology as well. We will be having experts. I mean, somebody where sometimes it's also the state which acts as violating the human rights, and also in terms of wrongful convictions that happen, and the need for those persons to also speak. So we have Jeff Deskovic, who will be talking about wrongful convictions and the impact it has had on his life. And today he's one of the foremost proponents of restorative justice. We have Lisa Rea from the Restorative Justice International, who will be sharing her views. It's an international body of which I'm also a member, and the way that they are dealing with establishing restorative justice in different countries, and the learnings that we are seeing, whether it is a person who has family member has been killed, and the victim's own desire to reach out to the offenders. So it's going to be a very interesting conference. As mentioned by Amit Chaturvedi, we have had a tremendous enthusiastic response from people around. Everybody, we will be looking forward to those participants and the ones who are attending. It will be a great eye-opener. You will enjoy that. And please feel free to raise your questions towards the end of the day when we have a plenary session. You can jot those down. We are going to be having a body of experts who are going to be dealing with all these issues. We have Dr. KP Singh, and of course we have Mr. Sanjay Kundu, both police officers, who will be discussing about the ways, because restorative justice is in different aspects at different stages of the criminal justice system, that it can be initiated, both at the pre-trial stage and at the post-trial stage. So for the prison officers, particularly the post-trial in terms of restorative justice in prisons, is something that I am absolutely always proposing that we need to initiate those aspects. So we look forward to this journey today. Despite the technical glitches that have been there, I'm sure we are all going to be enjoying listening to a very, very wise and persons who are very distinguished jurists, persons who have established the restorative justice framework in their own countries. And welcome once again to all the participants. And I'm so thankful to HPNLU for collaborating with this institute. And thanks for all the back-end work that is being done. Thank you so much.
Thank you, Dr. Upneet. On behalf of my university, I also thank the Institute of Correctional Administration, Chandigarh, for the immense support and coordination that we have received. Thank you. And technical glitches, let me go back to what I said before the event. I welcomed my Vice Chancellor. I stand corrected. This is not the first ever. This is the second international conference that we have organized. The first one was on the 19th of November to celebrate and commemorate 70 years of the Universal Declaration of Human Rights. So this is our second foray into our interactions with scholars, experts, global platform. Thanks, Dr. Upneet. I now invite the keynote speaker for this session, Dr. Brian Steels, who is the Director, Asian Pacific Forum for Restorative Justice. Dr. Brian, we are very eager to listen to you.
Can you see me? No.
No.
It says here that the video is disabled in this meeting.
Video is disabled in the meeting. Kindly carry on with your talk. We are the matter from our end.
Okay. Well,
thank you so much for joining us.
Well, firstly, thank you, Ahmed and Mr. Kumar Singh, Upneet, who I've been talking to already this morning, Professor, for your opening address, and other colleagues here. We hope that this address this morning is both thought-provoking as much as it is critical. Now, my colleagues, Dr. Mark Brisky and Miss Christy Abbott, have contributed greatly to this address, as we're all a part of the Asia Pacific Forum, as is Dr. Upneet Lalli, as well as being associated with Murdoch University in Perth. Now, I've spoken much about this before, but Asian legal systems and their criminology are really to be seen and set apart from Western and colonial criminology that has in the past been the instrument to control and suppress so many people. This Western and colonial criminology has promoted laws that have allowed workers to be exploited as slaves, villagers to become bonded labourers, languages and culture suppressed, and often education provided as a tool to change the very heart of nations and people. However, critical criminologists like ourselves note that Western legal systems have still today much to offer, but they have to be respectful of difference and not seen as the model for everyone, the colonial impost on everyone. Indeed, the United Nations makes us all aware of the respect due to all human life, the rights of women, children, Indigenous people, and those most vulnerable. However, it does so with the regard for difference, and so it is with our address today. We value and welcome difference, the new, the exciting and the most effective ways to resolve conflicts and dispute, and to resolve violent national acts and aggressive international actions. Here we speak of restorative justice and many times refer to its close companions, transformative justice and therapeutic jurisprudence. But firstly, let me pay our respects to the elders, past, present and future, of the Whadjuk people of the Noongar Nation within Western Australia. It is among these and other First Nation people around the Asia-Pacific region that we hope to see very soon in a position to use their own kind of justice, one that's restorative, but first that gives them all a voice within Asia-Pacific criminology to lead the way. We also recognise that myself and those with me are white and privileged, and so we are careful to be inclusive and therapeutic in our commentary. Restorative justice for us is really simple. It's about a facilitated process where, if possible, both the people harmed and the people who have harmed them, together with support from both sides, gather together freely and in safety to tell and to share their stories. It doesn't have to be encumbered by tight regulations. However, our attempts are often made to make it so. We believe that restorative justice across our region should be flexible, but we find that many government departments demand that victims mustn't be given the opportunity to meet the person who harmed them, or due to the severity of the crime, or the offender's perceived lack of remorse and closeness to the victim. It is as though the victim doesn't know best. However, with the call from government agencies, with the call from victims of crime, and their supportive networks, and far away from the trappings of power, government agencies and academics are beginning to hear the call to break from their well-defined and dominating parameters and limited flexibility that often engulf the innovative, local and culturally balanced processes. So it comes as no surprise to hear that many nations across the Asia-Pacific region have used local restorative processes to deal with community conflicts and law breaking over the years. Community sanctions were common and mostly carried out by elders or local council. At the extreme end, we note blooding, a process to ensure that blood was spilled, and the harsh punishment of banishment, the imposed isolation from one's loved ones and community, often in harsh environments. But even these can't compare to some of the brutal treatment handed out to so many during the years of colonisation. With trade routes and transport came commerce, business models, money, and that in turn interrupted bartering and local markets. Property emerged as supreme and supported by the influx of traders. The commercial enterprises within national boundaries acquired an important criminal justice system from their major markets and cities of commerce. Mostly, this was an adversarial system, although an inquisitorial system prevailed in several places. These legal systems spread along with Christian beliefs to be an often excessive influence within the region, and not always respectful of Buddhist, Tao, Zen, Muslim, Sikh, and Hindu faiths throughout the lands. The imported justice models were harsh and focused mostly on the poor and vulnerable, and yet often became corrupted by landlords and commercial interests that claimed common land and empty spaces for themselves. And worst of all today, the poor and vulnerable still suffer the most. It's only restorative practices that can identify the personal and structural harm being done in a fair and just manner. For example, the concept of applying a patent on locally grown and historical food seeds is a disgrace to fairness. In a similar vein, the promises of a fortune to women who are trafficked across jurisdictions remains a plight on the region. Women remain mostly voiceless, and once again, it is restorative justice that can enable their voice of experience to be heard loud and clear. And And this really is the foundation that we're trying to build restorative justice on. It's not a flat, fair and just field. In fact, today we see expanded and overcrowded penal estates, poor people facing judgments without representation, women being traumatized by officials and women not given rights and who remain as chattels, nameless and subservient to all. We see women and children trafficked far and wide, and still today we see arranged marriages that exploit one party. Added to this is the drug trafficking and its subsequent death penalties in Indonesia, China, Singapore and other jurisdictions. We can also turn our attention to Western Australia, my home, where people of the Noongar Nation and beyond the country remain constantly overrepresented in both juvenile and adult penal institutions. They're not born criminal, but they do receive a constant gaze of the police. They accept, or they have to accept, the intrusion into their family homes and communities, where they are then arrested and charged, taken to a court and sentenced to incarceration. And all of this is done to them by non-Indigenous people who are employed across police, courts and prisons. We have researched the model restorative courts and Aboriginal facilitators where their effectiveness was recorded, and yet political intervention has seen such processes left to the wayside. The combined average daily imprisonment rate for the June quarter of 2020, that is Australia-wide, was 210 persons per 100,000 adult population, whereas the Indigenous daily average for the June quarter was 2,325 persons. That is applied on our system. For this reason, it's crucial and incumbent upon academics and practitioners across the Asia-Pacific region to institute a framework for RJ to engage at all levels. This, of course, should prompt practices both within and outside of the courts in corrective and rehabilitative services. And
Dr. Brian, we seem to have lost your audio. Dr. Brian?
practices.
Yeah.
Sorry.
Yeah, you're audible now. Please continue.
Oh, sorry. It is evident that the rights, the perpetrators are left out of the option of restorative practices as they enter the court processes with their plea. The use of the court is not always the preferred place for community solutions to crime. Local village elders can now lead customary courts and circles in an effort to have fairness of process and just outcomes delivered in a timely manner with lower cost to governments. I'll skip the comments of Tyler here on page 4 and just briefly go across the RJ throughout the region. So restorative justice and mediation diverged or converged. Dennis Wong and Louis Mock saw and examined the processes in China. Now, these authors contrasted the RJ with mediation, suggesting that really there is sometimes coercion to accept an outcome in the mediation, whereas in restorative justice, the coercion wasn't present. And in a similar vein, Zhanxiang found that China more recently found that local resolutions to crime were handled much better with restorative practices. Across the Asian region, we have in Japan the Jidang, that it makes a use of negotiating quite well between family members to resolve a dispute. Then we have deferred the prosecution and conditional suspended sentences in Taiwan, noted by Lennon Chang and and Fanny Fenn. Most recently, when I was travelling to the Thai Institute of Justice, we saw some rigorous implementers of restorative initiatives. We've got the Bangkok Rules and the Princess and the Thai Institute of Justice really working hard to bring restorative justice to everybody. And of course, as Dr. Upneet Lalli spoke, we have the panchayats in India. Latha Subramaniam and Raj Thiragaj have pointed out in their paper the value to be found amongst the local processes. And again, across the Asia Pacific, we found in the Pacific Islands, Shah found in her paper, Sexual Offences, that there were compelling arguments between customary laws and the authority of the chiefs in finding and seeking solutions for that. Now, we've had our own examinations of restorative and transformative justice. They were found very successful, but once again, we really struggled to get the government to implement anything. But with that said, the Asian region accounts for the world's most populated land masses, with its diverse languages, national identities, cultural variations with values and assumptions about crime. These underpin a variety of philosophies and religions, colonial histories, indigenous and mixed populations, and varied degrees of legal support. So it's those complementary voices that have to give voice to restorative justice. In actual fact, we, and I mentioned it in the paper here, let us remember that best practice in one environment doesn't mean it will be realised in another. And in that sense, we don't wish to see a McDonaldization, where, like McDonald's tries to influence our eating habits everywhere, we don't want one model to suit everybody. And that comes from Kitty Yarrick's paper as well, where we have to be mindful that restorative justice is an ever-evolving concept and there is no definite formula for success. So in conclusion then, we call for an open, fair and just responses to any and all crime. Specifically, we call upon jurisdictions to embrace local models of restorative justice with circles of participants helping to assist in healing the aftermath of crime and conflict. So I finish here with what can go wrong? Well, there's plenty. What challenges do we face? Here are just a few. We're facing powerful actors who have a stake in the penal estates and who will not want a reduction in the use of prisons. The challenge is to have them embrace the inevitable changes brought about by the vast costs of maintaining large penal estates. Justice reinvestment, for example, has much to say about limiting or capping funds to such institutions and spending the money on alternative justice measures. Secondly, of course, we have the challenge of justice administrators. They often need to understand much more about RJ, and will it ever take away the need for the courts in many contested cases? Well, what we're saying is RJ can be of great benefit to the courts if it's allowed to work within the transformative and therapeutic jurisprudence models, as well as within investigative and inquisitorial systems. A challenge also is the dominant corporations and crime syndicates that are always wanting to corrupt judicial processes and will fight against RJ that gives a voice to the voiceless. Then there is a stubbornness of cross-cultural and interfaith encounters where one party is prejudiced against the other. It's here that facilitators have their work cut out to find solutions to these local issues, but local families, we suggest, who witness the benefits of RJ must be encouraged to speak out in favour of it, especially at the local level. And the big problem that I've left to last is the regional attitude towards women. Like it or not, it is men who have ruled the roost for decades. Women, though, have been presidents, police chiefs, members of parliament, and corporate leaders. But sadly, they've always had to contend with the male gaze and the often public commentary on their dress code, status, and behaviour, as well as their values, attitudes, and assumptions. Women in some jurisdictions are seen more as chattels than partners. They are often the voiceless, the most vulnerable, the poorest, least educated, and impoverished in so many ways. But the solution is easy. We need, especially as men, to treat women as though they are our mothers and daughters, speak to them with dignity and value them for being who they are. Always treat them justly and fairly, elevate them into leadership roles and trust them to find the best solutions to the current issues of truth-telling, peace-seeking, promoting fairness, oversee injustice, and enable reconciliation. So, in a nutshell, we have restorative justice passed on through the ages by the wise elders and by sages. What interrupted that was colonialization. What can interrupt colonization today is restorative justice. Restorative justice offers a voice to everybody, especially those victimized and those harmed. So on that note, I thank you all for listening, and I hope that you'll enjoy reading the paper. Thank you.
Sincere thanks, Dr. Brian, for bringing to light on a very erudite note the challenges as well as the pros and cons of the idea of restorative justice. You presented to us the Australian perspective, which was combined with an encompassing cultural perspectives, touching upon issues of gender, upon issues of patriarchal societies, investigative agencies, judiciary, indigeneity, what can local support and local modes of resolving the problem of crime can be. Dr. Brian, it was immensely enriching listening to you. And in a country like India, where the idea of restorative justice has not gained the kind of popularity it should have, your ideas definitely plant the seeds for the building up of a new robust network of organizations, institutions, as well as ideas that can further commit themselves to bringing restorative justice in the public discussion and in the law-making and law implementing process. Thanks, Dr. Brian.
Yeah, thank you.
I request attendees, prison officers, scholars who have joined us to post the chat box so that we can have a small session devoted to a discussion of those very ideas. And the conference definitely becomes much more meaningful because of that interaction. I now proceed to invite our next speaker, our guest of honor today, Sri Sanjay Kunduji, another speaker, professional, well experienced. It would definitely be a complementary version of what the behavioral criminologist Dr. Brian told us. I invite Sri Sanjay Kunduji, Director General of Police, Himachal Pradesh. Thank you, sir, for being with us. I hand it over to you.
Good morning to all of you. Good morning, the Vice Chancellor, Madam. Good morning, the dignitaries and the key speakers and the chief guest. Good morning to all NLU faculty and all our speakers and all our audience who are hooked up through WebEx. Thank you for inviting me for this conference and letting me speak. So I'll speak from a different perspective. Since I am police chief of a state, I'll speak from the idea of a first responder. See, crimes happen, and crimes have been happening since biblical times, and they have not stopped. They have increased, and it would have been a very, very fair and just society if there were no crimes. In fact, when I was in the UN in Bosnia, we had a officer from Iceland. And he's a police officer. I asked him, what do you do in Iceland? He says, I investigate organized crimes. I said, do you have organized crimes in Iceland? He said, yes, many. So crime take place, whether it is Antarctica, whether it is Arctic, whether it is West, whether it is East. So let us not deny that crimes don't happen. And the crimes are increasing. Their lethality, their violence levels of brutality is increasing. The spread of crimes is increasing, and we need to address them. As a police chief, I am regularly asked by the legislature or say the press or the political personalities, what are you doing about the crime? So I have to have answers. So I speak from the front end of this problem. That is the crime, first responders to crime, public order problems, terrorism, drug abuse. So I speak from that. So the restorative justice comes towards the end. And second thing about the crime is that you can only, it's like an iceberg. You can only see tip of the iceberg over water. Most of the crimes don't get reported. And if they get reported, they don't get registered. And once they get registered, very few of them get attended and investigated properly. And after investigation, they are taken through due process. See, different societies have different behaviors. And some behaviors are crimes, they're criminalized. And there are laws to address them, criminal laws. And then there goes the whole cycle of punishment, the whole system of punishment. And after punishment, whoever is the offender, he has to be reintegrated to the society so that he becomes a meaningful member of the society. So largely, Brian said about the colonial thing, I give credit to the British for establishing our penal code, our evidence act, and our criminal procedure code. That gave everyone a common understanding what is right and what is wrong. This process has served us very well for last 150 years. And having worked in the United Nations, I know that the code that was established by Lord Macaulay here has been mostly followed in the Commonwealth countries. The second code is Napoleonic Code, which is normally followed in the continental Europe. These two large codes have stood the test of time. They may have minor variations, but largely these are very, very robust laws. Now, I don't want to promote or encourage mob hysteria, mob violence, mob trials. But at the same time, we cannot have kangaroo courts because we are a huge nation. We have to have a strong state. State should not be seen as effete. For instance, if there is a violent sexual assault, the police has to attend the crime. It has to record the statement of witnesses. The forensic science laboratory team has to come. It has to pick up evidences. We need to arrest the accused. And you also need to keep the victim away from the accused. For the simple reason, these accused offenders of violent crimes, the first thing they do is they threaten the witnesses and their families so that the crime is not reported. So that is not the stage where you can actually have restorative justice. You can have both of them to meet. It is only after some time, in some cases, can you do it. Otherwise, so much of violence is associated with brutal crimes that you cannot let the offender and victim be next to each other. Next, coming to how we solve policing, like before I became the DG, I realized that our policing methods were reactive. A crime happened and then you react. We have gone for the latest thing, it's called predictive policing. And this was started by Brett Brayton in New York, and I think we have gone to the next version of this. So basically what we are trying to do is, we are trying to do geographical profiling of crimes, temporal profiling of crimes, victim profiling, and offender profiling. And after having done that, our traditional method of policing is basically beat, pen, roll, criminal records. We are trying to upgrade them so that we are able to warn the victims ahead of time that, see, these are the vulnerable sections, or take action against offender profiling. One thing that I've done after I joined was, as per the Punjab police rules, police is basically run by the rules and the laws. The Punjab police rules are very, very omnibus kind of rules. They're very robust rules. They were established in the year 1935. And they had this method of beat patrol and also police station, crime records, police station registers. To that extent, I'll agree with Brian that their objectives were to promote colonialism or imperialism. The register that they had were regarding property, say cattle pound register and all that, which are not relevant today. Police should not be doing that. But I found that crime against women and children, especially sexual crime, are on the increase. So I started a register number 26. This has been done for the first time in 70 years in North Indian states. This Punjab police rules is even followed in Pakistan. This is register of sexual offenders. Now, the theory of sexual offenses is, if you can talk anything you want to talk, but I have cases where 3-year-old girl was sexually abused. And I have a case where 60-year woman was sexually abused. So these are sickness of mind. Sickness of mind, because this doesn't give any sexual pleasure, say sexually abusing 3-year-old girl or 60-year-old. What we believe is, once you profile sexual offenders and keep a tab on them, it is quite likely that you will be able to reduce sexual offenses, because these people tend to repeat offenses. Okay. This register number 26 that I introduced, it has met with huge success and it has become a hit all over the country. The other states are also planning to do something along these lines. So when I talk as a police chief, basically what I say is I have to be proactive in what I want to do. I don't want to let crimes happen, because once crime happens, it is fait accompli. Second thing, I have a doubt about this. Do you have victim, family, society at a large and all that, and the offender? When we went deep into sexual offenses, we found that many of these sexual offenses take place inside the family. So a lot of girls are raped by their own father, grandfather, father-in-law, brother-in-law, sister-in-law. So where does this restorative justice come into play? See, there's a lot of sickness of mind also. Why it is happening, I can't tell you. But most of the crimes, especially during lockdown, because of lockdown, the movement was totally limited. There was hardly any traffic. So traditional crimes almost came to zero. But crimes within the family, they went skyrocketing. So it is not just the victim or society. There's something much more than this. See, earlier we thought schools and educational institutions were temples of learning. So you leave at that. Police has nothing to do with this. But you find that drug abuse is common in the schools, it is common in the colleges, and you have drug traffickers around the school colleges. So institutions which were meant to be centers of learning have actually become centers of crime. So what do? How do you restore? We do a lot of awareness, we do everything. We say drugs are bad, drug trafficking is bad, it will spoil the next generation. But you have to realize that the situation on ground is totally different. Secondly, the parliament enacted, I am very happy that this was done, POCSO, basically to address crimes against children and women, and especially young girls and all that. After we started doing that, there is a proliferation of these cases. And when we started to have a in-depth study or examining these cases, we found in a lot of schools, the teachers and say principal, headmasters and the staff are actually sexually exploiting the children. When we found how many of them were from the education department, we found 52 teachers and staff were actually involved in Himachal Pradesh. And a lot of them had abused serially one after the other. So I wrote to Principal Secretary Education, I said the least you can do is dismiss them from service, because trials will take on a long time. Trials will take long time, till the time, because they've been bailed out, they will get the opportunity to further sexually exploit children. So these are the problems. And third thing I would like to say, you say that family, everything, community is over. I have a question mark there. We started seriously investigating suicides. We found the number of suicides 10 times more than murders. 10 times more than murders. Okay. And you have the whole system, criminal justice system, taking care of murders and all that. But what do you do about suicides? What do you do about people who ended their lives? So the suicides can be classified under two heads. One is 174 CRPC, where we do inquest and then finally postmortem. Second is 306, abetment to suicide. And when we were profiling suicides, we found that the largest group was actually married women. They were pushed into suicide by their in-laws. And these were young women who were married. And because of disputes within the family, they were committing suicides. So a question mark came, see, our jurisdiction or court's jurisdiction, the whole jurisprudence jurisdiction ends at the door of the family or door of the house. But what goes inside the house is also very serious. And what do you do about that? This has set us thinking. What do you do inside the house? How do you change the behavior inside the house? And we found districts like Hamirpur had highest ratio of suicides per lakh almost in India. And this is because of married women being harassed by their in-laws. So once she ends her life, what kind of justice, restorative justice can you give? And what do you do about a problem like this? See, in my life, I've seen a lot of crimes. But I say this restorative justice cannot work in brutal crimes. Second is violent crimes, organized crimes, and sexual offenses. Because they are too deep to understand. And human mind is too wicked to understand and to get right. A person who's got into selling of drugs, it is quite unlikely. We also try and counsel them, don't do it. We try and counsel people not to consume drugs. But if it were a perfect word, it would have happened. It's not happened. It is only increasing. Secondly, people have become so smart. In the NDPS Act, there are commercial quantities where bail will be denied. You'll go into the jail. And there are quantities not commercial. So most of these traffickers, what they will do is they will carry fraction just below commercial quantity, so that they escape the law, they escape the whole criminal justice system, and they continue to do them. When we saw that many of them were repeat offenders. See, Department of Social Justice Empowerment, Health Department, Women's Child, they spent endless hours counseling these people not to do this. But that doesn't happen. Now, when you talk of victim, I am all for victim. All their rights should be protected. And when you talk of offender, he or she has done something wrong, he and she should be integrated. But when the crime happens, the level of violence is so high that you cannot let them meet. Because the first thing that offender will do is threaten the victim and his family. So that is why these people are put in police custody or judicial custody. Only thing is that after some time, probably they will become less violent and they may cause less harm to the family of the victim and the victim itself. There are many cases actually where the offender, after he has been released on bail, the first thing he tries to do is get to the victim and their family, threaten them or even commit crime against them, and some extreme cases even kill them. Now coming to where this restorative justice can be utilized is, say, minor accidents. So you are in rush of work Both of you don't want to go to the police station. You come to a compromise and you say that whatever damage has been done, since I have caused the accident, I'll do it. But when it leads to death or serious injury, I think that is not a possibility. Minor accidents, it's a surely possibility. Second thing is minor quarrels. Traditionally in police also, we did not want the cases to pile up. But when there were small quarrels in the villages and other places, we used to go and we used to do something called Rajinama. Both the parties, they apologize and then they finally come to a peace and then they this. But around that time, because I was young ASP that time, I remember the courts intervened. Courts said, you are not into restorative justice business. You are supposed to follow law. So you register a case, let them go through the whole process and let them decide later. But it is a good thing that 35 years from now, from them, the clock has turned back and now there is a theory saying that they should actually sit together and sort out their problems. Common sense also said that why to elevate the problems? Why should they be spending time in court kachari or courts? If something wrong has happened and they need to mend fences, they need to apologize, they can sit and police can basically countersign. It was quite effective. But I think courts intervened, that then we went around the whole process of criminal judicial system. Now, indigenous ways, tribal ways is accepted for minor crimes. And they have tribal ways in Himachal also, Kinnaur, Laos Spiti, they have elopement and all that, that is fine. All that is fine. But when it leads to violent crime, I think that is a strict no-no. A lot of powers have been given to village panchayats in Himachal for trying small offences. And they are doing it also. But a lot of time, what happens is that police is accused of minimizing crimes and sending them to the panchayats rather than to the courts. So a lot of MLAs and others, they complain to me that police has tried to minimize the case and now they have made it panchayat tribal. You try and explain it to them, this is restorative justice, they don't understand. They say no, police has not been doing its due diligence and you have tried to minimize and you have sent it to this. So largely, then small vandalism where you can do community service, totally doable. And misdemeanors, it's totally doable. But at this stage, I think things are not right to take this forward to brutal crimes, violent crimes, organized crime, and sexual offences. Thank you for hearing me out. And I'll be open to any question because I speak from my experience as a police officer. And I know the pitfalls of this. When all these doctrines are put in practice and then the rubber meets the ground, that is where the problems happen. And I don't want to condemn the present system. I do quite disagree with what Brian Steele says. The Britishers gave us a good system. And over the years, there have been some change in profile of crime, change in everything. We need to take it forward, but we just cannot condemn the system that we have today. It has paid us well. There is always a scope for improvement, and I think restorative justice gives that kind of scope. Thank you very much.
Thank you so much, sir, for this enlightening talk. As I mentioned before you started, your talk definitely was and has turned out to be a complementary version to what Dr. Brian said. It's fashionable in the academia today to talk about critical criminology, feminist criminology, and those are very developments. But they do learn a lot from lived experience of professionals, especially experience of your. The two talks that we heard from Dr. Brian and from you definitely set the tone, and we hope to arrive at a middle path by the time we end this conference tonight, this evening that is. Thank you so much, sir, and this is a perfect setting of the tone for the debates that are to follow. Where do we meet? I invite an initial resolution of this debate or tension or some identification of the meeting ground. Our chief guest for the day, Honorable Justice Peter Matthew Paris. Sir, it's an honor to be in a conference where you are the chief guest. Thank you so much for being here, and we really hope to learn from your words. Thanks. I hand it over to you, sir. You need to unmute yourself, sir.
Yes, yes, of course. I completely.
Yeah.
Again muted, sir. Unmute, please.
Right. Can you hear me now?
Yes,
Can
sir.
you hear me?
Yes,
Yes.
yes, sir.
Excellent. Excellent. So good morning to each and every one of you, and thank you very much. And once again, I'm delighted to be with you this morning, and particularly for the university in Himachal, and where Professor Jaswal actually heads the institution. I've been listening with great care to the diverse views that have been expressed this morning. Now, let me round this up. If I was to summarize the entire discussion, we had Professor Steele, then we had the young lady, and then we had DGP Himachal Sanjay Kundu, who gave us the other side of the coin, so to speak, right? And take it from me, this is my 45th year in the law. I was Attorney General, I was Chief Prosecutor, Chief Justice, Senior Legal Advisor to the Cabinet, in human rights, right in the thick of human rights, in the Human Rights Council in Geneva, in the United Nations General Assembly for Restorative Justice, because we went through a 30-year-old conflict, which bled, it was internecine and it bled the country. Now, how do we reconcile all these, the multiplicity of thoughts when it comes to restorative justice? I can well appreciate what the DGP actually said. Having been a tenacious prosecutor fighting for law enforcement, I worked with the police for years and have great affection for it. But at the same time, we also need to perhaps to be sensitive to the weaknesses in our own system, because this is something that it was a heritage that we succeeded to from the British times. Perhaps it's time that we decolonized our laws, but that's far away. It's farthest from us just now. Now, be that as it may, can I summarize all this for you in the context of what I have heard? Simply put, what we have heard, restorative justice restores victims, restores perpetrators, and restores communities. It is about the idea that because crime hurts, as the DGP quite rightly said, it is because crime hurts that justice should heal. Because crime hurts, justice should heal. In modern times, restorative justice, as we have heard, and endeavors to apply its principles in an environment of aggression, in an environment of hostility, wars, internal conflicts, terrorism, crime, and regulation, and so on. Now, if you read John Braithwaite, who probably was one of the exponents in restorative justice, who wrote extensively about it, he says that restorative justice is partly about the aim that justice processes repair the harm done through domination. Whether that is domination of crime, whether it is the domination of war, or perhaps simple university bullying. Think about it, there's not much of a difference. So restorative justice has a place for quiet contemplation, or perhaps what is called true contrition. True contrition, right? In other words, where there is a catharsis of the soul itself. but is more concerned with the principal actors taking blame or active responsibility or a guarantee for justice at a future time. A guarantee for justice at a future time. You will appreciate that the process of acknowledging past domination and submitting oneself completely to transcend the process of genuine contrition for the wrongdoing can be heavily laden with shame. Heavily laden with shame. Without doubt, it has great shame, has a great potential for humiliation. Humiliation, right? Avoiding humiliation, I'm sure DGP Kuldeep will probably tell you, where when a great politician or a leader is taken away from court in manacles, they know greater humiliation the fellow suffers, right, than to be seen by the public in such a pitiful state. Avoiding humiliation, therefore, and preserving one's dignity, whether it's individually or institutionally, are an integral part to shame management in restorative justice. It's shame management in restorative justice. It is said that these are reasons for conceiving restorative justice and shame management as important to crime prevention and the prevention of conflicts. My dear friends, restorative justice is a process of realizing values of non-domination by principal stakeholders, where we would transparently address questions such as what happened, how were people affected, and what needs to be done to make things better. I can tell you I drafted the Restorative Justice mandate for the Lessons Learned and Reconciliation Commission in Sri Lanka, and I followed the principle of Ubuntu of South Africa, right? The Peace and Reconciliation Commission. In fact, I drafted the mandate between New York and Colombo, returning from the United Nations Human Rights, returning from the General Assembly, after having deliberations with the then Secretary General. So, to the pioneers of this concept, the area of restorative justice is an effort to transform the way we think of punishment for wrongful acts. You will appreciate that when an unlawful act is committed, it has undoubtedly an impact on the victim, terrible impact on the victim, terrible impact on the offender, concerned bystanders such as family members, employees, or citizens, and the larger community in which the event occurred. My dear friends, restorative justice is simply the terminology we give to a series of practices, including apologies, restitution, and the acknowledgements of harm and injury, as well as to other efforts to providing healing and reintegration of offenders back to the community with or without the imposition of punishment. Don't get me wrong. I'm not saying we must not visit them with retributive justice. No. Perhaps the strongest feature in restorative justice is that it involves direct communication, often with a mediator of offenders and victims, the affected community, to provide a setting for the acknowledgement of fault by the offender, restitution of some sort to the victim, which would include an effective apology and material exchanges of financial compensation, and invariably a new mutual understanding, a new ethos of understanding, forgiveness, and an agreement to new undertakings for good behavior. Now, my friends, it is said that restorative justice in its perfect form nothing is perfect, but in its perfect form would repair, would restore, would reconcile, would reintegrate the offenders and victims to one another and to the communities they live in. Now, this is widely known as the 4 R's, and that's what we call it. Now, I said a minute ago, when something wrong is committed, It is the victim, the community, the offender, or the larger society in which the event occurred who has an interest in rectifying the situation, in putting it right. Now, it is the victim who invariably, naturally, wants vengeance. It is the state who would be interested in deterring future crimes of that type, as DGP Kundip was pleased to observe, or the community in which the wrongdoing is committed, who would decide what justice in that situation should be about. After all, justice is people's justice. It is they who have the power to forgive and accept restitution or reconciliation. My dear friends, I ask you the question, what would the outcome of acts of wrongdoing of both individuals and a large community, such as, what would be the outcomes, such as hate crimes or genocide? The question you will ask yourself is whether collective hurt or damage to the social fabric can be forgiven by individuals on behalf of anyone else besides themselves. In other words, I'm asking the question, can the victims of crime be representative for the rest of the society that may well define justice differently? You saw DGP Kundip tell us he differs differently and is entitled to hold that view. And I understand of what he says. I mean, who might want retribution? Maybe the members of the public might want retribution to be more harsh or less harsh. So the issue then is what proper balance we should strike between victim and offender reconciliation of community peace, social order, or justice, or is justice is something that we seriously need to consider. You might also ask the question whether restorative justice works in this day and age. The DGP was pleased to list a litany of things and he said, well, it doesn't work. He's right in some situations. Does it really work, meet its own claims? That it will reduce the tendency of a convicted criminal to re-offend? Does it restore communities and successfully reintegrate offenders? Is it more efficient than the traditional forms of punishment? Is it more fair or just? These are the matters that we need to perhaps give our mind to in the course of your deliberations in the adoption of the principles of restorative justice in the 21st century. The emergence, just to take a little bit more of your time, the emergence of modern day restorative justice was in the 1970s, as you probably know, as a response to the unusually harsh criminal justice system that did not effectively deter crime nor succeeded in rehabilitating offenders. It was thought by its proponents that by providing a controlled environment in which victims and offenders met and explained their injuries and feelings of anger to each other and make restitution to victims by apologies would be a paradigm shift in the field of the treatment of criminal behavior. My dear friends, restorative justice is a practice, therefore, which is intended to heal at both individual and social level. Restorative justice has several fundamental concepts that have been applied in the last 2 decades of the new millennium, as we have seen, and extended to many areas of political and social interaction. Now, these concepts arose from the belief that the traditional legal processes were often ineffective in their bureaucratic separation of the offender from the actual consequences of the act, in the timing of any remedial action, and in the inattention, perhaps, to the personal nature of the wrong, not to mention in their failure to deter or reduce crime. So, therefore, you will agree that the history of criminal justice and punishment is one that we see of increasing state control and surveillance, bringing with it increased costs of public institutions, public responsibility with hardly any return by way of a reduction of crime, a reduction of violence, a reduction of antisocial behavior. You will readily concede that the 20th century was perhaps the most violent of all centuries, at every level right across the planet, notwithstanding the sophisticated criminal procedures in the combat of crime that have been developed. You will appreciate that quite apart from the Anglo-European criminal justice systems, other legal systems have long focused on restorative or reparative or restitutionary forms of justice, as we would see in India, which included, as someone said, community modes, wise elder mediation, religious forms of repentance and reparation, and numerous mechanisms of communal conferencing, such as the concept of nanante, a ceremony where criminal offenders bring flowers and food and kill a sheep for community feast, often in the victim's house, where the victim will perhaps cook the food and the offender brings, and the offender is told he has done an injustice to that person. Then we have the concept of Ubuntu, simply meant humanity towards others. In a philosophical sense, it is the belief in a universal bond of sharing that connects all humankind. And then we have also the concept of Gakaka, which victims and offenders stated their case, and the tribunal was headed by people of integrity in an environment of tranquility, which had been practiced in Rwanda. Now we have, of course, in South Africa, the Truth and Reconciliation Commission. Sri Lanka, the Lessons Learned and Reconciliation Commission, put in place as a restorative mechanism consequent to a long-drawn conflict in that region. Mind you, we had 12,000 security detainees at the end of the conflict. 11,900 of them are back at home today after a rehabilitative process. 594 child soldiers who had cyanide capsules around their necks are back with their parents after rehabilitation. Restorative justice. What is important to appreciate is that all these forms of justice or dispute resolution mechanisms must make provision for a narration before victims, offenders, family members, community leaders with communally arrived at outcomes. My dear friends, that is something that we have to bear in mind. It is always useful to have face-to-face contacts with community members. It is possible that the 21st century, we would see a development of the restorative justice concepts in civil and family law towards mediation, experimental programs in victim-offender reconciliation or victim-offender mediation. Somebody, of course, you have your section 357A in your criminal procedure code, which already recognizes this particular aspect of the matter. My dear friends, we see a proliferation of restorative justice programs right across the globe. We have seen, I said, the Truth and Commissions in Argentina, Chile, Guatemala, Rwanda, South Africa, Sierra Leone, East Timor, Sri Lanka. The commissions were designed to heal the nation state or civil community by allowing many narratives of hurt and harm to be told, and by creating the environment for a new collective narrative of the truth so that a society can begin afresh with new ideas and understandings of its past and its future. My dear friends, these processes are clearly evolving and offer great promise of adapting to political, cultural, and historical context, and have the potential to ultimately transform our conceptions of international justice. Finally, we must remember that restorative justice requires a genuine, well-intentioned, non-manipulative actors and sufficient resources for genuine encounters and dialogue to be successful. Therefore, even for application in the 21st century, we have to bear in mind, as some of the proponents of restorative justice would surely entertain the idea, that restorative justice can only work with a complete commitment of time and an allocation of substantial resources and the resources of skilled individuals, and can suffer from great ineffectiveness if it is approached lightly and becomes ritualistic, and if only lip service is paid to this concept, which has great potential to bring about a paradigm shift in dealing with criminal behavior. You will bear in mind that restorative justice can be extended to specialized reparative courts, like the courts dealing with drug offenses, wise courts, family courts. And if one looks at the rehabilitative potential that restorative justice offers, one cannot but recall the mechanism of the many courts that we have put in place. Now, you will appreciate that what began as an idea to reduce the punitive nature of criminal punishment has today developed into a social political movement which seeks to use restorative justice to heal not only single acts of misconduct, but civil wars, genocide, and international multi-ethnic and political and religious conflicts. Someone may end up by saying that you can get, as someone said, an academic recently said, you can get more bees with honey than with vinegar. Perhaps we can get more social progress, peace and justice with healing than with punishment in the 21st century. I hope those little thoughts would give you food for thought and perhaps strike a balance between what the DGP said and the rest of the academics said, so that we can use a fine blend of retributive justice and restorative justice and ensure that the 21st century criminal jurisprudence would assure us, would be tempered with mercy and tempered with mercy, because as Shakespeare said, the quality of mercy is not strained, it droppeth as a gentle rain from heaven upon the place beneath. Thank you.
Event along with the ideas presented by the other speakers, academy from the police force in India, they leave us with important keywords. Listening to you, sir, was like sifting through a stack of books containing books on classical to postmodern criminological thought, classical statecraft. What should be the role of the state? Where do individuals figure in that relationship? And the debate, the torque in the thread that was established in the previous two sessions was so delightfully, sir, mediated by you, and we are grateful to you for further setting the tone and tenor of this conference.
Thank you. Thank you
so much, sir. I would request my colleague, Mr. Chanchal, to say a few words.
Thank you very much, sir. In fact, this inaugural session has set the tone for coming technical sessions, and from this debate of our distinguished speakers, participants must be aware by the time how vast and how potential this concept is, which is not confined, in fact, to criminal law and criminal justice systems. As Honorable Justice Pradesh mentioned, that harm is not to be conceived in the individual and bodily sense, but in the sense of social fabric and as well as historical losses and wrongs. So it goes beyond. Even Indian Constitution has these glimpses in Part 3 and Part 4, where historical injustices are recognized and tried to be. Though there is no formal mechanism such as Truth Reconciliation Commission and concept of Bandhu formally mentioned in the text of the Constitution. Thank you very much for the distinguished guests. Now, Honorable Shimla, Professor S.S. Jaswal, to offer a formal vote of thanks for the inaugural session. Over to you, Mr. Sir.
Thank you, Chanchalji. Honorable Mr. Justice Mohan Paris, former Chief Justice, Supreme Court of Sri Lanka, Professor Nishta Jaswal, Honorable Vice Chancellor, National University, Shimla, Shri Sanjay Kunduji, Director General of Police, Himachal Pradesh, Dr. Upneet Lalli, Deputy Director, Institute of Correctional Administration, Chandigarh, Dr. Brian Steels, Director, Asian Pacific Forum of Restorative Justice, all the participants connected with us virtually for this international conference, being organized by Himachal Pradesh National University in collaborations with Institute of Correctional Administration, Chandigarh. We are highly obliged and thankful to Honorable Justice P. Mohan Paris, former Chief Justice Supreme Court of Sri Lanka, for gracing the inaugural session of the International Conference as a chief guest. Sir, we take this opportunity to thank you for accepting our invitation as a chief guest of this international conference. It's always an honor and privilege to have you in our program. Sir, we are looking forward for your blessing for our university in future also. Thank you for today's program, sir. We are thankful to Dr. Brian Steele, Director, Asian Pacific Forum of Restorative Justice, who is the keynote speaker of this international conference in the inaugural session. Dr. Brian Steele, your presence means a lot for this newly established National University, HP University, Shimla. Thank you, Dr. Brian Steele, for your presence today. We are also thankful to Sri Sanjay Kuddu, Director General of Police, Himachal Pradesh, who is the guest of honor for today's program. Thank you, sir, for sparing your valuable time and expressing your experience and knowledge in the field of restorative justice. Thank you, sir. Dr. Upneet Lalli, Deputy Director, Institute of Correctional Administration, Chandigarh, is having a very long and strong association with National University, Shimla. For today's international conference, Dr. Lalli is collaborating through Institute of Correctional Administration, Chandigarh, as partner. Thank you, ma'am, for collaborating with our university and for all what you have done for this international conference. We are thankful to Honorable Vice Chancellor, Professor Nesta Jaswal, for organizing second international conference. Organizing such a program in the university will go a long way for the overall development and progress of the university. Thank you, ma'am, for taking lead in organizing this international conference. Our thanks are due to all the participants, conference coordinator, Shri Chanchal Kumar Singh, co-coordinator, Dr. Amit Chaturvedi, all the teaching and non-teaching staff of the university, our technical support,
put the cameras on first.
We are all participants. Please put your camera or video camera.
And please test your mics.
Good afternoon, ma'am.
Good afternoon. Good afternoon. उम्मीद है आप मुझे सुन पा रहे हो.
Yes, ma'am.
Okay. 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 In between a window props up saying that enter your password. Aha. No, it's not. Okay.
Can you stop, ma'am?
Yeah. अभी ठीक है सब.
Dear participants.
Put your cameras on, paper presenters, authors, participants.
We would be starting at 1:30, I believe.
Yes, ma'am, we are participating 1:30. Good afternoon, ma'am. This is Jaswal from Shimla.
नमस्कार. नमस्कार.
बहुत अच्छा लगा आपको, बहुत धन्यवाद देख के मैम.
मैंने भी सुबह में देखा, बहुत अच्छा लगा.
Thank you, ma'am. Thank you.
Hope you are staying safe and taking care. मौसम ठंडा हो गया है.
Himachal, no problem, ma'am. Shimla is always evergreen.
Okay. Evergreen in the right sense.
सिचुएशन एक बार नॉर्मल हो जाए तो आपको शिमला बुलाएंगे मैम एकेडमी प्रोग्राम में।
जरूर जरूर जरूर, my pleasure and my privilege.
थैंक यू मैम, थैंक यू।
Okay. Mutations and combinations because of which a person gets into and is driven to criminality, what we need to understand is that retribution is not the only way out. So where we are talking about an individual, a 16 or a 15-year-old girl, wherein the person is stealing a loaf of bread. In the current contemporary pandemic scenario wherein people do not have enough to survive on, it's a question of life and death. If he happens to steal a loaf of bread, we label him as a criminal, whether that is the right approach. Poor fellow has not stolen money and jewels, etc., etc. It's only a question of survival. So it is the existential crisis which drives a person in given scenario, in this particular illustration, to a crime. So keeping in mind such other illustrations wherein we understand that people are tempted to commit crime, we have to accordingly, and we have come up with an alternative thought process which talks about restorative justice. When we are talking about restorative justice, let me check with my colleague, Sonia. Are you not able to share?
Ma'am, I'm so sorry. I'm not able to share the PPT. I've asked them to allow me to share the PPT. I've written in the chat box.
Okay. If we would request the organizers if that's feasible and possible.
If
and Dr. Amit, please look into, or if Arun is there, ask him to make necessary changes so that Madam Sonia can share the PPT.
Yeah, the shared option is actually not available on my screen. I think we are not allowed as such. So,
okay.
Will it be okay that if we send it across to you and then you can share from your side?
It'll take time.
If that is possible, then okay. If that is possible, then I'll ask Sonia to send it across in the mail. In the meanwhile, I'll go just like that. Now, when we talk about restorative justice, it is basically restoring the relational harm that has been caused on account of the crime. Now, generally, whenever we are talking about restorative justice, it is not a static concept. As Dr. Upneet Lalli was mentioning in the inaugural session, the plasticity of this subject, I would still modify that phrase. I would believe in elasticity instead of plasticity. The moment you are saying plasticity, there is a possibility of breaking and breakage. But when we are talking about elasticity, then my understanding is that you can still maneuver, modify, experiment. So to my understanding, restorative justice as a concept has got that abundance of elasticity wherein different methods and tools can be employed and roped in to undo the harm. Now, generally, whenever we are talking about a crime, the idea is that here is a wrong done, what else, what next? My argument would be that should we not go into the causes of crime and to understand and appreciate as to why this individual was driven to criminality. If we are able to appreciate the nuances as to why a person was driven to criminality, perhaps our approach would be different. I would hurriedly add here that at no point of time I am suggesting that we need to be careful and conscious about the rights of the accused suspect only. We need to appreciate that the victim is the wronged individual. She has suffered a lot. The society is the indirect victim. The current Indian criminal justice system, or for that matter, global criminal justice system, focuses too much on the rights of the accused suspect. I would wish to see an equality of treatment with reference to the victims of crime also, so that it's not only the rights of the accused which are being highlighted through our criminal justice system textually, but also the rights of the victims are highlighted. And it is here that we need to appreciate that restorative justice talks about equality, respect for the dignity of an individual, whether he is an individual. Here it is. Thank you very much for that. The second slide, Sonia. Now, when we are talking about dignity of an individual, these are the four components of the criminal justice, restorative justice strategies, so that we are talking about respect, accountability, healing, and empathy. And each of the four components are equally relevant, not only with reference to the accused suspect, but also with reference to the victim of crime. And it's not only the victim of crime, I'm afraid, even with reference to the abuse of power. And that is what in the morning session, the DGP, Mr. Sanjay Kundu, and the justice from Sri Lanka, Justice Perez, was also talking about, that there are people who are exploited on account of state agencies' actions. So each one of them who has suffered, who has been wronged, not necessarily deliberately, but inadvertently, whether they should be heard. Who is going to hear the voices of these unheard lot who have been wrong? Now, it is in this context that we need to understand that restorative justice talks about the accountability. It's not only that you have done the wrong and here is the punishment. That's how we are the sovereign master and we are determining authoritatively for you. It talks about respect, accountability, healing, and empathy. Next slide, Sonia. And with that, what we need to understand that restorative justice gives opportunities. In retributive justice, we do not give any opportunity whatsoever to the wrongdoer to indulge into amends, to be apologetic, to get reintegrated in the system, because it is all through a process wherein we stigmatize people, we alienate people, though they have done a wrong, but we do understand and we must appreciate that every sinner has a future and every saint had a past. So on that basis, we need to understand that there can be possibly momentary lapses with reference to the conduct of an individual wherein he happens to wrong some individual, so that there should be a possibility of making amends, apologizing, somewhere gaining acceptance by coming forward, the accused coming forward, the convicted individual coming forward to help out the entire system so that justice is delivered. So generally, whenever we are talking about criminal justice administration, we have got that aloofness in our attitude. We think on the lines of objectivity and neutrality, but I'm afraid this objectivity and neutrality with a dispassionate attitude removes us from the ground reality, that by administering such a criminal justice system wherein people are being alienated, wherein they are being stigmatized, wherein they are being told that you are the outsiders, and having undergone the punishment, when they come back, they are still looked down upon with disapproval. Each one of us wants to be aloof from those individuals. We just do not want to interact with those individuals. So where would that socializing happen? Where would that reintegration happen? That suffers a lot in this entire criminal justice system, which is based on the policy of penalizing and retribution. And it is here that I would like to take you across, Sonia, that social discipline window slide, wherein contrasting the retributive justice system with the restorative justice system, that whenever we are talking about justice delivery, there are two components. Sonia, are you hearing me? Please take us over to the social discipline window slide. Historically, we know indigenous people have always been talking about restorative justice. Thanks, Sonia. Here is an essential distinguishing aspect of restorative justice, and in contrast with the retributive justice. I'll just pick up this and would ask Sonia to talk about the challenges. Whenever we are talking about this social disciplining, crime identification is a view to discipline people into a particular behavior wherein a collective coexistence of groups of individuals can exist. Now, with that focus in mind, we understand that whenever we are identifying a crime with punishment in mind, these are two components. One is the control mechanism, another is the support mechanism. Why do we punish people and what is the purpose? Now, this particular slide informs us that whenever we are having a retributive approach, that retributive approach is always authoritative and is stigmatizing, wherein there is maximum control of the state agencies and there is the minimal support from the state agencies. In contrast, when we are talking about restorative justice, here it is, we understand it talks about the attitude of with. What I would wish you people to focus on is the first word in the particular square. Punitive is always to, that I am against you, so I am addressing to you. So there is that dictatorial attitude coming in. But when we are talking about restoration, it is I am working along with you. And because I am working along with you, we are going together to bring about a circumstance wherein you and me would be at par ultimately after having gone through certain stages of the restoration, wherein you would come forward, accept your guilt, you would undergo the punishment also. At no point of time it is being suggested that punishment would not be a component in restorative justice. Punishment would also be there, but at the same time, we need to ensure that having undergone the punishment, what is being done with reference to the victim? Whether the victim remains a forgotten lot, or there is something being done with reference to the victim also, so that it's not just a theoretical lip service that we on behalf of the victim as the state agent are taking care of the wrongdoer, penalizing him, incarcerating him, sending him behind bars, and that's it, we are fine enough. No, we need to do something with reference to the victim of crime, directly as well as the indirect victim, the society at large. And it is here that we need to appreciate that fifth slide, Sonia, that we have various strategies across the globe, which are talking about fifth slide, which talks about various strategies being applied, and restorative justice, just in a singular word, if we might understand, it is the skill of negotiation, mediation, wherein we bring all the parties at par with each other. Here it is, that these are the kinds of strategies, these are the practices which are roped in different setups, so that we can think of possibly a balancing of interest of not only the accused convict, but also the victim and the society at large. So all the stakeholders in a given group who have been displaced from their original status, their interrelation, their interpersonal behavior has run into each other, so that they are undergoing difficult times. That is where Mr. Kundu was saying in the morning, that in cases of violent crimes, it is not feasible to let the accused and the victim encounter each other. Appreciating that, what we need to understand is that we need to take baby steps. And with that basic conceptual understanding that there is no single definition, but it is basically, I'll again put the emphasis on undoing the relational harm. We need to bring in those strategies wherein we should move forward on the lines of not only compensation, which has been incorporated in CRPC as an effective mechanism, but we also need to have counselors. Various other segments of administrative agencies have to be made available in order to make restorative justice practices fruitful. From here onwards, we have put up a slide with reference to the distinction between retributive and restorative justice also. I would request the organizers to share it across with the audience so that they can go through, and if they happen to have any questions, we are open to that. From here onwards, with reference to challenges, I would request Sonia to please go ahead.
Thank you so much, ma'am. Am I audible?
Yeah.
All right. So I'll just quickly talk about the challenges related to, dealing with the concept of restorative justice. So the idea was to just have a reality check on restorative justice rhetoric versus reality. So we know that, and we have learned from the morning session as well, that there is no consensus as far as the first challenge as, in implementing the restorative justice as a justice delivery mechanism is concerned, that we don't have a consensus on the definition. So some scholars believe it as a value-loaded concept, where others talk about as a means of practice to approach that justice delivery mechanism. Now, second, quickly, I'll talk about that we know that in restorative justice, what we require is collaboration among the participants and professionals. Now, the question to be asked is that, are we aware about this requirement that we need the collaboration at every level, at every stage when we are talking about narratives and encounter? And if we are aware about these requirements, so are we even aware about this, that what is the adequate level that is required to which these people need to be engaged in order to restore back all the stakeholders in the society? And also, are their roles defined? So do we have a consensus on that as a system, where we talk about that all the participants and professionals should come in together and talk about, we know that this is an engagement where we are asking the lay people to come in together and talk about restoring themselves. So what is the level of the awareness as far as the collaboration is concerned, and what is the system that is put in place as far as the collaboration and the definition of the role of these participants are concerned? Then we also know further, looking at the another challenge, that restorative justice talks about the narratives and the management of emotions. So there is a narrative from the side of the person who is harmed and the person who is made accountable. When we encounter these emotions, when we encounter these narratives, as we saw in the morning session as well, so we know that there are a lot of emotions that we have to encounter. It's again pushing back something, like you're pushing the person same to you to feel that same pain, the same agony, and also to the same fear that the victim would have gone through. Now, again, it brings to the light that it requires a participation from the professionals. It requires a participation from the facilitators. Managing emotions is not a simple thing. Are we ready for that? Are we prepared for that? Do we have adequate number of people to manage those counseling sessions, those adequate number of psychologists, doctors, all right? Or have we oriented the family, or have we raised the awareness level of the family to that level where we can teach them that how to manage these emotions of anger, disgust, fear, shame, etc. and etc. And we can just go on and on that. So what is the mechanism available to manage these emotions? Because the flooding of emotions sometimes can backfire, and it can again, cripple down the entire and collapse the entire system. Then what I feel, and what my discussion with my mentor, I can zero down upon a point that another challenge which I feel in this concept of restorative justice is that restorative justice work on certain theories. One of the theories is shaming theories. Shaming. So I feel particularly that, like, although it talks about reintegrative shaming, but then I have a doubt as an inquisitive student of law, and I just want to put up a question over here to the experts, that don't we feel that this is a misnomer that is used in the positive approach of a restorative justice mechanism? Shaming any which way leads to self-esteem. If we go about all the psychoanalysis, if we go about all the psychological therapeutic techniques, we do know that shaming can affect only people who are concerned about that how their behavior is being considered by others. But is it going to work in a similar fashion for each and every person? Or is it again going to lower down the self-esteem of the person, let the person get prejudiced and stigmatized in the society? And rather than reintegrating the person in the society, are we not disintegrating the person? Now, that is a question that is need to be asked. I don't know whether the terminology need to be changed or the theory need to be changed, or we need to look at in a different perspective altogether. Now, coming to the next challenge, quickly, I'll just go over it. Like, I feel that restorative justice and, to flourish needs a particular fertile ground. Now, that ground, that social and political fabric, which I which I can think of, is
humble request from the organizer, please maintain the time limit because we are having so many presenters of the paper.
Yes,
My
sir.
humble
I'll
request.
quickly.
Humble
Yes,
request.
I'll quickly
Please
go
maintain
about it.
Thank you
Okay.
very much. Thank you, please.
Thank you. So as I thank you so much, sir. As I completely understand the paucity of the time.
Yeah.
So
Thank you.
as far as the other challenges are concerned, so as we learned in the morning, so just 2-3 lines. At the end, I would like to conclude that the state needs to shun away with this paternalistic attitude as far as dealing with restorative justice concept. It all has to be flourished is concerned. We need a lot of investment, not only financial, social, and psychological from all the stakeholders that has to be taken in mind, right? And we need to develop a conducive environment as far as socialization practices, indoctrination, and everything else is concerned to start from the very beginning. Then only this concept can flourish in the society. It is an ideal concept, but are we an ideal society? That has to be taken in mind. So thank you so much. With that, I would like to conclude. Thank you so much for the patient listening.
Thank you. Thank you
all
very
of you.
much. Yeah, Shuklaji, please take.
Thank you, Sonia. Thank you, Dr. Anju. May I now invite Dr. Ved? Because of some assignment, he has requested me. Dr. Ved, are you there? Can you start your presentation?
Yes, sir. Yes. Thank you, Dr. Shukla. Good afternoon, one and all. I am Dr. Ved Prakash Sharma, Assistant Professor of Political Science, Himachal Pradesh National Law University, Shimla, presenting my paper on Restorative Justice in India, a Gandhian Perspective. It is widely organized that punishment of the offender is not justice to the victim. There is a demand in human rights activist circle to follow the punitive approaches for making justice meaningful. The recommended restorative justice, which is deeply associated with the Gandhian philosophy, value of ahimsa and satyagraha, for seeking the truth because only truth endures at last. This paper attempts to see concept of restorative justice from Gandhian perspective and try to see the implication in Indian judicial system. In India, the criminal justice system is largely focused on the offender. It views crime as wrong against the state and civil society, where offense are viewed as violation of rules made by the state. The system holds the offender accountable by punishing him against his crime. If we see consequences of punishment, crime have a physical or psychological impact on not only the victim, but also their friend, circle connected with them, and overall community. Under restorative justice, crimes are perceived as wrong against the victim as well as the community. The focus is on the private dimension of a public wrong by limiting the role of state and that of a facilitator. The offender is made to accept responsibility for the wrong done by him and it required to make aims by preparing the harm resulting from his deeds. The one affected by the crime, that is the victim, plays a key role and has a significant say in restitution. Gandhi, wisdom over a country, over a century, demonstrated to us by the words and the life of Gandhi shows us the path to active engaging the restorative practices at an individual and collective level. Gandhi shared with us his vision of what prison should resemble in India. Gandhi wanted all criminals be treated as patients, and the jail should be hospitals admitting this class of patients for treatment and cure. He said that no one commits crime out of the fun. It is a sign of a sin of a disturbed and dissent mind. Few principles of Gandhi, like Ahimsa, Swaraj, and Satyagraha, are the basis of Gandhian philosophy of justice. Ahimsa, Gandhi translated as non-violence, should not be a negative concept, rather it refers to positive action grounded as a worldview of respect for one another, a vision of how we live together. Similarly, restorative justice is based on respect. Restorative justice, representative, positive action of creating for one another, for our needs and our relationship. It reflects a vision of how we live together, steeped in values such as respect, responsibility, and relationship. Gandhiji's famous concept of Swaraj reflects to self-rule. The Gandhian movement emphasized self-governance, both personally and socially. Looking from the prism, restorative justice argued that individuals and communities have the potential and the resources to govern themselves. In its practices, it encourages both individual and communities to call upon their best lives. Restorative justice, in this sense, is helping individual and communities develop their capacity for self-governance. Coming to Satyagraha, is often translated as non-violence resistance. It is basically truth force on action through truth. Like Ahimsa, it is a positive, not negative. Restorative justice to represent encouragement towards truth-telling and truth-seeking. Gandhi defined his vision of humanity with these popular concept and in the heart of India's most marginalized people. It became instrumental in the Indian independence movement and also become helpful in during a lifelong life against modern form of enslavement and caste oppression, religious hatred, gender oppression, and other form of violence and poverty. Gandhi put more emphasis on one's consciousness than it is court of justice. He says there is a higher court than the court of justice, and that is the court of consciousness. Thus, it is clear that Gandhi's justice was not limited to the favorable decrees of the court. It means the achievement of higher goals. He wanted to achieve the goals which had been led time and again by prophets and not formed the goal of human consciousness and various religions. And he also put down as much emphasis on ends as well as means.
Wait, sorry to interrupt. Mr. Amir Ali, please mute your mic. It is creating disturbance.
He also
one participant is here, Mr. Amir Ali. Please mute your mic. Yeah, wait, sir, please conclude.
Okay, thank you. Therefore, Gandhi wanted to create a society based on humanity. He wanted to correct the injustice by peaceful means and to change the heart of criminals by restorative justice. In the true sense, That could be the idea of modern India and a just India. Thank you.
Dr. Ved, whatever comment is there, I think I can pass it on to you. Thank you very much for presentation. May I now invite Ms. Sabina Anjum? Ms. Sabina Anjum, are you there? Dr. Amit, I can see the list accordingly. Ms. Sabina Anjum is there, the next presenter.
Yeah, she doesn't seem to be present at the moment. We may move.
So we can go ahead with Ms. Monica Punia. Ms. Monica Punia.
Yes, good afternoon, everyone. I'm here. Am I audible?
Yes, you are perfectly audible. What I suggest you, Monica, that you first tell us what is the structure of your paper, what exactly problem or the theory which you have searched on, and then how it actually going to help us in restorative, establishing restorative justice system. So be precise on these three issues. Am I clear?
Sure, ma'am.
Yeah. Sure.
Yes, definitely. I'll try to concise the paper within the time limit which is given to me. I'll not be taking more than I guess I do not have more than 5 to 7 minutes, so I'll try to conclude my paper within that time. Thank you. So thank you for giving me this opportunity, and my paper is on evaluation of pursuit of justice through reformative theory, which is a step towards achieving restorative justice. So we human being, we are a need to live in a society. We need a society which can protect our rights, and we need a government which is actually going to protect our rights, which is going to protect our lives. So in that regard, if we say some law of the land are being created by the government, and if there is just a second, if there is any rule breaker we find in the society who is going against the norms which are created by the higher authorities, then in all the criminal justice systems, we have seen that those people, they are punished in one or the other way. Imposition of sanction is present in almost all the criminal justice systems. So as imposition of a sanction is concerned, the problem does not lie with the imposition of sanction, but it lies with the legal process which is involved in it. So my main motto will be to discuss the objectives of punishment, that why punishments are given in the present criminal justice systems, and whether the objectives, the reasons behind giving the punishment, they are attained by the criminal justice systems in the present era or not. So as far as the first basic objectives for giving punishment to an offender, that if we have to answer the question that why we should punish the offenders, the first reason which comes up in our mind is that it will reduce the crime rate. And secondly, that offenders who will be punished, they will not be committing the same sort of offense again in the future. And punishment also tells the victim and the society at large that we are not accepting such forms of crime, and we are going to punish the offenders. And such punishments, they will also bring a deterrent effect in the society. Deterrent effect as in that the people with the same intent, if they are thinking that they will commit, or even if the paucity or even if the circumstances arises such that they think that they will commit such sort of crime in the future, then also they won't be committing that crime, thinking that they will also be punished in the same manner as the offender has been punished by the state. But one by one, I am going to define these objectives that we can see in the present era, that such objectives are not achieved by the punishment given by the authorities in our country. As far as the deterrent effect and the crime reduction in crime rate is concerned, we can see that in the month of March in the same year 2020, accused of Nirbhaya gang rape case, they were hanged till death. But still we see that every week in fact, just in a state, if we talk about UP, every week we can see that some incidences are reported of rapes, gang rapes, and sometimes the victims, they are even minors. We are also aware of the situation that many crimes of same sort are not even reported in our country. The National Crime Record Bureau, they do not have the actual number of crimes which are happening in the country. They just report us the number of crimes which are reported. So we cannot say that the we consider punishment as the most important aspect of the criminal justice system, but we consider it as a pillar of becoming an ideal state. That state will achieve the status of an ideal state only when there will be a fear in mind of people. But the objective behind the punishment, it is we do not see that in present era it is fulfilling. So that is why we can also see that there is a change in modern systems. Nowadays countries, they are actually following the principle and they are going towards a more humane approach, and that is why they are trying to follow. I guess there are 100+ countries which have ratified the protocols related to abolition of death penalty. There are protocols which are attached to ICCPR, ICESCR, the major covenants of human rights, and these protocols, on the face of it, they talk about abolition of death penalty, and various countries are coming up and they are signing such protocols and ratifying such protocols. So with this, we can see that we are moving from the traditional aspect of giving punishment to the offenders, but now our focus is on reforming and bringing the behavioral changes in the offenders, so that it will bring the long-term effect in the society. We are going to change the psychological we are going to bring the psychological changes in the offenders. So that is why that is going to make the offender not to commit such crimes again in the society. And as far as the punishment is concerned, it is a sort of an method through which we remove the offender from the society. Removal of offender from the society, it is actually not fulfilling the purpose, because an example was given. I've also cited that example in my paper. Suppose if we take a scenario where a drug dealer used to distribute drugs in a local area and he is imprisonment. He has been caught by the police and he is imprisoned. He has been removed from the society because he was creating a he was committing an offense of selling drugs. But because of that, there is an unmet demand of drug in that particular local area. And because of that void which is created by imprisonment of that drug dealer, new drug dealers will come in that area and they will be supplying the drugs to the consumers. So this is how we cannot say that it is bringing a deterrent effect. In fact, the person who is going to find an opportunity, and in today's scenario, we can see that it is not just the offenders who are committing these crimes, but somewhere as a society, we are also responsible for creating such circumstances which makes those offenders these crimes. So as a society, we should all come together and we should try to accept and try to make the offenders again to become a part of mainstream society. We should actually, with empathy. So that is why, as the restorative justice principle, as far as it is concerned, it is becoming more popular in modern justice systems, as it helps the offender to get back in the mainstream society, that too with the acceptance by the victim and his family. In this way, a sense of empathy could be built up in society, which could help people connect in a better manner. Though restorative justice also, it has its own limitation, and we could not just deny the existing criminal justice system. We cannot just deny the punishment aspect from the criminal justice system which is existing nowadays. But for some time, I guess we have to, these two theories, they have to go hand in hand. And that is why if an offender has to spend some time in prison, that time should be used in a positive manner. That time should be used in reforming the inmates, reforming the offenders, so that their psychology changes, there comes behavioral changes in them, and they could actually pass on such behavioral changes to other peoples in the society whenever their sentence is completed. So this is that was conclusion of my paper. Due to the paucity of time, I was not able to take it any longer.
Thank you, Monica. A quick comment on that before I can supply a little bit detail of that. I think you should more work on restorative aspect, because there is some confusion I see here with respect to restorative and reformatory jurisprudence of criminal justice system. So I'll put across all these things. Thank you very much for presenting this paper.
Thank you.
The next paper is of Mr. Rishi Sehgal. Mr. Rishi Sehgal, can you start your presentation? Thank you.
Yes, for sure. Thank you. Good afternoon to the honorable co-chairs as well as all the participants. I am Rishi Sehgal, a fourth-year law student from Pune University, and the author for the research paper titled In-Depth Analysis of the Restorative Justice System from the Stance of Indian Criminology and Indian Criminal Psychology. Keeping the limited time allotted in light, I hereby present a brief about my research paper. Analysis of Indian justice mechanism and the suitability of the restorative justice system in India from justice tiers perspective has been made by my paper. It is necessary that both the justice system of India, the judicial tier of government, and the citizens of the nation, that is the Indian society, think alike and agree on the same points. Situation of conflict of interest and contradictions have always been found in the country among the judicial minds and the social minds. For instance, in the year 2018, by the virtue of the landmark judgment in the case namely Navtej Singh Johar versus Union of India, the apex body of the judicial tier of the nation legalized relationships of people belonging to the homosexual community, the LGBTQ community. But did the society accepted the said decision at that particular time is what can be said to be a classical example of contradictions between the beliefs of the society of the nation and judicial tier of the nation. Whether the society will welcome the same decision of adopting the restorative justice system with the same mindset is something that is not something someone can be sure about, right? Hence, what the common citizens of the democratic and republic nations feel about the restorative justice system is another point of emphasis. Ahead in the research paper, the effect of acceptance of restorative justice system in India by the society at large has been emphasized. If the history of the nation is viewed, the Indian people have witnessed a rich history, mainly consisting of four recurring factors, precisely salient, personally to the same country, oppression, struggle for independence, and history of series of battles and territorial partitions. It is necessary to form a crux of the above described outcomes on the homogeneous thought process of the current citizens of India. India has been into hot-blooded battles and has witnessed one simple rule: being welcoming and hospitable to each and everyone doesn't yield a fruitful result on a large scale. Trial purposes, out of which observations can be taken and conclusions can be made after a specific period of time in order to answer the question that whether the restorative justice system is suitable for the people of India or not. It is certain that restorative justice system great cause and can preferably decrease the amount of struggle that is faced by both the sides of crime, namely the criminal and the victim. Ahead of the research paper, a comparative analysis with mediation and conciliation has been made. If the restorative justice system is suggested to be a mere synonym to the practice of mediation, it shall be understood that a crucial element of the restorative justice system is not present in the case of mediation, that is criminal or offender. Following the fate that an accused is not said to be a criminal until and unless the allegations leveled against him are proved. In other words, in India, a person is said to be innocent until proven guilty, right? Therefore, in order to come under the definition of restorative justice system, a case has to be necessarily disposed of, which is in exact contrast to the practice of mediation, because mediation can also be said to take place in ongoing case to reach a conclusion. Therefore, it shall be understood that if mediation is successfully being practiced in India, it isn't necessary that restorative justice system will do as well under the same blanket of mediation. A separate An independent system of restorative justice system is thus desired in order for it to function at its best. Another issue comes in the picture due to the restorative justice system in India is while dealing with the habitual offenders. The same has been discussed ahead. In my research paper, and while forming a conclusion by all the analysis has been made in my research paper, the restorative justice system has witnessed to be a great successes in other parts of the world and hasn't been adopted yet by the Indian justice mechanism. Those similar practices have been involved in the proceedings of the case, and are often confused to be congruent to the restorative justice system, but are different in their own fields. Restorative justice system is said to be the practice of making both the parallel edges of crime, that is offenders and the victims, come present and try to understand the psychology of other side in order to get psychologically relieved from the mental outcomes of a crime. The need for the same is felt in the Indian territory as the impact of crimes is life-changing. In a negative context though, adopting this method come practice may prove to fill the missing part of the journey to reform and nail the traits of the offender inside the person. On the other hand, the reformative justice system can be proved to be equally effective for the victims as well. By conversing with the criminals, victims might feel psychologically relieved and can broadly be termed as a possible treatment to the traumatic disorders thus developed by the victims after being victimized in a crime. Undoubtedly, the restorative justice system is an effective reform that is felt in India according to the current situation. One concern that originates in regard to the adoption of restorative justice system in the response of the citizens is thus need to be paid emphasis on. A crux out of the analysis can be believed to be thus formed that as far as the requirement of the reformative justice system is concerned in India, the practice can prove to be effective and working to change the whole Indian criminology. But the resolution of the adoption of restorative justice system will acquire the sincerest of minds in order to mold the system according to the requirement of the Indian legal framework. This was all about my research paper.
Thank you, Rishi. Thank you so much.
You're welcome.
As of now, I can only say that if you can develop this paper into more of empirical in nature and can find out certain facts, certain evidence to argue, especially I am really impressed by your argument that confrontation of accused and victim at certain later stage, at the stage of resolution can work better. So if we can find out some evidence either in India or abroad, that would be really wonderful for your paper. So
Yes,
with this comment, thank you very much for making this presentation. May I now invite the next one, Dr. Kishrod Moharana. Dr. Kishrod Moharana, if you're there.
Sir, good afternoon, all of you. I am sir, audible, sir?
Your camera is not on, it is off. Put the camera on. Dr. Moharana, can you put your camera on?
Is it visible?
Not yet. Not yet. Yeah, it is visible now. Go ahead.
Go ahead.
Good afternoon, all of you. Relevance of restorative justice in Indian context. Hello, sir. Is it audible, sir?
Yes, sir, it is audible. You are perfectly audible. Go ahead. I suggest Mr. Somkant Khare to mute the mic.
Sir, this is my paper. I focused on relevance of restorative justice in Indian context. Yes, I am Kishrod Moharana from Odisha. Actually, the relevance of restorative harm caused by criminal behavior. It is not traditional. it is not introduced in any penal provision. Actually, we know that there are 5 justice system which is provided in the Indian Penal Code for punishing the offender. But restorative justice leads to transformation of people, relationship, and communities, where justice process is inclusive than the traditional criminal justice process. Though the criminal justice system cannot be as inclusive as restorative justice process, but there are at least 4 ways that the victim could become more involved in the process, such as information, presence in court, victim impact statement, and legal standing. The relevance of criminal investigation, plea bargaining, sentencing, and post-sentencing. The restorative justice places a high value on having the victim and offender encounter. Relevance of encounter might be done directly in meeting between two or done indirectly through exchange of letters, videos, and by message delivered by the third party. Here, meeting, narrative, emotion, understanding, and agreement are most 5 relevant elements in the restorative encounter. Restorative justice helps to repair the harm done by the because it is required for the restorative justice to the apology through apology, change in behavior, restitution, and a generosity. The restorative justice system places high value on the reintegration of the victim and of the offender that to have attributing members of their communities. Before we go ahead, I have to say the Bentham's word regarding the punishment. According to Bentham, punishment is a of desire and of the inclination of sufficient pain. According to him, the offender's temptation, not his oral culpability or the gravity of the harm determined by the nature and extent of punishment. There is no substantive difference between punishment. Sanctions are punitive. In some punishment is a coercive deprivation intimately applied to commission of harm forbidden by penal law and implying his moral culpability. That's why restorative justice is necessary to our country, our society, for a crimeless society, because it is the remedial reformation for the offender as well as the victims. Actually, the 4 relevance of the restorative justice in India are inclusion, encounter, amends, and reintegration. The relevance of encounter is by the meeting between two, or it can be done indirectly through exchange of letter and videos already. The restorative justice processes are more inclusive than the traditional criminal justice process. They actively invite all affected parties, victims, offenders, and community members to participate in resolving the crime. Inclusion seeks the full participation accomplished by all interested parties to participate, expecting the parties to pursue their own interest and enough to accept new approaches to relevant. And after our relevance is related to encounter, that restorative justice places a high value on having the victim and offenders encounter one another. This encounter might in a meeting between two with a indirectly through exchange of letters and videos also. It is the most effective way for the restorative justice to the victim as well as offender. Then amendment, restorative justice seeks to repair whenever possible. This repair should be done by the persons responsible for harm. By restorative justice, value efforts by offenders to make amends, apology, changed behavior, restitution, and generosity. Each has potential for helping the victim to heal, to become a productive part of the community. Next, reformative justice, that is reintegration. Crime causes injuries. It also can result in both the victim and the offender experiencing stigmatization. Therefore, restorative justice places a high value on the reintegration of the victim and of the offender. The goal is to have them become whole contributing members of their communities. Victims often feel stigmatized, friends, and the community. Sometimes this is because of the loneliness experienced during victims are uncomfortable, they must to those around them and to anyone. So reintegration is most necessary for restorative justice. Sir, in my conclusion, I will say one thing that victim compensation is not to resolve the dispute between and victims. So government should take initiative to make the specific law for retrospective justice to for coming a society. Thank you.
Thank you. Thank you so much. Thank you so much, Dr. Kishore. In fact, your comment on victim compensation is really something urgently to be heard and properly executed to really think about restorative justice system. Thank you very much for your presentation. May I now invite Miss Ayushi Soni. Miss Ayushi Soni, are you there? Miss Ayushi Soni, can you hear me? By the time she is coming, I think we should go to the next speaker. Miss Sarita?
Yes, sir.
Please go ahead.
Can you see me, sir? And I am audible too?
Ayushi, are you there? Ayushi has joined. Ayushi? Ayushi? No, we can't hear you. Check your mic. By the time you check your mic, I request Sarita ji to present her paper. I'll ask you later, little later, Ayushi. Okay?
Thank you so much, Rakesh, sir. Am I audible?
Yes, yes, perfectly.
Thank you. Thank you. First of all, I would like to congratulate the organizing team for organizing such a wonderful conference. And thank you, Grijesh sir, for giving me opportunity for presenting this paper. The title of my paper is Formalizing Justice for Dalits, a Restorative Approach. I'll present it on behalf of my
Unmute, your mic got muted. Unmute first, yeah.
Now it's okay?
Yes, it's okay.
Okay, sir. So,
and please,
restorative...
be precise as much as you can.
Yes, sir, I'll try my best.
Sure.
Restorative justice, as we all know, is not a new concept which has emerged during recent years. It was in existence in various ancient civilizations of the world, such as Babylonian and Sumerian civilization. So it was obliterated from the scene only when kingship began to rise and its head and took away the function of law and order from the community. Earlier, the system was delivering justice and resolving the matter was in the hands of community, which involved both offender and victim. But by the time after of this criminal justice system, which involved the state and the offender, that gradually changed. Now a time we can see that states takes over the role of maintaining the law and order in the society, and hence handles the impact factor on the community at large by punishing the offender. But in all these processes, victim is left alone. So victim who put the law in motion are usually forgotten people in the criminal justice delivery system. So his participation remains at the periphery of criminal justice as the initiator of the prosecution and as witness of the prosecution when desired. He is neither participant and in the proceeding launched against the offender nor a guiding element in any of the stage of the prosecution. So there has been a gross neglect of the victims who are in need and whose interests are prejudiced. So as my study is focusing on this Dalits and restorative justice, so I would like to highlight that Hindu society is stratified into 4 varnas, where status was the insignia of Brahmins, power was insignia of Kshatriyas, and wealth was insignia of Vaishyas. So Dalits were at the lowest and they were not marked with any insignia. They have to do the menial jobs. So just the process of the you can say depriving justice started that from that very point when we can see the stratification of the society. So the increasing atrocities against these SCs in the community, particularly I'm talking about India, that in our country there have been alarming you can say ratio which talks about the increasing atrocities against Dalits. And at the same time, accessing justice for SCs have become different at, you can say, every stage, be it from the lodging of complaint, registration of FIR, arrest of the accused, or at the time of investigation too, they have to face the harassment on one or the other level. So despite we having the SC/ST Prevention of Atrocities Act, we are having Civil Liberties Act, and many of the protections which have been provided under the Constitution, the ratios of these atrocities, which is very, very alarming. I'm having the latest data of this crime NCRB. The total ratio of crime committed against Dalit in 2018 were 42,748, and now in 2019, as reported in the NCRB report, that was 45,852. It is providing us the data that the crime rate against these persons, that's Dalits, that is increasing. These crimes include both the crimes you can say committed under this SC/ST Act and the Civil Liberties. I am posing some questions with regard to this restorative justice for Dalits. So now my first question to all of us, including me, that are we doing justice to these community? Are we doing justice? You have seen what has happened to this Hathras rape and murder case. So what media is doing, it is you can say adding upon fuel to the fire. The victim is already suffering, the family of the victim is already suffering, but media is again adding fuel to the fire. My next question is, are we really accepting the marginals, Dalits, as fully capable? So many of the time there might be chances, there might be occasions when as a normal human being, as a layman, or as a man or woman particularly, they might have done some mistake, but by the time we get to know about the community of that very person, we start stigmatizing that, oh my God, you belong to this community. So that is why this was a genuine remark of the general public. So why there is still be stigmatizing of these Dalits in the society? So we can corroborate these things that what happened in the time ago, that they have converted from this Hindu religion to in the mass Buddhism, then they converted to the Sikhism and some other religions too, Christianity too. But there the position of these people still remains the same. So as far as this restorative justice and its approach, I want to conclude with my thoughts that law is doing its work perfectly fine. Law is doing its work, but being a citizen of the society, being the part of the society, it is our pious obligation that we should change our mindset towards these persons and stop stigmatizing these persons. Because law is doing their work, law is doing its work, but as a vigilant citizen of India, we should also change our mindset so that the restoration which has been given, provided to these people in the shape of justice, that can be actually be realized by these persons by non-stigmatizing by ourselves. Thanks a lot. I hope I have tried to be concise as much as I can.
Thank you, Sarita ji. Thank you. As usual, you have been always very punctual to the time, especially
Thank you
about
so
the
much,
time. And the concern which you have raised about the community is really something very, very touching, and that need to be noted by everyone. Thank you, Sarita ji, for making this presentation. May I now invite Mr. Chanchal Singh and Mr. Mrityunjay Kumar. Mr. Mrityunjay, are you there?
Yes, sir. Hello.
Please go ahead. Mrityunjay, your camera is off. Can you just switch on?
Yes, sir.
Please
Thank
go
you,
ahead.
sir. Thank you so much.
Go ahead. I need not to remind about the time, Mrityunjay. If I can purchase 2-3 minutes from your account. Mrityunjay.
Hello.
Yes, Mrityunjay.
Suklaji, somehow my laptop stopped working, so I'll be using Amit's laptop. Till then, it might get corrected. Okay.
What I'm suggesting that Chanchal, every presenter has 10 minutes, and from your account.
This is very good. Being organizer, we are aware of it. Thank you. Mrityunjay, can you switch on your camera? Mrityunjay? Mrityunjay, can you switch on your camera? Hello?
Yes, yes. Should I go ahead?
Mrityunjay, just a second. I'll just explain the structure. Suklaji, our project two part is Mrityunjay, can you hear me?
Yes,
Mrityunjay, can you hear me? Okay.
Yes, sir. Yes.
Our presentation has two parts. One is theoretical, that will the classical theoretical conception, how the modern concept of restorative justice has developed from classical Roman and Greek period, and it has got popularized in the modern legal system. That part Mrityunjay will be covering, and then I'll speak later on the education system and policy, new education policy, and restorative justice. Mrityunjay, over to you.
Thank you, sir. Thank you, sir. So, to start with restorative justice, the concept of restorative justice. The terminology of justice is as ancient as the civilization started to live in ancient time. And language of justice is applicable and available in every civilization, in every society. If you look at Babylonian or Prussian or Greek or Roman or Hindu political system in ancient time in India, everywhere you will find that the language of justice is there. Now the question is, as far as the concept of restorative justice is concerned, which was for the first time this terminology was used in 19th century, whether it was a new concept or was there an idea of restorative justice in ancient system, ancient legal system as well? This is the first question I would like to investigate. On this question, I would like to present certain points that if we look at ancient village community in India, Henry Maine has written a beautiful book called
Chanchal, can you switch off microphone? It is echoing very much. Chanchal, can you switch off microphone?
All right. I've done it.
Okay, sir. So if we talk about ancient legal system in India, Sir Henry Maine has written a wonderful book called Village Community of East and West, in which in that book Henry Maine has tried to present a picture about the village community in India, and he tried to make an outline that the structure of justice delivery system in ancient village community in India was quite like restorative in nature, because the very fundamental aspect of that system was and settlement and balance between all the parties. Because if any violation of customs was taking place, it was the responsibility of the community to ensure that all the stakeholders are able to harmonize and their interest are able to harmonize. So, for example, panchayat system or the elderly councils in village community were quite active in settlement of dispute in village community. So it was quite similar to a restorative approach, which is not a new phenomena. In modern world, we use this phenomena started with 19th century, but before 19th century, we can find in indigenous communities across the world this particular aspects. For example, in New Zealand community, there is a term called Utu, UTU. This particular tradition of Utu in New Zealand Maori community is very much prevalent, and they believe that our common destiny is the same. So it is all about interdependence between one person and other person. So they believe the justice delivery system must be social in nature, and it must harmonize the conflicting interest between people as well as society. Not only Maori community in New Zealand, but also in African communities, there's a tradition called Ubuntu. And what is the meaning of Ubuntu? Ubuntu means that you are there for I am. It means that there is interdependence between one person and other. So how to treat others like me? How to sympathize and empathize with other person? That is the whole structure of the tradition which is found in indigenous community. So in 19th century onwards, this particular restorative justice, the concept of restorative justice emerged. So what was the significance? Why it emerged? Before 19th century, there was widespread tradition of retributive theory of justice. And retributive theory of justice could be found in Hammurabi Code, Babylonian Code, Sumerian Code. Everywhere you will find there is a conception of retributive theory of punishment. However, if you look at the writings of Immanuel Kant, for example, he was deeply concerned with intention, or you may say categorical approach of looking the punishment. According to Kant, even whole humanity is going to perish, but there is a single person who is the violator of law must be punished. Because Kant was not looking at the consequence of the act, Kant was looking at the very intention. Because he believed that every person is autonomous being responsible for his act. And if he does anything wrong which violates the autonomy of other people, then he must be punished in proportion of his transgression or his violation. But after the French Revolution, there was an argument between two different approaches of punishment. The one approach was categorical imperative or categorical approach led by Kant, and the another approach was utilitarian approach led by Jeremy Bentham, Cesare Beccaria, and the third one, William Paley. So these people started to treat crime not simply as individual phenomena, but a social phenomena which must have cause and effect. So if we look at the crime, it must have some cause and it must have some effect. So if we are going to trace and going to cure that cause, then effect will not take place. That is the whole idea of punishment. So utilitarian started to calculate that the purpose of punishment should not be deterrent or retributive, but it should be able to curb the crime. And what is the impact of that punishment over the society, over the victims, as well as over the accused. So that was the shifting the approach of punishment after the 19th century, when the utilitarians started to look at the whole philosophy of punishment. In fact, it started different disciplines of punishment, as well as discipline of victim called victimology, penology, criminology. You look at the word logy. It is significant because it is related to the word logos. Logos means reason, which is connected to Greece idea or Roman ideas. So when you talk about reason, so you started to calculate punishment under the calculus of reason, that whether this punishment is going to help to the society, what kind of impact this punishment is. So this is totally a shifting approach of utilitarians. Now, from there it started. Now, what is the significance of this terminology, restorative justice? Is it only limited to criminal justice system, or it has some wider meaning? After 19th century, there is a shifting horizon of the very terminology called restorative justice. And one important facet of restorative justice is equity and distributive justice. Equity is a very important term because when we talk about equity, it means leveling the inequality. Some people are unequal, so how to use equity in order to provide equal justice to all. So it started with Roman jurisprudence, then it became part of common law tradition, equity. And that's why equity is very significant for restorative justice. Why it is significant? Because after the romantic tradition in Europe, what happened that people started to believe that the society is an organic entity. It is just like a tree. If any part of body is not feeling well, then whole body is not going to work. So organic conception of society requires that all sections of society works efficiently. And that's why this particular requirement required that there should be principles of equity that should be applied so as to cure or heal the malaise of social problems. Because if there are some social problems in the society, how can an individual be happy? So that's why it was the requirement to apply the principles of equity so as to provide justice to every single unit of the society. This is one of the facets of restorative justice, because when we talk about curing, healing the disease, that is the whole idea of restoration, restitution. And that's why equity is a very important term. Not only equity, but it is also distributive justice. Because when we talk about distributive justice, there should be justice in distribution and distribution process. So after the independence in India, we had an opportunity to create constitution and to establish those equitable principles, and we did it. In the fundamental right chapters, we tried to establish that structure called egalitarian equality. So mind it is not formal equality, it is not proportional equality, it is egalitarian equality. Something quite akin to Rawlsian principles of distance, Rawlsian principles of difference principle. So egalitarian equality requires that there should be protective discrimination in favor of those people who have suffered from historical wrongs. And that's why we can look at Article 14, 15, 16, 17, even Article 25. So all the structure of these articles are something in consonance with that idea of equity. So how to fulfill that equity, that is the whole concern for the state. And education was considered as one of the important duty of the state, because it can't be the responsibility of any other person. It should be the responsibility of a state to use education as a medium and method to uplift the people, because education is not simply connected to the salvation or the idea of moksha or idea of enlightenment. It has connection with skill as well. And a skill is dependent upon employment. So employment and skill both are connected. And employments are very scarce commodity in every society. So in that sense, if you deprive some person from education, you deprive that person from very economic resources and employment. So that is going to make the poorer people more poorer, not only poorer, but also socially, educationally backward. So in that sense, how to reintegrate those people within the common mainstream, that was the whole philosophy behind egalitarian equality, the principle which was instilled in the fundamental right chapters. Now the question is, what happened after 1991 and how education was interpreted as a goods, like a trade and business. What approach Supreme Court adopted after 1991, after liberalization, And ultimately, what happened today? In today's context, almost 70% of the universities in India is private university. And since these are private universities, poorer people cannot afford those universities, those schools, those colleges, and they are supposed to be a part of public university system, public schooling system, but that is not working properly. And there are a lot of problems in public university system or schooling system in our country in current situation. And that's why we have created two different classes, just like segregation in America happened. It is happening here and now, because poorer people are not able to get education in that manner, which was supposed to be. And that's why there is segregation, and that segregation needs to be dismantled. So what is the approach of current legal education policy? Whether that approach is to fulfill the requirement of restorative justice, or the approach is simply to continue with that malaise or even aggravate that malaise. That is the whole question we need to inquire about current education policy. So I would like to pass over this particular discussion to Chanchal sir. Thank you so much.
Thank you, Mrityunjay. Are you able to hear me, everyone?
Yes, sir.
Perfectly. Go ahead.
I'll just try to make 2 points and take not more than 4 minutes. As Mrityunjay has elaborated, the idea of restorative justice in whatever form we have today, or we see it or study it today, can be traced back to Romans and Greeks. A clear indication of this theory or this kind of concept can be found even modern Western tradition or Western tradition, not different, in the Nicomachean Ethics of Aristotle. There are 2 statements he makes that whether the moral judgments can be universal and absolute. One, answer he gives that it can never be absolute and universal. It has to be partial, or it will always remain partial. So whether, for example, murder is wrong. This is, if we take this legal example, example from law, or practical law. So that makes the thing clear. Whether the killing is immoral. Whatever you have, you can generalize this answer. In the similar fashion, if the moral judgments cannot be absolute and universal, practical laws also cannot be absolute and universal. If looked from this point of view, for example, whether you say that A is a good person, A is a good person, or another example, A is a good doctor, for example. Both are 2 different examples. Whether A is a good doctor, now this may be a correct, might be he's an efficient surgeon or whatever kind of doctor physician. That does not necessarily imply that he is also a good man. Now, when we look at the education system, just keep in mind this example that A is a good person. These are 2 different perspectives. And the second question, statement is made from a point of view of moral judgment. Right? If you look at the present education system, we are not going to produce, and particularly new education policy, the draft policy of 2019, and the final policy that adopted in and known new education policy 2020. It does not concentrate or differentiate between these 2 statements. Though there is rhetorical remarks in the rules that has been or part of the draft that has been adopted and being implemented by central government and UGC. I just point out one example. The draft, if you look at the draft policy, it's more than 100 pages, 160 pages. It uses words such as A is a good dog, but A is a good man. This is a different question. Profession, competition, vocationalization, skill. More than 1,000 times these words are used. Nowhere its opposite counterpart, in the sense is a good man, is used in the whole of the draft. Now look at the way, for example, we are from a law school, so I'll take example from law or legal. The exercises we undertake are through rules we prescribe for students. Look at the moot court. When you say whatever restorative justice concept the theoretician and philosophers might come down to determine, and general emergence of general agreement about its component. But how do we go about in education policy? One of the problems that I have already highlighted, that Indian education policy, including, is based on one and simple idea: efficiency and exclusion. Efficiency and exclusion qualified by economic filter or capacity to pay. That is a different point, but the way which Mrityunjay have already made in our presentation, the way we impart education or legal training or education in law, learning in law or scholarship in law. Look at every student, according to Bar Council rules, is required to undergo some practical training, including moot courts. Now, idea of moot court is a parallel idea that of the real court, higher court. Parallel idea that of a high court or Supreme Court. And what happens in a higher court and Supreme Court, the whole judicial process, be it criminal or civil or public process, it is based on simple probability, and there is no place for either sentiment, emotion, social fabric. What will happen due to a particular verdict or due to a particular process to the social fabric, whether it hurts social fabric, harms or dents social fabric, or breaks down some social fabric or social sentiments, social emotions. So in the similar fashion, idea of harm is determined or defined, that it is the harm in the sense of only right hand duty, which is imposed from above. Even in the West, the modern theory of rights, the way it developed, and the greatest problem that the theoreticians of restorative justice are facing and would continue to face, how to bring out or emancipate this new project or movement from the shackles of liberal theories of right and duty. Harm, the way victim and the person, the perpetrator. This is the two. It works in a binary manner, victim and. But there is no accountability or taking into consideration of what happens to the society as a whole, not only of the individual. So can we enlarge it? So whether can harm be identified in a larger fashion, looking into the connection with which the individual can really and actually be perceived to be an individual. Multiple or innumerable connections or networks he has with, including nature to society and other individuals. Now again, these are the problem. Nowhere the education system or the new education policy and the thing we are practicing in law school, sciences, these fundamental questions are raised. Now, what happens in a court, and the students are already taught in the very first year or second year onwards that you have to do an judicial process, and it works on mathematical probability. Neither the respondent nor the petitioner are concerned with either truth, primarily, which would be the highest concern, or should be the highest concern according to Gandhian and ancient philosophical perspective of any judicial or trial procedure or process. But what is happening in a post-modernist and post-truth world sense? Only both the parties have to prove their point on probability basis. Kisne kitna point prove kiya? Petitioner ne kiya, isne kiya.
Somebody request to conclude.
We are going. Yes, Honorable Chair. So the thing that is already there in the traditional legal system and the judicial process, our students not only law, but in other disciplines are also taught and they imbibe it. They cannot be emancipated. They have to be competitor. Now, competition and restoration, both cannot go together. That's all. Thank you. Thank you, Suplaji. Thank you, Jaswal sir.
Thank you, Chanchal. May I now invite the
Excuse me, sir.
speaker? Yes.
May I go next, sir? Am I visible?
Ayushi, okay, go ahead. Switch on your
am I
camera.
visible, sir?
Yes, switch on your camera. Yeah, you are visible now. Go ahead.
Yes, sir. Yes, sir. As said by Dr. Howard Zehr, an American criminologist and a pioneer of modern concept of restorative justice, he said, and I quote, "Restorative justice does not ask what laws have been broken, but who has been hurt." A very good afternoon to all the dignitaries present. I, Ayushi Soni, a sophomore at Himachal Pradesh National Law University, is here to present my research paper on the topic Restorative Justice, an alternative to conventional justice response system. Conventional justice system focuses on giving the punishment. It asserts that the punishment should be proportional in proportion to the wrongdoing committed. Restorative justice has emerged as an alternative to this conventional system. Restorative justice is a philosophy which provides an entirely different view of thinking about crime and victimization. It assumes that person most affected by the crime, that victims and offenders, should have the opportunity to become involved in resolving the conflict. It focuses on transformation of criminals through reconciliation of families and greater public. The objective of restorative justice system is to get offenders to take their responsibility of their act and to recognize the damage that has been caused and to enable them the chance to redeem themselves and to preclude them from causing more damage. This may be include payment of money given by the offender to the victim, apologies, and to compensate to those who are affected by his crime, to ensure that no future harm should be caused. Most contemporary criminal justice systems focus on law violation, the need to hold offenders accountable, the need to and to punish them, and the other state interest. Actual crimes are quite subsidiary to the process and generally have no legal standing in proceeding. Crime is viewed and has been committed against the state, which therefore essentially owns the conflict and determines how to respond to it. The resulting criminal justice system is almost entirely offender-driven. Restorative justice offers a very different view of understanding and responding to crime. The three big ideas, if we say about the restorative justice, it can be repair, encounter, and transformation. Repair means crime causes harm and justice requires to repair that harm that has been caused. Encounter is the best way to determine how the affected parties decide the future outcome together, and transformation is fundamental changes in the public relationship and communities. Restorative justice emphasizes on the importance of working with prisoners and victims in the way that promotes healing and encourage reconciliation, elevating the roles of crime victims and community members in the process. Holding prisoners directly accountable to the people who has been affected from their crime, and to whose rights has been violated, enabling the prisoner to have access to the transformative programs while incarcerated, restoring the emotional and material losses of victims and providing a range of opportunities, dialogue, negotiation, problem solving whenever possible that lead to a greater sense of community safety, conflict resolution, and closure for all involved. Restorative justice is a different way of thinking about crime and response to the crime, focusing on repairing the harm. Though there are challenges in implementing restorative justice, these challenges, if we say, can be sustainability, structure, education. The need for sustainability is measuring if funding is continuous, as the funding is required for the smooth functioning of the system. That comes out to be a significant challenge. Under the parameter of sustainability, the time component and the availability of individual as and when required is also come under this head. And then comes the structure. It is the challenge as the current structured justice system is in respect to the retributive system, which is designed to know the truth behind the action, in rather than holding one accountable to the harm and healing the victim overall. So both the design retributive and the restorative have both have different design, and they are entirely different concept. In the absence of a structure, various challenges arises in the need, that is the need for standardization of models and coalition activities. For the formulation of designs and the coalition, the stakeholders necessary, and this turn out to be a difficulty, the meeting of minds of designing the tough tasks to obtain. The designing of the policy will serve the ends and of all the stakeholders with a bigger problem than it seems to be. The challenges and the need of education in implementing the restorative justice is important as to end the stereotypical method of assumption and to decrypt what has been written. Education is furthermore important as from a different perspective, if we see, to make people encouraged to opt for the restorative justice. To conclude up, I would like to say that the current justice system deals with finding the truth and punishing the one who has committed the crime. It does not take care of one who has been hurt, the victim. There has been dissatisfaction around the current formulated system for imparting the justice. This dissatisfaction has led to a new design of system with an entirely new vision. Restorative justice has made advances all over the world. Countries like Norway, a country which practices restorative justice, is one of the countries which have lowest crime rate in the world, according to the report by United Nations Office on Drugs and Crime (UNODC). In 2018, Norway had a murder rate of 0.53% of over per 1 lakh people. The correctional because the restorative justice, the correctional facilities in Norway focus on care of the offender and make sure they can become the functioning member of the society again. And it has one of the lowest. Yes, sir. I would like to say, therefore, restorative justice is a movement that is vital for the conflict transformation in our country. In the long run, it can change the mentality of our entire culture, as well as our country can become more sustainable. Thank you.
We all need to listen the views of young generation because they are the one who will be changing it entirely, I believe. Chanchal, you are not audible here.
Excuse me, sir.
Yes, Ayush.
Quickly present my paper. My connection broke.
Oh, sure, Ayush. But most precise, as much as you can. Okay. Go ahead.
Sir, student of paper is titled Aspects in India. Starting with my paper, I would just present that I have divided my paper in 3 broad categories that I'm going to proceed with. Would be justice system in our society, how restorative justice is answer to that, and alternative to that, and thirdly, how we can implement this restorative justice paradigm starting from education in our country. First of all, as it has been talked about, that restorative justice entails the idea of making the perpetrator of a crime and the victim simply to talk with each other and to face the demands and to face and demand answer with respect to the commission of the crime. It is whenever a crime is committed in a society, it is always directed to the state. It is the state that is replying to a crime that has been committed in the society. Great sociologist Emil Durkheim had presented in his capitalist that whenever a crime is committed, it is flowing through the normative conventions of the society that is existing, and at the same time, Michel Foucault has pointed out that it is the power tactics of the government, that the judiciary that is governing a society. It primarily aims at reforming the perpetrator of a crime from correcting him, but in this scenario, only it is the victim that has always been left out from the system. A victim of a crime is always left out of the system. So restorative justice primarily aims at including the victim of a crime in this scenario, and it simply by offering empathy and support, that is to say, because the that the existing punitive measures has is to rehabilitate perpetrator of a crime, to reform a perpetrator of a crime. It is very important that he realizes and he's held accountable of the acts that he has committed, how the harm that has been occurred has caused, how the ramification of the harm has been for the victim of a crime. So just to summarize, I would like to say what I have suggested, because in my paper, because my paper primarily talks not about the post consequences of a crime, but before that, it is the mentality of an individual during his upbringing from the very childhood that determines how he's going to be in the future. The mental trauma, in many cases it has been found that when a perpetrator has committed a crime and we conduct a background check, there has, in majority of the cases, there has been a mental trauma, a mental turmoil that has led him to commit such a crime. So first of all, that what I suggest through this paper is we introduce a system in our education policies where we can enhance the upbringing of the students by cultivating and inculcating in them the morals and moral science that is associated with our actions in a society. Moreover, in a country like India, the rape and sexual assault practices are very prevalent in the world. So a very well-defined sex education is to be introduced in school curriculum of our country, along with moral sciences and introduction of feminism. A feminist theory, whether we agree or not to that, is very important to be introduced in our curriculum, so children know how we have to conduct ourselves and we have to pay our respect to women and the other genders that lie within the spectrum. Concluding my paper, I would like to say that it is a relatively new theory. Restorative justice is a relatively new paradigm, and I'm not suggesting that it is a replacement for the existing punitive system, but it should go in tandem with the punitive measures and justice system of our society. Thank you.
Thank you, Ayush. Thank you very much for making this presentation. May I now invite another Ayush, but this time Ayush Raj. Yeah, Ayush. And I think I can take the liberty from you. Ayush, your paper is titled as Restorative Juvenile Justice, a Theoretical Framework for India. So we all are from law background, and other police officers to whom I can see here, they're also dealing in the same pattern. So if you quickly jump to theoretical framework, which you are suggesting, only on that.
Yes, sir. I'll do the same. My co-author is also here, Shruti Jain, but she wouldn't be able to show her video due to internet connectivity. I hope I'm audible absolutely to everyone.
Absolutely.
Okay. Amit sir, if I can be given the presentation rights, please.
As quick as possible.
It's done, Ayush.
Okay, sir. Don't worry, sir. I'll quickly wrap it up. Okay. Just give me only like 6 to 7 minutes, so please. Okay. So भगवान कृष्ण ने कहा है गीता के बारे में कि जो कुछ गीता में लिखा गया है और जो कुछ गीता में समाया हुआ है, बस वहीं तक संसार है। और रश्मि रथी, जो कि रामधारी सिंह दिनकर के द्वारा लिखा गया है, मैंने उसे कई बार पढ़ा है। कहीं ना कहीं मुझे लगता है कि जिंदगी के हर पहलू के हर बात को उन्होंने पूरे कविता में संग्रहित कर दिया है। रामधारी सिंह दिनकर इस कविता में एक जगह पर लिखते हैं, जहां जो कि इस कंटेक्स्ट में, इन द कंटेक्स्ट ऑफ रेट्रिब्यूटिव एंड रेस्टोरेटिव जस्टिस फाइंड्स रेलेवेंस, ही सेज, शरासन तान बस अवसर यही है, घड़ी फिर और मिलने की नहीं है, विशिख कोई गले के पार कर दे, अभी ही शत्रु का संहार कर दे। सो ही इज आस्किंग अर्जुन टू किल Karn, while Karn is helpless because of retributive justice principle. But towards the end of the same stanza of the poem, he says to Yudhishthir that Yudhishthir bhuliye vikral tha vah, विपक्षी था हमारा काल था वह, समझ कर द्रोण मन में शक्ति भरिए, पितामह की तरह सम्मान करिए. So he's trying to actually give homage to the person who has been retributively killed as a context of restoration of the injustice that has been caused to Karna in the Mahabharata. Okay, now this is the context or the backdrop in which the entire restorative justice मेरी समझ में इसको summarize किया जा सकता है. Now I would not discuss much about restorative justice because a lot has been said. The only thing that I want to mention through our paper, I and Shruti, is that there are three primary arguments or four primary arguments that we have. The first argument is the policy on which the Act of 2015 is based and how it departs from restorative justice and why restorative justice should be assimilated into the Act of 2015. Second, the second argument is that experience from the world shows that there is evidence for decreased recidivism on the basis of restorative principles. Third, with respect to the cost analysis of restorative juvenile justice system from across the globe, there is again evidence that this approach can be applied and it can lead to lesser financial expenditure on the exchequer. And fourth, which has already been dealt by other speakers, which is the Hindu philosophical foundation of restorative justice system, and therefore it should be integrated into the juvenile justice system of the country. Now, I would request Shruti to just summarize the juvenile justice system and the Act of 2015, and then I'll just take 5 more minutes to summarize my arguments. Shruti, could you please go ahead with this?
Yes, sure. Thank you, Ayush, for beautifully explaining what is restorative justice and its concept. So, quickly running to juvenile justice system. So, in one line, I can say that the concept of juvenile justice system was never existed before the 18th century. So, earlier, the juvenile offenders were no separate than the other offenders. So, they were prosecuted the same way in same criminal courts with same penalties and similar sentences based only on the crime that they commit and not specific to their age. But then there is a need which came for the like there were a lot of international conferences and conventions came up which talked about child welfare and how the juveniles are treated. So India also came up with different acts and talked specifically about the juvenile offenders. So first the Children Act 1960 came, then with 86 Act, and finally we enacted the Juvenile Justice Care and Protection of Children Act 2000. Even if all these laws were in existence, the system were never restorative in the approach. Then we have all seen and heard about the unfortunate incident of Nirbhaya case. So it was important in many aspects. And the aspect which we wanted to talk to you about is the juvenile justice system. How the juvenile justice system took a reverse mode after the case. So in the beam of law, where one side propounded the lenience on minors as a mandate for a civilized society, the other category demanded a retributive reformation. So petitions were filed in the court, committees were set up. So here, the one important committee which was set up was the Justice Verma Committee. So it specifically talked like how the talks which are happening of reducing the age of juvenile from 18 to 60 is wrong, because already existing system of justice in India is bad, is not actually following what is stated in the law. The children institutions were not reformatory, and how state are failing in their duty to protect the children, which they has to do. So if we go for lowering the age of juvenile from 18 to 16 years, it will further deteriorate the situation. But going against the committee recommendation, the Juvenile Justice Care and Protection of Children Act 2015 came up. And this act was problematic in many approach, but if we talked about the restorative approach, so it had certain sections like section 15. It talked about there has to be a special category for juveniles of 16 to 18 years, and a discretionary power is given, a discretionary and I would say a wide power is given to the Juvenile Justice Board to determine whether a juvenile to be treated as an adult or not. So here, the assistance of psychologists is not mandatory. So here, you're determining the mental capacity of a juvenile to commit a crime, and you won't be requiring a person who's professionally qualified to determine it.
Dr. Grijesh,
Professor Jashwal, from organizers, we have a request.
Yes.
We are running short of time. We have second session at 4 o'clock. So can we make it short? After Amit, can we have deemed to be presented for the two papers?
Okay.
2 minutes
Rather
each,
than,
or 2-3 minutes
rather,
each.
no. That would not be a fair,
Sir,
Chanchal.
that is our request.
Rather than deemed presentation, better we should cut down the time.
Very good, very good. That's what I'm suggesting. Either 2 minutes. We need 10 minutes break before we start the second session at 4 o'clock.
Yes, sure.
Thank you.
Sure. Ayush and Ms. Jan, please quickly
Yeah.
wrap up.
Okay, so Ayush will now talk.
Yeah, Shruti, thank you. So coming to the theoretical framework that I'm talking about, the theoretical framework is yet to be developed, sir, because it is not possible for one person to develop the entire framework which would be applicable with respect to the restorative justice in integration with the retributive justice system which is currently prevalent. However, there is ample evidence from around the globe in terms of lowering of the cost, in terms of the effectiveness that this can bring, and in terms of the Hindu philosophical approach, which is already enshrined in the Indian legal system, which has been time and again reiterated in various reports of the Law Commission, and therefore the restorative justice approach could have been easily integrated in the Act of 2015. So progress is needed. Need for some more analysis on this aspect so that a proper practically implementable framework can be developed, which I'm working on through this paper, which I hope in a year or two I would be able to better develop and better present. So thank you so much for this opportunity, sir. Thank you so much. Thanks for the time, sir.
Thank you, Ayush. Next presenter is Dr. Amit. You are not audible, Amit.
Thank you, Dr. Shukla. The paper is titled, in quotations, Civilizing Rape, an Analysis of Provisions in the Indian Penal Code 1860. And the paper is a semi-baked, half-baked product. I've been working on this paper on this idea in collaboration with my co-authors, whom unfortunately, due to an inadvertent error, I have not named here. They are students from the university, Miss Marine, who's an assistant professor of law at UPES Dehradun, and Nishant Goel. He's a student of the current 9th semester. I duly acknowledge contributions, sincere contributions to this paper. And the idea very seriously when she says when men discovered that they could rape, they proceeded to do it. Later, much later, under certain circumstances, they even came to consider rape a crime. Can justice in cases of rape be better administered if rape were to be governed by civil rather than criminal law? This is an overtly outlandish question, but is at the heart of the exercise carried out in this paper. It's nowhere a definite argument that we are trying to make, but by asking this question, we are definitely trying to destabilize certain fixed ways of our understandings of crime as an act that has the capacity to shake and affect collective conscience. And we are questioning this idea of the collective because it comes to us from a train of scholarship which is overtly patriarchal, be it Durkheim or be it modern day lawmakers as Macaulay. So we have tried a deconstruction of the provisions in the section 320 of the IPC. We have tried to deconstruct the notion of grievous hurt and psychological damage that an act of sexual violence causes to the woman who gets constructed in this modern criminal jurisprudence as a creature who is specially vulnerable and therefore in need of proactive legislation. So it's a paper that's still under progress. We'll need some more time to finish it. I thank you for this opportunity to present this seed of an argument in front of this august audience. Thanks.
Thank you, Amit. Thank you so much. May I now invite Ms. Shivani Singh?
Yes, sir, I'm here.
Yeah, please.
Am I audible?
Yes, you are.
Okay. Greetings to the chair, co-chair, faculty members, HPNLU, organizing committee, my co-presenters. So my topic is inconsistent decisions and delay in judicial review by Supreme Court of India, contemporary issues. So I'm skipping the part wherein I have explained the concept of judicial review and the jurisprudence related to the Constitution Court. I'm directly coming to the recent cases by the Supreme Court of India. So, Supreme Court suo moto's initiation of contempt proceedings against lawyer activist Prashant Bhushan for 2 tweets criticizing judges of the Supreme Court, including Chief Justice of India, is against the principles of judicial dignity and prudence. Most importantly, when 3.5 crore cases are already pending and they have been postponed because of the COVID situation, it is hard to understand why Supreme Court considered the case of contempt to be more relevant. The problem is not a matter of interest. Contempt of court has been completely and notably been dismissed by the nations such as the US and UK. Supreme Court itself in Shreya Singhal 2015 judgment clarified what freedom of expression meant in sense of social media. Moreover, though the 274th report of the Law Commission report that attacks on the personal dignity of a judge as punishable contempt is also mentions that the very essence of the authority is a sacred obligation on the court to conduct it with the utmost caution and circumspection. So the Apex Court itself in 1974 set out a litmus test for the assessment of contempt. It will be decided if the alleged matter is false either to the judge directly or to the public. Most importantly, the main word is justice and not judgment. Additionally, the inadvisability of taking admission of action in the middle of a pandemic, it places the lives and livelihoods of people at significant risk and confusion. Besides this, the presence of 60,000 lawsuits, including a bunch of habeas corpus pleas from Jammu and Kashmir pending before the court. In this situation, the court would have reconsidered its stance before the rightly hyped case of Prashant Bhushan. 2 more cases have been come into the light. In the midst of 2 instances of social media offenses related to the chief ministers within 30 days. Not going into the details, I'm just taking the name of the 2 journalists, Prashant Kanodia and the worker Priyanka Sharma. So hearing Kanojia's bail plea, a bench of Justice Indra Banerjee and Ajay Rastogi ruled that the right to freedom of speech and expression protected by Article 19 of the Constitution is non-negotiable. Hence, bail was granted. However, conceding bail to the Sharma, another bench of Justice Banerjee and Justice Sanjeev Khanna initially based the release on an apology saying freedom of speech is non-negotiable, but it cannot compete with the rights of others. This is not done. It is unfair to put one's face on someone else's. So the condition was consequently revoked after Sharma's counsel said that calling for an apology before her guilt had been decided would constitute an infringement of a fundamental right to freedom of speech and expression. That also that Section 66A was struck down in Shreya Singhal in 2015. Section 67A does not refer to the circumstances of the case, and Section 500 is a bailable offence. Now coming to the migrant crisis, including infringement of heap of those rights of countless citizens, following the game-changing lockdown requested that the judiciary activate itself. Off chance that if the Supreme Court or High Court has stayed that action for a week or so to empower government to encourage the exchange of traveler labor in humane way, the entire issue would have been unraveled with no attack against the legislature. In case of Kashmir, till November 2019, almost 22 petitions had been filed. Nothing could be more crucial and important to the Supreme Court of India than hearing them. The intentional delaying of the matter by stating we do not have time to hear so many matters. We have a constitutional bench case, Ayodhya dispute, to hear. I would like to conclude it by stating a few points from the Justice Amitav Roy from his farewell speech. He says that I feel that we cannot in any way project a fractured face to anyone. If this happens, we lose credibility. If we lose credibility, we lose paramountcy of the judicial process. If we lose paramountcy of the judicial process, the rule of law is undermined. Thank you.
Thank you, Shivani. Thank you for your presentation. May I now invite the last presenter for this technical session, Ms. Priyal Sipaha.
Sir, am I audible?
Yes. Also, Brijesh, an announcement that the paper has been co-authored by Priyal Sipaha and her colleague Yashwardhan Singh. So that name does not find mentioned in the schedule. Carry on, Mr. Sipaha.
Amit, I'm going to hear a girl whose birthday I attended almost 13 years back. Priyal, probably she might not be recognizing me.
No, sir, I do.
Me. Okay, go ahead, Priyal, go ahead.
Sir, could you please kindly grant us the sharing option? Just quickly skim through the presentation. It will be quicker if you do that.
इनको sharing.
Dr. Amit, please do the needful.
It's being done.
All right. Very good afternoon to the Honorable Chair and all the esteemed attendees. I still haven't gotten the access to share content.
It's being done, Yashwardhan.
Yashwardhan, please continue. We are doing it.
All right, I shall continue. As soon as the share button starts working, I shall share. So my name is Yashwardhan. I am joined here by my colleague, Ms. Priya. We are both final year law students from Symbiosis Law School, Pune. And it's truly an honor for us to present our paper here today titled The Right to Self-Determination in Tibet, Contentions and the Way Forward. Now, before delving into the paper, I would like to address how our topic chooses not to focus on a constricted understanding of restorative justice in relation to the commission of a crime. Rather, as Ms. Upneet Lalli has stated in her inaugural address in the morning, what is restorative justice? In fact, restorative justice is a victim-driven movement. It is something which focuses on addressing the wrongdoing to the victim in a way so as to bring about resolution between the wrongdoer and the suffering party. This was also noted by Honorable Justice Clearis in the morning session, who stated that crime hurts and restorative justice is about repairing harm done through domination. Now, this paper aims to look at restorative justice from the point of view of the state as a wrongdoer and an ethnic minority citizen as the victim. Now, in furtherance of the same, our paper is divided into 6 main sections. By first understanding what the right of self-determination is, we shall then elaborate upon what the plight of the Tibetan refugees is, after which we discuss the restorative measures undertaken to resolve conflict. We then discuss the present scenario, the role of international bodies, and finally we end our paper by discussing the possible solutions. Due to the paucity of time, I would not be going into the history of the situation of Tibet. However, I do need to mention what the right of self-determination is. Simply put, it is the right of a person to determine his or her political status. Now, this right has been laid down in various international documents, even in the United Nations Charter itself. But today it has come to be associated with the secession or the creation of a new state.
Can I just interrupt there? I think, can you see the option? I can see it.
Priyal, you can present now.
Unfortunately, the organizers, I still do not have the option to share. If Priyal, you do have the option to share, I would urge you to do so.
Yeah.
Thank you.
Okay, can you see that now? Is the
it is initializing.
Okay. Yes. Just let me know when it's visible.
Yes, it is visible. Go ahead, please. Yashwardhan.
All right, Priyal, let's go to the restorative measures slide. So now I'll be talking about the 2 major restorative measures which have been devised for resolving this conflict. Now, both these restorative measures have been proposed by the Dalai Lama. The first is the middle way approach. Now, this argues for greater autonomy to the Tibetans. Keep the Tibetans a part of China. However, let them govern themselves. The second is a 5-point peace plan, which argues for making Tibet a peace zone. That is, no Chinese soldiers in Tibet except for protecting the borders. The plan also argues for stopping China's population transfer policy, which essentially states that Han Chinese people are to come to Tibet and populate the region, making Tibetans a minority in their own homes. Next slide. Today, India stands as the home and hope of Tibetans. Yet, Tibetans in India are not granted citizenship, nor are they treated as refugees. This restricts their personal liberties. Besides, India has not been vocal about the rights of Tibetans internationally. Now, my colleague Ms. Priyal would take the panelists and the attendees through the role of the international community and the plausible solutions that we can bring about. Thank you.
मैंने मैसेज दे दिया मैसेज दिया
is the United Nations Security Council that is more coercive in nature. But the only problem is that China holds a veto power in the UNSC, and it is also coupled by the fact that there exists a principle of non-interference under Article 2 of the UN Charter, which does not allow the UN to interfere in the internal matters of any state. When we look at the international community front,
Dr. Shukla, Priyal, can I interfere? This is Chanchal. Just done your slide. We need 5-10 minutes for the next session. And it will start exactly at 4. Dr. Shukla, can you hear me?
Yeah, I can hear you.
Yes.
You can go to conclusion. Just briefly summarize your argument and
thank you very much.
Priyal.
That China being one of the P5 and a powerful country, not much concern has been raised by the UN and the international community, and the Tibetans are failing because it is not a war against the law, but a Chinese ideology itself. And this has been seen in a lot of cases, such as the Falun Gong religion, which originated from China, and the recent case of Uyghur Muslims. And the religious policing of China is not a new or an alien concept to the world. To curb this problem, we pose 2 solutions to it. First is the concept of power dividing, which focuses a lot on restorative justice, constant dialogue between parties and setting up a system of checks and balances. And this has worked to the extent that it has granted independence to a lot of states, such as the cases of Rwanda and Urundi and West Samoa, as well as New Guinea. And the second solution is a future vision where the autonomous word in the Tibet and can be given a more political settlement that can end into their into the granting of them as a liberal state. So these were the 2 solutions. Due to the paucity of time, we could not explain our proposals in depth. But
with the permission of Chair, I'll just add to all presenters that we will continue to interact with respective papers of the contributors, because these papers are to be developed, fully researched further as respective contributors desire and things fit appropriate. Fine. And that then it is to be published. So we still have option to continue to be in touch and do the academic work further. Over to you, Amit.
Without taking any more time of the participants, as well as of the esteemed chair and co-chair, I would like to thank each one of you presenters for being here. And I would reiterate, this is merely the beginning. We'll continue to interact, we'll continue each other's work, peer review, because we will come up with a publication. Thank you for your patience, and thank you for showing interest in HPNLU's and International Conference on Restorative Justice. And we are very hopeful, and we would indeed be very happy if you join us for the technical session that is to follow in the next 5 minutes. That's at short notice, but still, we need you for ideas. Thank you so much. Thank you so much, Professor Jaswal, Registrar HPNLU, for agreeing to chair this event, and to my colleague, Dr. Shukla, for for agreeing to co-chair at your extremely busy schedule.
Kindly, all participants kindly continue to be logged in. We are not ending the session. The same link and meeting will continue for the next technical session, which is on empirical aspect of restorative justice. We'll start sharply at 4. Thank you.
Thank you.
Ma'am, with your permission, can we start? Can you hear me, ma'am? And you, ma'am? Ma'am, please unmute yourself. Yes, thank you. Thank you, ma'am. A very good afternoon, participants. With the permission of chair, I would just like to introduce chairperson of this session, Dr. Anju Alitiko, who is an associate professor, Law Center 1, Faculty of Law, University of Delhi. And for me, it's a pleasure to state that she has been my teacher, and I have been her younger colleague for 7 years at Law Center 1, Faculty of Law, University of Delhi. Ma'am has taught since 1989 at Faculty of Law in Campus Law Center, and then Law Center 1, and then she has also worked as professor at National Law University Delhi during 2007 to 9. Ma'am's interest area includes criminal law, criminology, law and society, jurisprudence, civil liberties, advanced jurisprudence, socio-economic offenses, and business regulation. Ma'am, I remember that while I was at the university, you had actively organized along with other professions a conference at on restorative justice in the university. So we find surely there is no better person amongst us to chair this session, particularly critical session, other than Professor Dr. Anju Alitiko. Our co-chair for this session is Dr. Amit Chaturvedi, Assistant Professor of Sociology at HPNLU Shimla. Am I audible?
Yes.
Yes. Amit is one of the keen and erudite scholar at our university. I must state that, and he has interest not only in sociology and anthropology, but he's a keen researcher and reader, learner of victimology and criminology, forensic sciences, as well as criminal law and other public law. He teaches both at graduate and postgraduate level at HPNLU Shimla. So I welcome all participants and particularly Honorable Chair and Co-Chair. Thank you, ma'am, and welcome, ma'am. Over to you, ma'am. The house is at your disposal. Command. Thank you.
Thank you, Chanchal, for those wonderful remarks and observations. I also remember those days when we were together. Anyway, in this era, virtual convergence has become the rule, has become the norm. So, enjoying that, getting back to meet some old friends and then meeting new ones through this platform. Coming straight to the program schedule, because I happened to present a paper in the previous session. So what I suggest, and I would wish to have the opinion and input from my co-chair, that let's devise a strategy wherein we say that 8 minutes to say the last time. So it would be say 6 + 2, so that we have got good enough time in between to maneuver the time limit, so that we need to finish off by 6. And we have got by the list 14 participants. So 14 into 8, that turns out to be somewhere around 112. So we will be reasonably well within the time. And maybe at 6 minutes of speaking by every presenter, we can somewhere tell them that the time is up, so that we have some time for interaction also. If you agree, then please let me know.
Sure, absolutely done, ma'am. Thank you.
Okay, then the list that has been shared, we have Ms. Golda Sahu. I invite Ms. Golda Sahu to come up with the presentation, and I repeat again, 6 + 2, dear.
Thank you.
Take care.
Invitation.
All the best.
Can you hear me?
Yeah. Yes, we can hear you.
Good evening, all. I am Ms. Golda Samu from Tamil Nadu National University. I am assistant professor in the area of case arrangements. I am going to give a small presentation with regard to victim impact statement and how this victim impact statement having impact on the restoration of the victim. And take very little time. I know since time is running away. So, very beginning, I want to give that how and why we need victim impact statements for restorative justice. And then we'll see the pros and cons of victim impact statement. And we'll see the different cases with regard to victim impact statement. Then the last part, I will conclude with misunderstood measures. As we know, the victim plays an important role in criminal justice system. But in addressing the system, always we focus on accused and their rights. In that way, the victim feel a kind of ignored and kind of mental agony. And throughout the justice system, our court process designed in such a way that all the vital stage of the court process in trial, the victim not required and the victim presence is not mandatory. But at the same time, the accused presence is mandatory. For example, when the charge has been framed, or the accused discharged, or granted bail, or by the time of punishment or compensation, all crucial stages, victim presence is not required. In that way, the victim failed a kind of secondary victimization again, and it's really traumatic mental stress for the victim. For that reason, I would like to recommend that victim impact statement must be mandatory in our country. In the very beginning in 1987, this particular concept of victim impact statement has been germinated in US Supreme Court in Booth versus Maryland cases, but that time this particular system has not been approved by the court. And that is all. In 1891, that time, in another case, Fine versus special cases, Tennessee cases, Fine versus Tennessee, in that case, the concept of victim impact assessment has been approved. And since then, lots of other countries like UK, Canada, Australia, and New Zealand, many countries they have started applying this particular concept of victim impact statement. Victim impact statement is very short. It will explain it's nothing but a small statement. It can be oral, it can be a written form, it can be by the victim or by the relatives or friends if the victim is not comfortable in physical and mental state of the victim is not proper. Then it can be explained about the particular condition, the impact of the crime, and it may include his physical and mental impact by the crime or the even upon the relationship of the victim or the financial impact. Altogether, it must be present in this particular statement. At the same time, the victim can be confronted with the accused and can explain the how the crime committed by the accused having the impact. In that way, even if it could take impact on accused as well. And in Supreme Court also, in few cases, not in more cases, they acknowledge the requirement of victim impact assessment. The past case, Malik Arjun versus State of Karnataka, and that case is can be clear that the impact, the stress must be given to victim impact statement so that accused can get appropriate punishment. At the same time, victim also will get a kind of relief. And in another case in 2013 itself, in road accident cases of the cars versus state, in that
Respected Chair, time's up for the speaker. Ma'am, unmute yourself, please.
Oh, Ms. Golda, another 2 minutes to conclude.
So we see the pros and cons of victim impact statement. If there are lots of benefits are there, the curative measures. Apart from the curative measures, we have to think about the negative point as well, the loopholes as well, existing in this particular victim impact statement. As the victim impact statement, the statement given by the victim at the time of trial and sentencing, the court must ensure about the veracity of the statement. It must not be false or it must not be narrative in nature. At the same time, the age, gender, and religion, community, and other factors must be taken into consideration. As far as possible, it needs to be conducted through camera trial. At the same time, focus must be given to the people and the frontline officers so that they must be ensured that the statement can be recorded voluntarily. There should not be any kind of compulsion as it's completely private in nature. And last but not the least, the statement, the victim impact statement need to be statutory to give statutory recognition so that there will be a standardized form and a victim need to go through the particular standardized form and mandatory permit to the prosecutor, and that way victim impact statement can be an effective tool in a way of restorative justice.
Thank you, Golda, for that concise and precise evaluation of the relevance of victim impact statement. And I'm happy that you have highlighted this. I would certainly wish you to further dwell into the strategies as to how we are going to come up with an effective victim impact statement. Given the vast differences and disparity in our population base and the wrongdoer and the wronged, how they are pitted against each other, along with sexual offenses, I would love to hear you at some point of time or maybe see your writing wherein you are also devising strategies for not only legalizing a victim impact statement through CRPC amendment, but also to devise the guidelines as to how the same can be implemented. Dr. Amit, would you like to observe or suggest or comment?
Sorry to interrupt, ma'am, that one important point is section 235 of section 2, which mandates the court to hear the accused before the sentencing.
Yeah.
At the same time, there must be some legal provision in that particular section with some other subsection regarding this victim impact statement as well. So that there can be a balance between the two. Suppose subsection 2 is talking about to hear the accused before the sentence, that is talking about section 235 of CRPC. Similarly, there will be amendment to the particular section as well. So we can ensure the balance between, and the victims won't feel a kind of ignored. We can marginalize victims at the same time in this particular
I understand, Golda, a valid thought process, immediately thinking on your feet that 235(2) can be similarly made applicable with reference to victims' participation when we are talking about sentencing. But I am afraid that only at the time of sentencing, we are asking for the viewpoint of the victim, but should we not be building it throughout the mechanism of even the pre-trial stages?
Yes, exactly. But the court should not give much stress to the willingness of the victim regarding the sentencing process, because they are not the legal expert and how the evidence and other part. That part after talking, at least court must hear before the sentencing the accused, then only the victim, the mental trauma can be minimized.
Thank you. Thank you. Very well taken. Dr. Amit, the floor is all yours if you want to.
Thanks, Ms. Sahu. I'll repeat, go back to your paper and I'll write to you. Maybe I'll write to all the presenters for a collective feedback and suggestions. Thank you.
Okay. The second speaker for the day is Dr. Ranjana Ferrero on sexual violence in marriage and social change in India. Again, just a reiteration, 6 + 2 minutes, and here with me it is 4:16. Please.
Good evening to the Honorable Chair, and I thank the organizers for giving me an opportunity to present my paper. Marriage is a But unfortunately, the concept in India is once a woman gets married, the husband acquires a control over her body. Not only in India, but worldwide, the World Health Organization has reported that 1 in 3 women are victims of sexual violence in marriage. The question I'm raising through my paper is that marital relationships should not be a shield for abuse. What is sexual violence? Unfortunately, we do not have a clear definition, but we have to refer to a galaxy of laws to answer this question. It could be simple practices like forceful kissing, some sexual acts, disrobing a woman forcefully, or some act directed to the personality of the woman. It could even be an attempt to commit this act and an unwanted sexual comment or even an advance. But the victim being a wife, many a time she's blackmailed and threatened, and the most horrific form of sexual violence in marriage is rape. Unfortunately, the wife being the victim is left with a very few remedies. If we want a very good definition of the word marital rape, there is a huge legal conundrum over this word. Rape, yes, is defined under section 375 of the Indian Penal Code, but different law commissions and expert opinions have given different views whether it should be criminalized or not. For example, the 84th Law Commission report suggested that when a woman undergoes rape, she undergoes two crises: the legal crisis and the subsequent trial, and of course the trauma that she. But a wife who suffers rape has only remedy only in cases when she is separated from her husband. Otherwise, in all other rape cases in marriage, she would not have a remedy. An important element of the offense of rape is consent. Now, the only defense in rape is that the woman could have probably consented to the act. But when there is a threat, and when she's blackmailed, when she's forced to have sexual intercourse with the man who happens to be a husband, this happens to be an exemption of law in the legal system, which is drawn by Sir Matthew Dale's implied consent theory, which says that a wife automatically consents to sexual relationships with a husband. So therefore, to some extent, the courts also sometimes have regarded the wife as the husband's chattel. The word marital rape would include all kinds of unwanted sexual advances, but not defined in our legal system. Married women have a very limited right while filing a petition. Experience has shown that even when they go to the police station, the police are reluctant to lodge a complaint because they are not sure the FIR would be registered under which provisions of law. There is a lot of delay in registering the cases, and the biggest problem in marital rape cases is the collection of evidence. Usually the courts rely on circumstantial evidence, but in this case, the question is who will give the evidence, whether the husband, the relatives, or the wife. There also might be situations where the wife has gone through a history of physical sexual violence, and this might be a habit. Many wives have started facing violence immediately after the honeymoon period. So it becomes a problem for women to get justice. Very often the judges do not treat marital rape and sexual violence in marriage as a more severe crime than the way in which they would have treated rape. The point I'm raising is, should India criminalize rape? Yes, in a number of court cases, the courts have said that we need a law, particularly court in its own motion versus state, where the court struck down exception 2 of section 375 of IPC, but they clearly said that if the wife being under 18, then it is a criminal offense. But on the other hand, in RJI Foundation versus Union of India, the courts also went on to say that just because other countries has criminalized marital rape, India need not go the same way and follow them blindly. But the courts have also been very kind and helped up feminist jurisprudence in India, where they said the wife is not the chattel of the husband. And right now, currently, as we are debating this topic, the Delhi High Court is looking into a petition which is talking about criminalization of marital rape. Since the judgment is not out, I would not be discussed. What would be the positive steps as far as we could give justice to women? The answer is criminalize it. No, criminalizing will not be enough, because as we have seen, we have brought stringent laws in rape. The Justice Verma Committee brought the Criminal Law Amendment Act 2013, but has it helped to stop rapes and horrific rapes in India or gang rapes in India? Answer is no. So legislation is not the only solution. First of all, we need effective police training and change in mindset of all the legal officials involved. Secondly, we need to conduct a lot of public awareness and education to impart gender justice and, importantly, recognize the rights of women in marriage. And last but all, keeping with the theme of this conference, rehabilitation programs need to be conducted for those abusive husbands who are in a perpetual history of conducting abuse on the wife, preferably restorative justice, because what we see is here is a relationship within the family, and punishing the husband and sending him to the jail may not be the right option for the wife. So preferably,
Time's up, Honorable Chair. Time's up.
Thank you very much to the organizers.
Thank you, Ranjana. I've got two questions to you. One is that when we are talking about, your title is sexual violence within marriage, sexual violence in marriage and social change in India. And the topic of the conference is restorative justice. So my first question is that when you're talking about sexual violence, somewhere you interchangeably use the word rape along with sexual violence, and you did talk about marital rape also. So I am anxious to know, and when you are talking about sexual violence and rape specifically, can we say that even touching or kissing amounts to rape? First question. Because I can understand that as a component of sexual violence, but can we say that it is rape? In your presentation, it came up as a part of rape. So I'm just wondering on that. And the second question is, when we are talking about restorative justice, and you are saying that rehabilitation of the husband, I am rather, I'm at a loss of words to understand that. Should it be the rehabilitation of the husband, or appreciating that reformation is different from rehabilitation? The focus should be more on the lines of giving relief to the victim within the institution of marriage, which happens to be within the private realm of the victim, wherein the victim doesn't have any say. So you did talk about patriarchy and all that. I would wish to be enlightened on these two aspects when you are coming up with the presentation of sexual violence. Thank you from my side.
To reply, or should I put these suggestions in my paper? Okay. The first thing is that rape, penetration could be the sine qua non of the rape, but in a marital relationship, it may not always lead to penetration. There may be unnatural offenses involved. In fact, the courts have gone on to say marital rape should be treated as unnatural offense. So starting with violence is the act forcible kissing, the act of forcible touching, which the wife may not actually want, but it's imposed on her, and she's a silent victim to all these things. So because of the paucity of time, I've not been able to explain it too much at length, but it's a stage-wise process which a wife goes through, because the idea of marriage is she is entitled to give her body up as sexual relations with her husband. The second part, when I talk about rehabilitation, my clear focus is that from studies it has been indicated that husbands who are habitual alcoholic, even rape is sometimes the people who are habitual offenders, like who have that desire for sexual activity, would commit horrific rapes, and that would include even their wife. So in that situation, the perpetrator, who is a husband who is having some kind of sickness like this, whether it's alcoholism, whether it's a desire of sexual urge, those people need rehabilitation.
Okay. And with reference to restorative justice?
Yes, restorative justice here, as I'm saying, that it's most important part, that since it happens in the marriage. So first of all, as far as restoration, we need to listen to the victim. We need to send them through an entire justice process. We need to examine the capability of the system and identify the victim's needs. And most immediately, like if you look in the Domestic Violence Act, the wife can get an injunction and ask the husband to move 90 days away from the husband, but that's not enough, and that's not the solution to the marriage. That could lead to the breakdown of marriage. So we need to think about programs which can still maintain the sanctity of marriage and remove the barriers as far as violence is concerned on women.
Okay, thank you, Anjana. And as a last comment on that, whenever you are developing this paper, just try to contrast this sexual violence on the lines of cruelty and sexual violence alone, and then have some theoretical background that on what basis we are saying that people who are alcoholic are we talking about psychopaths, etc., etc. That would come up with a very nice write-up, a consistent and coherent. Thank you very much for that thought process.
Thank you, ma'am, for your suggestions.
Next speaker is Ms. Divya Subramaniam. Prevention of Child Sexual Abuse and Path of Restorative Justice. 426 to be precise, 435. You should be winding up.
Okay, ma'am. Ma'am, I'm audible, ma'am?
Yeah.
Okay, ma'am. A pleasant good evening to everyone present here. I'm going to present on the topic prevention of child sexual abuse and the path of restorative justice. To start with the words of K.R. Narayanan, our former President of India, the of the child and the roadside mars the harmony of the universe. Nowadays, crimes committed against children and the issue of child victims are becoming a matter of serious concern and very heartbreaking. Every day we are coming across in newspapers, magazines and TV channels the incidents of child sexual abuse and the cruelty subjected to children. So when we come into the legal aspect and definition part of the child sexual abuse, World Health Organization has defined the term child sexual abuse as involvement of the child in sexual activity where the child can't understand or unable to give consent. So it includes array of sexual activities like child prostitution and sexual intercourse, exhibitionism, and child luring by cyber predators and etc. So basically, the child sexual abuse it's have a very detrimental and long-term impact on the child health and also on the society. So when we look into the causative factors behind these child sexual abuse cases are more prevalently illiteracy and poverty and excessive use of drugs and increase in watching the porn sites are all the causative factors behind the most of the child sexual abuse cases. In viewing the child sexual abuse as a problem, it can't be viewed as a single crime. We must have a multidisciplinary approach in viewing the crime because the problems like child marriage, child trafficking, and child prostitution and child labor and missing children, in these all problems in the one way or the other way ends in child sexual abuse. According to the NHRC report, in its 108th report, it has stated that every in India, every year 44,000 children are missing, and among them 11,000 were untraced. According to the National Crimes Record Bureau, it is viewed that the children's every 8 minutes a children is missing. So in India, we have a rich heritage and culture of tradition, but the topics like sex and sexuality are considered to be a taboo topic. And most of the time, the adult members of the family are very embraced to discuss the topic among the children. This leads to the a lack of awareness and ignorance on the child, and the child are easily moved by the perpetrators. So, what the culture of silence among the family members should be abolished, and the child must be made aware from the upbringing itself about the topic, and it should not be considered as a taboo topic. So when we come into the legal aspect of the child sexual abuse, our Constitution of India, which is the fundamental law of the land, provides many provisions for the protection and welfare of the children. Starting from Article 15 Clause 3, enables the state to make special laws for the women and children, and Article 21A provides the fundamental right for the children to have a free and compulsory education, and Article 23, Article 24, and Article 51K, etc. So when we come into the international conventions, India is a signatory to the United Nations Convention on Child Rights, and also many protocols it has signed, and it also has witnessed the Kathmandu Commitment Report on ending violence against the women and children in South Asia. So when we come into the addressing the child sexual abuse cases, POCSO Act is a very comprehensive legislation and first of its kind which addresses child sexual abuse. And POCSO Act is a comprehensive legislation which is gender neutral and has approached and has adopted a child-friendly approach in all its procedures from starting investigation, trial, and till the judgment procedure. It has adopted child-friendly procedures. So when we see the one of the golden principle of the criminal justice system is that accused is said to be innocent until is proven guilt. But in POCSO cases, the burden of proof is shifted on the accused, and the culpable mental state of the accused is considered to be present, and it is the burden of the accused to disprove culpable mental state, and even the attempt to commit offense or abatement or such offense are also made punishable under the POCSO Act. So POCSO Act is a comprehensive legislation which addresses child sexual abuse cases. So when we come to the restorative justice part, in these cases, victim compensation plays a major role. So victim compensation is nothing but a social assurance which is given to the victim for the loss suffered from the act or crime. So the victim compensation, according to the POCSO Act, Section 33, Clause 8 and 357, Clause A of CRPC provides the special powers for the special courts to award compensation to the victim. So Rule 7 of the POCSO Rules 2020 also provides procedure for victim compensation, how to divest the funds from the victim compensation fund. So the victim compensation ultimately helps to really have a relief and rehabilitation for the children. That is the aftermath life of the aftermath life after getting justice. So the true pain, actually in child sexual abuse cases, it's very painful in for the child to travel through the entire justice process. But even though after the getting justice, the having a dignified life after getting justice is a very big question mark, and it's very difficult. So the victim compensation helps the child to have a dignified life and have a relief and rehabilitation. When we look into some of the important cases, in one such case, State versus As Mohammed. In this case, the court has in this case, the fact of the case is that the landlord has sexually abused the servant of the servant, that is a girl child. The mother has made complaint in the court that the landlord has sexually abused the child. In the process of trial, the landlord has accepted to marry the girl child. So the mother withdrawn the case, and the court has awarded 30,000 rupees to deposit in the for the victim as a compensation. From this case, we could infer that it's a wrong precedent, because we should not encourage child marriage, and this is not the right way of victim compensation. So it will encourage child marriage.
Time's up, Divya.
So okay, I will conclude by saying that compensation is nothing but it's not a reward or inducement given to the victim for cooperation in the trial process. It's just it's a compensation for loss or injury the victim has suffered due to violation of the dignity and rights of his life. This was said by Wesley. So what I think is that our conventional criminal justice system has changed from retributive justice to restorative justice by the compensation mechanism. This is not enough. We must convert this to next stage, that is preventive justice. That is zero tolerance of violence against children should be our ultimate aim. Thank you. Thank you, ma'am.
Thank you, Divya. I'll quickly make 2 points only. When we are talking about restorative justice, somewhere do you think compensation alone is the rule when we are talking about restorative justice? Compensation has already been identified. I would suggest that you think on the lines of somewhere counseling, psychological facilities being provided, counselors being provided. So that would somewhere go in bringing that self-esteem back to the child who is to see the light of the day. And as far as the preventive approach is concerned, I believe we are thinking on the lines of a utopian society wherein prevention of crime is next to impossible, as Durkheim said, that it is a symbol of pathology. So somewhere we have to accept the reality that at any point of time there would be some aberrations here and there, and people of different kinds would be there in the society. So we should have an approach wherein we should be prepared not only for the prevention but also for the curative approach, wherein restoration would be one component.
Yes,
Dr. Amit, would you like to say something?
Thank you, ma'am, for your comments. You encompassed the paper, and I hope Divya found it useful. And
yes, sir.
We would be reading, writing these papers again and again till the time they are publishable. Thank you, Divya.
Okay.
Thank you, ma'am, for your insightful comments.
Okay. Next speaker is Ms. Aarti Mohan. Reimagining justice as meeting needs, restorative justice and children in India. It's 4:35 with me, 6 minutes to be very precise. So 4:41 is the time limit, and we'll be bothering you again if you do not happen to conclude by that time. Okay, please.
Okay. Thank you so much, and good evening to everyone. So I'm going to be talking about restorative justice for children based on a pilot project that we have been running in New Delhi. My organization is called Council to Secure Justice. So I'm going to talk very briefly about our restorative justice work, but I'm going to be sharing our website details and other information at the end. So please feel free to get in touch with us. So to begin with, why restorative I was in law school with women, and my role was to understand what the impact of prison was on them and what their prospects were for rehab. That probably they had no prospects for rehabilitation. Their families had broken ties with them. They had no opportunity of getting a job or even having any sort of housing once they were released because of the stigma that came with being in prison. And started exploring what alternative ways we can have. Sorry?
In between, your voice breaks. Please carry on.
If you could, Aarti, maybe go off video so that the connection is, it works for us.
Yes, I will do that. Yes.
So,
yeah. So seeing that prison causes alternative ways we have to offer justice and accountability. And my current organization where I work, Council to Secure Justice, has been working with children who've caused harm since 2012, offering legal aid and psychosocial support. So I worked as a lawyer, being with these children right from first response through the trial, through closing arguments. And what I saw was that the trial was extremely harmful for a lot of children. Despite the fact that we have child-friendly laws in India, we have the POCSO. Despite that, cross-examination can be a brutal experience. The conviction rate at the time I was litigating was only 13%. Now it's 34%, but that still means that more than 60% of cases end up in acquittals, not because they are faults of lapses in investigations and forensics, and because of a lot of myths that surround sexual harm cases. That the existing victim needs, often it causes further harm. And that is when at CSJ we started exploring what is it that victims really need. In the morning today at the keynote, Dr. Upneet said that justice is a feeling or a perspective. And that is what we wanted to understand. So from 2016 to 18, we carried out a research study. This is available on our website, where we explored what is it that victims need, people who have been harmed by sexual abuse, what is it that they need. And what came out for us was that for a lot of them, justice was synonymous with having their needs met. And there were certain needs that came up again and again. These included the need for participating in the justice process. Now, victims do testify in the court process, but their role is very ancillary because they're just witnesses in a process that is between the state and the offender. They wanted to have a say in how they could talk about what had happened to them, how they had been impacted. A lot of them said that they needed validation. They needed to be told, yes, this happened to you and this was not your fault. A lot of times in sexual harm cases, incest cases, children are not believed by their families. And that validation was a need for them, which for them was justice. Some said they wanted an apology from the wrongdoer, and some said that they wanted relationship repair if the person who was causing harm was in the family. Of needs, as meeting needs being justice is what led us to restorative justice. It causes harm and that results in needs, and an attempt to repair those needs is an idea of, and that is when we started our restorative justice work. So while the existing legal system solely focuses on what law is applicable, which section of IPC will apply and what the sentence is, there are some factors that are missed out, especially like why is it that the person did what they did? What is the impact on the victim? What is the impact on the community? Often in sexual harm cases, there may be an impact on the community in terms of massive fear, but that is not something that is necessarily addressed by the legal system. Restorative justice is something we saw as a more holistic response that could address all of that. There's a lot of restorative processes to children who've caused harm and children who've been harmed. To children who've caused harm. For the rest, you can read up on our website. The other processes are based on the same principles that everyone has a voice. Necessarily involve the person who caused harm and the person harmed coming face to face. We knew that there are a lot of risks that restorative justice may have. It is not something that is extremely safe. If you bring the person in the same room as the person who's caused harm, they may threaten them, intimidate them. In sexual harm, seeing the person who's caused them harm may trigger them, and that may be extremely harmful for them. So we acknowledge that there are risks, and to offer restorative justice, we must ensure that there is safety at all. So before we start the project, we created robust protocols and ethical guidelines. So these were based on best practice models from across the world. At the same time, we acknowledge that best practice in one context may not really apply here. So we've also culturally adapted it. We've looked at child rights-based tools because working with adults is quite different from working with children. So we use different communication tools while working with children for restorative justice. And we continuously evolve our protocols based on our experiences on the ground. So the stages of our restorative justice process are, yes, I'll just take 2 minutes. Yes, I'll just take 2 minutes. Thank you. So the stages are quite detailed. We begin with an initial assessment of suitability for the case. Now, every case is definitely not suitable for restorative justice. There may be significant benefits, but that may not apply for every case. Restorative justice is based on completely voluntary participation of all participants. One person says they do not want to participate, we will not go ahead. And it involves significant and detailed, which can take up to months and sometimes even years. Then we have the process, and then we have the follow-up to follow up on their well-being and how they're doing and how the process impacted them. Last part of what I'll be talking about. We've done few processes, just 2 as of now, 2 completed restorative justice processes. We've done preparation and many more. We've seen that there are benefits of these processes. This is also backed by evidence, and this is also in our experience. The restorative justice process gives the child who's caused harm a space to tell their story, which the legal system does not. They can learn about the impact of their actions. In one case, the child actually heard from the person who he had harmed how it had impacted him. And that was very powerful for the child. It also gives them a way to have a say in the outcome plan. And finally, it also involves the family to support them. Because in restorative justice, we believe that they don't just need accountability, but they also need support so that they don't cause the harm again. Just a final note that restorative justice is definitely not mediation. It's very different. There is no fact-finding in restorative justice. And we don't assume that parties on the same level playing field. We assume that there is a responsibility of guilt which has to be discharged. And also forgiveness, reconciliation are not goals of restorative justice. It may happen, but it is definitely not the goal. Just creating space for voice and meeting needs is what we aim for. And restorative justice is also different from counseling. They can go they can go complementary to each other, but they are not the same. And with that, I come to the end of my presentation. I've given our email IDs and our social media pages where you can reach out to us for more information about our programs. Thank you.
Thank you, Aarti, for that wonderful presentation. I would certainly like to connect with you at a later point of time. And it was nice to come to know about the empirical work that you have been doing in the field. We look forward to a continued exchange of ideas in future to come. Thank you very much.
Thank you,
with that,
Thank you.
Still looking at the website and the project report, and I'll definitely be in touch. Thanks.
Thank you.
The next speaker is Ms. Sonal Seth, Restoring Lives of Children Coming in Contact with Crime Victims and Offenders. It is 4:44, 6 minutes to go. So to be precise, 4:50, your time is over, would be over. Please go ahead.
Yeah, Ms. Sheth, if you could please begin. Also mention the name of the co-author that has been missed out in the schedule here. Voice is cracking. Your voice is cracking. Maybe we can come back to your presentation. You can set things up better. Ma'am, we can move to the next presenter.
Okay. Miss Maria.
Sorry, I not.
Hello. Hello, Sonal. I believe you can
Is this
come a little later. Let the next presenter. Sonal, I would advise you to wait for a while. Let the next speaker deliver the address. Deal with the paper. Thereafter, you can take up. In the meanwhile, you can get adjustments done. Okay, please, Mariam, go ahead. Your paper, title, your introduction, everything. Yeah.
Good evening, everyone. I am Mariam Khan, and I'm pursuing my LLM in criminal law from Jamia Millia Islamia University. And
Mariam, go ahead.
The title of my paper is Restorative Justice. Is India undermining a potential panacea for victims' rights? So during the course of the presentation, I'll be briefly touching upon as to what is the underlying concept and theoretical framework of restorative justice. What has been the historical background of evolution of restorative justice? What is the current state of criminal justice system in India? How we are supporting retributive form of justice instead of restorative justice, and why do we need to have a paradigm shift towards restorative justice now, and what are the hurdles in the course of the process. So restorative justice basically is a concept, is a theoretical framework wherein the definition of crime is broadened. It does not merely see crime as an offense or as an act by a person which has been penalized by a statute. Rather, restorative justice sees a crime as more than just an offense which has been penalized. It sees crime as an act by which relationships have been severed, and which the ultimate aim of which is not merely punishment, but rather than meeting the immediate needs of the victim and his or her family, or all those who are dependent on him. So what has been the evolution of restorative justice? Simply to say restorative justice is very nascent form in the criminal justice system. It began being practiced by social workers and human rights advocates and activists way before it was conceptualized. So it was during the 1970s victims' right movement when restorative justice gained popularity. And the very famous Kitchener experiment of 1975 has been recorded as the first incident wherein an offender was confronted by the victim and his family directly, and which marks the beginning of the concept of restorative justice. So if I talk about the basic tenets of restorative justice, it would basically be a restoration and giving the center stage to main stakeholders, which are the offender and the victim and his immediate family and all those who have suffered. It includes restitution. It includes centralization of community. The entire justice process is convened by the community itself, and it reduces and minimizes the role of the judiciary and other elements like that. And the parties, as I already mentioned, are the main stakeholders themselves. So if I talk about restorative justice and retributive justice, so the basic myth that needs to be busted is that both of them are opposite of each other. It is not the truth. Restorative justice and retributive justice can be termed as being complementary to each other rather than being opposites of each other, because eventually if we see the eventual end that sought to be met by restorative as well as retributive justice is justice being delivered to the victim and his family. So if we talk about Indian criminal justice system, which is the basic core of my paper, because my paper is India undermining the concept of restorative justice. So if I talk about Indian criminal justice specifically, we follow an adversarial model wherein the judge acts as a neutral umpire, except for very few incidents as in section 167 of Indian Evidence Act, where a judge can put questions. Other than those very few instances, the judge mostly acts as a neutral umpire. And the degree of proof is beyond reasonable doubt. For a person to be convicted, the prosecution has to establish the guilt of the offender beyond reasonable doubt for him to be punished. So this provides basically the entire Indian criminal justice system. It can be easily said that it is centric around accused right and protections to accused. And in this race, in this course of transactions, victims are mostly left behind. Their rights are mostly ignored, because we are majorly focused upon granting accused their due rights. The Malimat Committee report also mentioned it in 2003. The report was submitted, and the report clearly stated that the neutrality of the umpire, the neutrality of the judge mostly results in injustice to the victim. It does not provide protection to only to the accused, but this neutrality in some cases, rather in most cases, result in wrongs against the victims as well. So we follow the adversarial system, and the rights of the criminals are only mostly kept in mind. So if I talk about, but there is a ray of hope as plea bargaining, concept of plea bargaining, compensation, victim compensation schemes have been incorporated. So it will be safe to say that we are seeing a gradual shift, a gradual transition from retributive justice to restorative justice. So, in most of the cases as well, the concept of restorative justice, if we talk about Indian justice system specifically, is not very new to it. If we go through Arthashastra, Kautilya's Arthashastra, and if we go through ancient legal system as it existed in the country back then, the concept of taking into account the guilt of the offender and the intentional part of the offender, if he was
Time's up, Mariam. Time's
Okay,
up.
so okay, sir. I'll very briefly just enumerate what are the advantages of moving on to the restorative system, and why
Mariam,
India
I
should.
would have a specific question. Your
Yes,
title
ma'am.
is Undermining a Potential Panacea for Victims' Rights.
Yes,
On
ma'am.
what basis are you suggesting that the Indian legal framework is undermining the potential of RJ system?
Ma'am, I intend to say that restorative justice system can be a very potential solution to victims' needs. That if we implement this system of justice, we can actually meet the as a crime is committed against a person. It is not merely about the physical injury that has been implemented to it. It is also about the psychological harm that has been done to the victim. In the present justice system which exists, victim suffers duality of sufferings. One is at the hand of the offender, and the second is at the hand of the system. Because the justice is not instantly delivered, and it takes a longer period of time. So what I'm suggesting is amalgamation of the two systems of justice can maybe provide a better healing to the victim, as well as as well as ensuring that timely justice is delivered, and his psychological as well as other materialistic needs that may be there can be met.
Okay, thank you, Mariam. My observation would be that instead, then you need to somewhere reframe the title. So it cannot be undermining, because what you are suggesting is that plea bargain, you have informed plea bargain and compensation have already been incorporated in the legislation. So if the two components of RJ are already there, how do we say we are undermining? Theoretically, we cannot. Secondly,
Ma'am, if
yeah, please.
If allowed, I'd like to put a point forward. We
Let
have
me
already
first complete my question.
Yes, sure, ma'am.
And
Sure, ma'am.
then you can address that. Secondly, when we are talking on the lines of restorative justice, and we are saying that historically this happened, what are the other ways that you are suggesting over and above plea bargaining and compensation that would certainly give your paper a boost? Okay, please respond.
Ma'am, with regard as the plea bargaining concept is concerned, we have very rightly incorporated the concept of plea bargaining in CRPC, but in the practical scenario, it has not been implemented as much as it could have been, because it ensures 100% conviction, and it is failure on the part of the judges, of the advocates, of the counsels as well, that they are not convincing the offender that much, so it has not been implemented properly.
We are not on to the implementation part. We are just thinking on the theoretical line that when we are talking about restorative justice, what are the strategies and mechanisms which could have been possibly roped in, which have not been. That is where you say that we are undermining a potential for panacea for victims of crime. Certainly, you need to rethink on those lines. And with that, I believe you have made a right beginning, and there is a way to go. Thank you.
Thank you, ma'am. Thank you, ma'am.
Thank you, Mariam. Ma'am, if you permit, maybe go back to Ms. Sonal's presentation.
Yeah. Sonal needs to present. Sonal, it is 4:55. So we have already lost a minute. So by 5, you need to wind up. You're welcome. there's still some problem, maybe bandwidth issue.
Ms. Sonal, you can speak without making presentation of slides. That might work. Please try it. Stop sharing.
Sure. I just and then so very much for the opportunity. Is titled Restoring Lives of Children Coming in Contact with Crime, Victims and we have to begin with this, which itself for me is the context of restoration when we talk about children. It is not also crime, psychosocial, which and communication social and public policy. This paper is not and looking gaps and if I'll restorative last year does restorative is
We have lost the yeah.
extremely sorry. I just to know, is this any better?
Slightly better. Give it one try.
To just briefly leave where I start where I left. My paper is basically around looking at is the existing of meeting psychosocial care of children who are entering, coming in touch with crime, be it as victims or offenders. And further, what are the gaps in the existing system and how does restorative justice help us address these gaps? So, to cover two major acts deal with children, and Juvenile Justice Act 2000, Care and Protection Act 2015. Now there are several what we may term as child-friendly provisions already, which is, say, for example, the special courts are to complete the trial within a period of 1 year. The name of the child is punishable offense. The institutional mechanisms like Child Welfare Committee and Juvenile Justice Board, which determine in cases when a child enters as a victim or an offender whether the child requires counseling kind of care or the child needs to be placed in a home. So the stance of the legal architecture, there are debates around 16 to 18 years of juvenile being tried as an adult. One also sees that there is a large child-friendly stance that we have. Now, in spite of what are the gaps that are to be seen in existing framework. Some is that and
Sonal, can you please conclude by giving us two concluding remarks? When you're talking about gaps between the criminal justice system and the implementation thereof, or the victims as such, what are the two major points that you would like to highlight?
Ma'am, respective ma'am, we can move to the next presenter.
Yeah.
I think Sonal, please stop, and we will come back to you at the end if it is connecting well. The bandwidth is good. Ma'am.
Thank you, Sonal, for that presentation despite hiccups. We would certainly love to read what you are saying as far as the concluding remarks are concerned. Next round is next is Miss Anushka Chaturvedi, Mr. Mohammad Rameez, and Mr. Shishir Yadav. Juvenile justice system, understanding psycho-legal factors and suggesting the road ahead. So, please take note of the timeline. 5 minutes to say the least.
Good evening, everyone. I am Shishir Yadav. Today, I am going to present my paper titled Juvenile Justice System, Understanding Psychological Factors and Suggesting the Road Ahead, which I co-authored with Anushka Chaturvedi and Mohammad Rameez Raza. This paper traces the evolution of the existing international and Indian juvenile justice system, acknowledges the goods in the present system, and at the same time criticizes the wrong in the Juvenile Justice System. Justice Act 2015. Also, in the end, suggest the changes to be made for a better juvenile justice system for the overall psychosocial development of a child within the legal framework. In the 20th century, popular reformist governments had their focus on acknowledgement of the legitimate spot of the child in the culture.
May I interrupt you at this very moment? We would love to hear, instead of historical background which has been talked about over a period of time today, since morning, can you give us something, if you had been participating, as to what is different in your paper as far as the historical perspective is concerned? And please come over straight to the Indian scenario so that we get to learn and hear what are the important segments of your paper and then the way forward.
Okay. The Juvenile Justice Act 2005 was highly criticized for various factors as it rigged the juvenile justice system and undermined the psychological factors related to a child. When the act said juveniles can be tried as an adult if they committed the wrongful act as an adult. Adolescents can neither be considered as the children nor can they be considered within the definition of adult as all these categories have their own distinctive development needs and wants. Adolescence is a period distinct from other life periods in the life of the human being, in which very drastic changes occur in the psychology, physiology, and social psychology. These occurs the process of synaptic pruning and myelination in the brain, which help in the biological maturity as well as the psychosocial maturity of the individual. Therefore, there is need to move forward from the binary to the triple or three-stage classification, which takes care of the needs and wants of the each development stage of human being, as this will help in proper understanding of the problems and the needs of the adolescents, which will be beneficial for dealing with problem of juvenile justice. Our paper therefore proposed restorative justice as an alternative solution in which the juvenile justice system should consider the psycho-legal factors while dealing with the child, which does good for both for the system and the child. Thank you.
Thank you, Shishir. If I might ask you, can you just give us some points on the basis of which psychoanalytical tools can be used and which are not being used with reference to juvenile justice?
Every time certain psychological factors have their presence and are likely to impair the judgment of the adolescent, due to which they take the way for crime, we need to understand that to ensure that they have the path they to good end and need to lead the life other way.
Okay. So when we are talking about understanding psycho-legal factors and suggesting the road ahead, psycho-legal factors have, we do understand and appreciate that you have made a point that there are, this is a specific stage in an in anybody's life, which is adolescence, which is different from the childhood and also an adulthood. So that there are psychological, emotional aspects which are influencing in identifying one's own integrity, individuality, etc. I would suggest that please read and review in the light of what are the additional strategies over and above the counseling or psychological support, on the basis of which we can say that juvenile justice would be better implemented and would have a better efficacious thought process. Thank you very much. Dr. Amit, if you wish to add on in the alternative.
Thank you, Shishir. Thank you, ma'am. Shishir, want a better justification for your overemphasis on the psychological and the social.
Okay, thank you, ma'am. Thank you, sir. We will try to incorporate your suggestions in our draft.
Please include that justification in your paper, because
yes,
it's
sir.
a vexed question, nature versus nurture, and the debate is not settled.
Yes, we will incorporate in our draft.
Right?
Yes.
Next speaker.
So let's not make it a fashionable thing to overemphasize the social context.
Yes, sir. Yes.
Right?
Right, sir.
Even if that is to be overemphasized, the justification is required in the paper.
Yes, sir. Thank you, sir.
I hope I'm correct in saying that, ma'am.
Yeah. We need to balance it. That's how I understand that a student who is writing something is to be encouraged and the right direction is to be given. And I really appreciate your comment that overemphasis is not to be given specific point without a justification. And if you are emphasizing something, there should be strong justification as to why you are saying so. May I request everybody else who is not speaking to please mute your mics. Next speaker is Mr. Charan Tej and Ms. Snigdha Singh on acid attacks. I would want to know what is your content.
I would request my friend Mr. Akash Sharma to please mute his mic. Sir, if you could please mute your mic. Yeah.
Snigdha.
Good afternoon, everyone. I would request the organizers if they could make the presenter, my co-panelist is the presenter. We have a PPT which we would want to kind of deal with.
Yeah, permission.
Sir, I would request you to make Charan the presenter.
Charan, all right. You begin with the presentation.
All right. So with the permission,
please introduce yourself and your topic.
All right. Good afternoon, everyone. I trust everybody is well. I am Charan, assistant professor at the Science University, and the topic that we have chosen today is exploring the scope of restorative justice in reference to acid attack victims. But now, without further ado, I will come directly to the topic. Our criminal justice system is largely focused on the offender. It views crimes as wrongs against the state, where offences are violations of rules prescribed by the state. Punishment is the standard response to the crime, but punishment to the offender does not necessarily translate into justice to the victim. Justice lies in undoing the harm, repairing the loss, making the victims regain their lost sense of security, and imparting a closure to the unfortunate event. The focus of restorative justice is on healing. The basic tenet of restorative justice is to adopt a restorative approach by attempting to find out what happened. Next is to find out what needs to be done to undo the resultant damage. In doing so, they repair the harm, restore the human worth and dignity, reconcile with the accused and the victim, and reintegrate the offender and the victim with the mainstream society. So restorative justice involves the families of the victims as well as the offenders in an attempt to create an atmosphere where the offender can be accepted back in the society. Now, it's a very complicated situation because of the topic that we have chosen. Because justice is an abstract concept and it can truly be said to be done when it addresses all the aspects of damage and case of any crime. Our paper explores the possibility of exploring the scope of restorative justice in reference to acid attack victims. Now, though the acid attack is a crime which can be committed against man and woman, it has specific gender dimension in India.
Snigdha, if a few slides could be presented by Mr. Charan. He hasn't started with the presentation yet.
All right, so I will share the presentation then in that case.
All right, just run us through the slides.
All right. Is this slide visible, yes, sir?
Yeah.
It is visible.
The first slide basically deals with the observation of the Law Commission. The 226 report of the Law Commission of India dealt particularly with this offense and stated that though the acid attack is a crime which can be committed against any man or woman, it has a specific gender dimension in India. Most of the reported acid attacks have been committed on women, particularly young women, or rejecting suitors for rejecting proposals of marriage, etc. And the attackers cannot bear the fact that they have been rejected and seek to destroy the body of the woman who has dared to stand up against him. In most of the cases, what is seen is that the aggressor is conscious that the self-worth and self-esteem of a woman often lies in her face, which is a part of her personality. The dismemberment of the face or the body is not merely an offense against the human body, but causes permanent psychological damage to the victim. It affects the victim's right to live with dignity, which survives the crime. The gender specificity and discriminatory nature of this offense does not and should not allow us to ignore the offense as any other crime against women. So IPC, which deals with the substantive provisions in relation to criminal law, before the amendment of 2013, did not provide for a specific sort of section which dealt with specific cases of acid attack. It basically came under, it was punishable under section 320, which dealt with grievous hurt.
Snigdha, because of time constraint, I would advise you to please come over to the restorative aspect in connection with acid attack victims.
All right, ma'am. So the point that I'm trying to draw is before the 2013, because we are looking at specific angle of very specific different kinds of case, where the immediate concern of the victim is basically to get the finances to restore the damage as soon as possible. Because these kinds of crimes, the primary, I think the first step, the first initiative, which really works in the interest of the victim, is to undo the damage. And first few hours are very, very critical. And therefore, the compensation, the monetary support becomes very, very essential. Another kind of aspect, what we are trying to say is there are different dimensions to this particular crime. There is economic aspect, there is physical restoration, there is psychological impact, there is social impact. And if we are talking about restorative justice, we have to be addressing all these particular components. So initially, before the 2013 amendment, we didn't have a specific crime. With the recommendation of Justice Verma Committee report and the Law Commission coming into picture, they specifically categorized with their efforts and with judicial initiatives like Lakshmi versus Union of India. We have now a specific, sections dealing with acid attack, where the minimum punishment is 10 years, which can be extended up to life imprisonment, with a specific emphasis on the compensation which is appropriate to the medical expenses which the victims incur. Two, there are other provisions in place. For example, earlier 357A provided for victim compensation scheme, but there are specific introductions in terms of section 357C of CRPC, which deals with treatment of victims. So what we have seen that, there has been an attempt to kind of approach to restorative justice with the legislative tool by providing such kind of provisions which mandates an obligation on the hospitals and other stakeholders to provide immediate help and relief to the victims of such a crime.
Time's up, ma'am, for this session.
Yes, so I'll just take 10 more seconds. So what the point that
for those 10 seconds, I have a question, Snigdha.
Yes, ma'am.
The question is that you are talking about compensation. You did talk about economic aspect and financial constraints, etc., etc. And you did say that after acid attack, the initial 3-4 hours are really crucial.
Yes.
I would think differently along with you in the sense that compensation is already incorporated.
Yes,
we do have the relevant provisions also in IPC, and then we have got CRPC also, wherein we are talking not only 357, 357A, B, etc., etc. That being so, implementation is one aspect. But I would certainly wish you to think on the lines that if those initial 3-4 hours are crucial, what is the kind of support they need? So that when we are talking about restorative justice, we are really on the right track, so that the compensation would arrive later on, say after years together, if the complaint is lodged, if the trial begins, etc., etc. Even though there is interim compensation, it would be taking to say minimum a couple of months. So at that point of time, when we are saying that initial phase wherein medical assistance is to be provided, counseling is to be provided, family support has to be there, at that point of time, what are the strategies that can be thought about with reference to acid attack victims, whether they are women or men equally? I would really wish you to think on those lines, along with, of course, the compensation and victim impact statement, etc., etc.
Thank you, ma'am, for your feedback, ma'am, which is basically, partially we have tried to address the concern by providing is one of the pointers here in the last slide. I didn't really have time to deal with it. We wanted to emphasize on a need for a change in the social outlook towards women to begin with, and two, a single immediate accessible window for interim compensation, which can be used for the immediate, benefit of the, because there is a role that is played by the State Legal Service Authority and the courts time and again once the complaint is lodged and the crime is proved. But I do understand in the interim process, because of the various corrective surgeries and the immediate treatment, money in the form of lakhs and lakhs of rupees are incurred by the family members. And therefore, the role of the legal service, State Legal Service Authority comes into picture. So we do have provision in place.
You are still missing the point that I was trying to highlight, and that is over and above compensation, monetary relief, assistance, etc., etc. We need to think on the lines of that single window, which would be providing medical help, psychological counseling, and family support. Because invariably in such situations, we find that the family breaks down. Somebody has to be there to put them together and encourage them, and then bring it across, the victim to be brought across to the institution for some medical help and assistance. So what I was suggesting is that when you are talking about a single window for compensation, don't think only on the lines of compensation and monetary assistance, which is already incorporated. Implementation certainly is an issue, and we need to talk about that. But at the same time, when you are saying holistic, then beyond Lakshmi, you have got Parivartan's case of 2016 as well, wherein they said not 3 lakhs only, depending upon the number of surgeries that a person has to undergo and the quantum of money that has been spent. We need to take that into account. So I would wish you to think on those lines also, along with compensation and victim impact assessment.
Sure, ma'am. Thank you. We'll incorporate the changes, ma'am.
Okay. Thank you. Dr. Amit, if I have your permission.
Just that, Snigdha, a very commonplace critique of the idea of restorative justice is that it's inapplicable to cases of brutal or serious. So how do you respond to that criticism? It's something your paper must try to address.
Yes, ma'am. But there are two takes. Like I mentioned before, now we have a provision which says that which mandates the hospitals, etc., as soon as the victims approach, You have to kind of give immediate free service to those victims because the first few hours
No,
are
I'm hinting at the inverse relationship that the force of restorative justice has in relation to the severity of the harm caused.
So the point that we were trying to emphasize is that as far as the physical component and the economic component is concerned, obviously I agree with you that there are certain crimes for which restorative justice does not make sense, because you cannot really put the victim back to the position. The pace is not the same, the impact is not the same. You don't go back to, you don't get a job easily.
I understand. I merely wish to suggest that you place the pay somewhere.
All right. Thank you so much, sir, for your feedback.
Okay.
Incorporate the change.
Thank you.
Thank you.
The next speaker is Dr. Gijresh Shukla. Hate crimes in India, the roadblocks in restorative justice. And over to you, Dr. Gijresh. But
thank you.
But I am begging your support. Please note my words, begging your support. Respect the timeline, and I'm just giving you 2 minutes.
Finish.
You are asking from Chanchal that you need to snatch away 2 minutes. I'm not snatching any time, but I would want you to be within the time limit. Despite saying that snatching time, you gave them more than abundant time. Okay.
Yeah, sure, ma'am.
Yeah,
I'll
please.
finish my concept paper well within the time, rather in advance. My paper theme basically the hate crimes in India, the roadblocks in restorative justice. The paper is basically conceptualizing the idea based on the very definition of definition of restorative justice. Restorative justice basically demands the conciliation between the offender and the victim. This is restorative justice with what benefit restorative. The very interesting idea of how hate crime is actually an area where restorative justice in principle can play a very huge role, but in practical sense, in practice, it is rather becoming very tough and somewhere you can say overlooked area, somewhere a lot of problems are coming in the way. We can see a lot of riots happen in the past, very recent in Delhi, and then the Hathras case, which is also one of the case which can be very easily could be grouped as a crime, which is might not be out of hatred, but yes, once the community things comes into, once the caste things comes into, it takes the nature of that hatred. So this paper is basically talking about that there are 5 reasons which I have counted in my paper. There are 5 reasons which are responsible somewhere for non-implementation of restorative justice model, whatever little model we have as of now in our criminal justice system, non-implementation of that restorative justice in criminal in cases relating to hate crime. So I will count all those 5, and rest of the things would be for this paper to look into and find out things. So I'll count what are the reasons. And I believe that hate crime is understood by all. And just one liner, that hate crime is basically an act of causing some injury out of prejudice, and the prejudice out of somebody's perceived identity. The perceived identity may be about the caste, maybe religion, maybe region, maybe sex, maybe anything else. So when we commit an offense because of somebody's perceived identity, when the victim is victimized because of his or her identity, then that is called as a hate crime. So what are those 5 roadblocks? What are those 5 things which I have somewhere narrated? Crime is different in nature and impact. The very motive behind hate crime is to hurt the victim due to his or her perceived identity, about the religion, caste, or ethnic. It is because of this reason the possibility of reconciliation between the offender and victim becomes somewhere not possible even. Because when 2 people fight together because of some other reason, not about the identity, then possibility of reconciliation maybe because of
whatever loss is there in terms of economics, you can just recompensate and things over. If there is some other kind of grudge, some other kind of enmity, you can reconciliate. But if I have an enmity with somebody because his or her identity, then obviously it is very tough to reconciliate because I'm not ready to reconciliate. The second one, roadblock which I see, the deep-rooted prejudice harbored by the offender against their victim. This deep-rooted prejudice I'm talking about is not kind of one incident. It is a generational prejudice which is often harbored by the offenders against their victim. So I identify myself as a part of one religion. So my religion has a history, and this religious history is so much, enemical to other religion, to other caste, to other kind of region, that because of that reason, again, reconciliation becomes next to impossible. The third block, which I see as a student of criminology, the third roadblock, the very nature of hate crime, what nature of hate crime invariably affect the psychology of police and judicial administration, and thus the efforts from the state agencies are often colored with bias. Now, this is the most important thing which I have received in practice in my own life, that during elections, forget about the kind of messages received from some unknown person. Even the senior police officers, bureaucrats, politicians, they circulate messages somewhere sending a very clear and categorical idea that what to do, what not to do, whom to vote, whom not to vote. Based on that data, I can simply say that the bias is so much reflected in these communities, in this caste, in these religious identities, that whenever they occupy any administrative post, whenever they occupy any police post, whenever they occupy, I'm sorry to say, even judicial post, the possibility of reconciliation. I'm just putting an example, ma'am. Probably, as I know you are one of the legend in criminal law. I have seen people as a police officer, while working as a police officer, while working as a prosecution, while working as a judicial magistrate or judges, they're so much perceived by their own identities, their own ideologies, religious or otherwise, that they do not enter into any reconciliation process, even at the level of plea bargaining. Before I go to the fourth point, I can just give you one example. While this particular session was going on, I was going on for a while. I just opened my Twitter account, and there was a news from UP. A police officer was suspended because he was having dadi. He was having a beard, certain, and he was issued a notice why you have not cut your this beard, and he didn't reply, and because of that reason he was suspended. I checked the detailed profile, and something which was obvious there, something the religious identity. You can have a beard and become a prime minister, but you cannot have a beard and then become a police officer. So if the prejudice is of such a nature, then in that case, talking about restorative justice in terms of the criminal justice system, somewhere I feel like a biggest roadblock. Because of all these reasons, they do not engage into any type of real, what I should say, real and effective reconciliation or conciliation process. Another point which I see, that because of religious and caste related identities or hatred, the parties themselves do not engage into. The engaging of parties in reconciliation in case of once the offense happened is important one. But because of these perceived identities, the party themselves get separated, disengaged, and because of that reason, the actual idea of restorative justice, the actual idea of confrontation. Somebody has presented a beautiful paper on confrontation, that you confront, the offender must confront the victim. Now here the possibility of confrontation might result into something different. So that is another thing. The last but not the least, the present administration, be it police administration, be it criminal justice administration, works on a presupposition. The presupposition is that rule of law is there. As a matter of fact, as what I have perceived, as a matter of fact, is not rule of law, it is a majoritarian model. So rule of law gets changed, gets redefined the moment we apply the principles of majoritarian. So on these five, theoretical understanding, I believe that restorative justice need to be re-examined and somewhere remodeled for the purpose of criminal justice system. So this is what precisely I have somewhere narrated in my paper. Thank you, ma'am, for giving me this opportunity for presenting the idea, whatever I have, and I really look forward for comment from you.
Thank you, Girjesh, for that precise bullet points on 5 points with reference to the stumbling blocks in delivering maybe restorative justice in hate crimes. Couple of points. When you're talking about hate crimes, and we do understand that it is primarily because of perceived identity. In this perceived identity, necessarily the biases do creep up. The prejudices do come in. I'll just put all these 5 points together because somewhere I find that they are all interlinked. When we are talking about perceived identity, and because of that identity, there is animosity. So the possibility of reconciliation is almost minimal. So what I would think as a person arguing for restorative justice is to have those agencies and institutions in place who are trained enough to ensure that the parties do come on the table, for which there is the need of having not only budgetary allocation, but budgetary allocation with a view to have the infrastructural support in the sense of human personnel who are committed, who are genuine, who are willing to apply this reconciliatory processes. And when we are talking about certainly, I would not talk about on this forum the religious identities or communal identities, but I would certainly take up the hate crimes as a class in unto itself, and I would want you to think on the strategies that can be applied to undo and remove these roadblocks. So when you are saying that the third point, that there is agency bias, state agencies are flaunting their identity, their values, their principles, or they are openly known, or for that matter, they are circulating in the social media that whom to vote and whom not to vote. I believe there has to be a strong message from the authorities that this is something which is not permissible, that having a public office, if you are conducting yourself like this, you are not a good person to be kept as a public official regulating public spaces. So there should be some stern message and an action taken against them. That's how perhaps people would have an objectivity. And when you are talking about the rule of law as not the rule of law, but majoritarianism, I believe the moment you take care of this very third point, naturally, eventually, the rule of law would be there. And our individual biases, that when we are talking about, say, for example, I did hear a couple of times Hathras within this session. I'm afraid I didn't hear anything with reference to other places also, which are equally brutal, nasty, heinous, grievous. So it's all about narrative being created. So should, as academicians, be not our role to balance out everything and to think that where the work has not been done. So these are the roadblocks. I would wish Girjesh to come up with alternative solutions. That what are the possibilities, because you have done a research on hate crimes, and what are the reasons because of which these prejudices get created. So the moment we get to these whys, we would certainly have an answer with reference to what next.
In my full paper, I have made this as well. Obviously, it will be the part of the publication. Dr. Chanchal would be more than happy to see that. Yeah.
Okay. Dr. Amit, the floor is
Thank you, Girjesh, for those 5 bulleted, concise points on the roadblock to achieving restorative justice. It's probably not related to what you are thinking about at the moment, but the raging controversy, raging debate about nepotism, Sushant's case in Bollywood, Kangana not saying things. So would you also like to encompass such cases where personal identity is a very important factor in determining life chances of individuals?
Since my paper, Amit, is limited, those identities result into hatred. So I have not included that. But yes, there are many cases where identities become the focal point rather than doing justice with individual. So that point is there, but I have not included that.
All right. Okay. Thank you so much.
Okay. Thank you, Rajesh. And I look forward to the refined and published article.
Thank you, ma'am. Thank you. Sure, ma'am. It will be made available.
Okay. Thank you. The next speaker for the session is Dr. Lalli, Restorative Justice and Hate Crimes Against Women in India, an overview. Dr. Prerna, it is 5:36, and to be precise, 5:41 is the outer limit.
Yes.
Please go ahead. And I would again request and suggest that whatever has already been discussed, you can just touch sketchily and come over to the main argument of your paper.
Yeah. Thank you. So thank you, Chair and the co-chair. I'm indeed proud to present.
Dr. Prema,
Yeah,
may I also
just
request you to announce the names of the co-authors?
Yes, Professor. My co-author will be Dr. P.R. Rajavenkatesan and Dr. V. Shyam Sundar, and I'll be presenting on behalf of them. Of course, my co-author, Dr. Rajavenkatesan, is also there. So thank you, Chair. And actually, in my abstract itself, I have said that it have to be dealt with socio-legal aspects when it comes to the hate crimes against women. And especially I have discussed when it is going to be a lower caste women concern is how hate crimes is going to impact upon her. And I have also, it's not that I have heard something in the, news channels or in the newspaper. Of course, my co-author, he himself staying in a particular region where this particular incidents have happened, where the hate crimes is more in practice. As we always say, when it is going to be restorative justice comes.
Can you please, Dr. Prerna, can you please let us know your institutional affiliation and your author is resident of which particular area?
So I'm from VIT School of Law, Chennai, and my co-author is also working there, and he's the HOD of BA LLB program. And his region is actually his native is from Kadlur district.
Okay, thank you.
Yes, madam. So as I just made a point about this because it is the ground reality which we have seen where the hate crimes nearly, were very near to the victims. So that was one reason where I just wanted to highlight how restorative justice have to protect the women concern is when it comes to the victim perspective is. And as the international initiatives, I have just discussed SDG 16, which states equal justice to all, and SDG, the Sustainable Development Goal 5, which talks about equality and empowerment of women. So these two concepts have to be applied when it comes to the restorative justice concern, where you are going to look upon the victim perspective concerns. Because I just want to tell one incident where I was beginning, the suggestions were given, awareness have to be given, how it is going to be education which will help restorative justice to be very successful. So the very recent incident, it was 2 weeks before, which happened in Tamil Nadu, the districts which I was mentioning, where this particular panchayat vice president, the president was she belongs to a lower caste, and she was made to sit down in the floor, and the vice president and the other members were sitting on the chair, right? Because the practice, the very practice, how the lower caste people were treated, even the political position was given to a woman who belongs to a lower caste, right? So how this impact of the treating of people when it is going to be the caste based. Of course, I have also mentioned how hate crimes against women has played a big role even in the countries like UK. It is a very big data which they have given based on color and also gender. Hate crimes have been increasing, and the concept of how it is going to decrease, of course, when the restorative justice comes into picture here, the concept of SDG goal 5 have to be taken into consideration, because when it is going to be specifically caste related, the empowerment, because the women are shunned. They could not survive in the society. Even compensation is going to be paid, or the offender is going to be punished, whatever it may be. When they are going to come into a particular society, the only the empowerment, how the restorative justice have to include them, and the inclusiveness in the activities where it will empower her will be helpful, right? So I'll just have to mention one more thing, where it is not only the lower caste or the upper caste. We have heard about the self-respect marriage. It happens in the districts of, in the places of South India, especially Tamil Nadu. The self-respect marriage concern is, we also have a legislation for that, where people don't believe in any kind of caste and they get married, right? So here it also has some reverse, where it was not successful as a restorative measure, where we are not going to believe in caste system, but involving in such kind of family togetherness, which had reverted, right? So one incident where it was a real case, Kausalya, she was married to a lower caste man, and she belonged to a upper caste women. I mean, she belongs to that upper caste.
Dr. Prema, you need to conclude.
Yes, madam.
After the minute, you need to conclude.
Yeah, yes, madam. So I just had highlighted where this legislations like the SC/ST Atrocities Prevention of Atrocity Act or the IPC is not really helpful. And of course, restorative justice is a boon for the criminal justice system, and more programs which is going to concentrate on protecting the women especially have to be brought out. Yes, madam. I have concluded.
Thank you, Dr. Prema. I believe you need to somewhere redo your topic, because if you are suggesting that the practical incidences happen to be from down south, can we say that this is the Indian perspective? Until and unless we have got empirical studies which confirm the same, even from other areas, regions of India. Secondly, when you are suggesting that there is the failure of IPC and SC/ST Act as far as the implementation is concerned, somewhere I would love to hear from you. What are the suggestions to improve implementation part, or in the alternative, when you're thinking on the lines of restorative justice, specifically with reference to offenses against the women in caste-ridden society, how do we in this particular institution of marriage, how do we rope in restorative justice practices?
Yes, madam.
That is the only remark I wish to make. Unless you have got something to respond to with that, I would ask my colleague, Dr. Amit, if he has any question or any observation to make.
Ma'am, we can move to the next presenter. I will request.
Okay.
Thank you.
Okay. The next presenter is Ms. Vidya Ann Jacob. Restorative justice, a new means of achieving climate justice in India. Vidya, are you around?
Yes, ma'am, I'm right here.
Okay.
Good evening.
What I would wish to hear from you, because it is already 5:44. So instead of going into the details of restorative justice, I would certainly like to hear from you the restorative justice in the context of climate justice straight away.
Yes, ma'am, I will surely do that. I would request the organizers to give me the presenter right, if it's okay. Good evening, respected chair, co-chair, and the panel and the participants who are present here. This particular research that I've done is an attempt to go or look at a justice system for climate victims, which is on a surge right now in India. Considering that climate change is, sir, can you please give me the presenter rights?
Chanchal.
If they're not there, then I will proceed with.
Chanchal, she is asking for presentation.
Okay, I think.
Access.
Vidya, you can present now.
Yes, sir. Okay, I think there's some problem with the download version of the presentation. Ma'am, is it okay if I just continue?
Yeah,
I do understand
please
there's
go
not
ahead.
much of time. Okay, considering that
But you
recent,
need to
yes, ma'am.
switch on your camera, please.
Sure, ma'am. I thought because of the bandwidth, I will surely do it right now. Is that fine, ma'am? Are you able to see me?
Thank you.
Okay, okay, ma'am. With regard to the impacts that I was talking about with regard to climate change, recently in 2015, countries came together and signed the Paris Agreement, stating that we will make all sort of measures to reduce any sort of impacts that's going to come with regard to climate impacts. And in that, the preamble specifies that there should be care taken with regard to the vulnerable community. When I say vulnerable community, it is equated to the climate victims. And these are the people who are currently having inequality and injustice which is being rendered. Out of the number of climate injustice done globally, 1/3 of them are from India. One of the recent climate impacts that we had was the Telangana floods in October 2020. We saw many people lose their property, their lives, and also their basic fundamental rights. And why do we look at, or why am I proposing climate justice? Is basically climate justice helps in bringing about equality, human right, and collective rights. And if we look at the recent report which has been given by the Climate Risk Index in 2020, India is ranked number 3 for the adverse impacts of climate change. Now, coming to the climate crimes that we've been facing over time, for example, in the Sundarban Islands, which have already been sunk because of the water level rise, people have been migrating or displaced. Now, they are termed as internally displaced migrants or internally displaced people, which is not being recognized. But majority of them happen to be women and children who are prone to crimes of human rights violations, and nobody is there to address their crisis or their the violations that's happening against them. Now, when I come to restorative justice, as already been spoken at large by the specialists, it involves community victims and offenders. When it comes to climate victims, it is going to bring about climate equity. It is going to ensure that the human right violation is going to be bridged by the perpetrator, which could either be the state or it could be an industry who's caused or who's violated the norms that has been prescribed under the environmental statutes or the constitution itself. Now, if I look at the relation of restorative justice and environmental crimes or climate crimes, we can see that New Zealand is one of the leading global leaders in restorative justice and environmental harm. And as of now, they have about 33. So they had an act called the Restorative Justice Act in 2002, which they passed, where as of now, there are 33 environmental crimes which has been resorted. And what they found out was that because of the restorative approach used in environmental crimes, which includes climate crimes, they found out that indigenous communities, vulnerable communities could include even disabled people. Disabled people again could include transgender people. It could be anyone who can't voice their opinion. They have been in a better position to come back to the society and also bring back the loss that is caused to them. Now, coming from an Indian perspective, I do understand restorative justice is not being used in environmental crimes or even environmental violation, because we look at more of a deterrent form of punishment here. But I think, through the research that I could conclude, was that restorative justice can be a means to render climate justice in this global era where anthropogenic activities are causing adverse impact. Further, I do understand that restorative justice might not be the end in all for all our climate victims, but it could be one of the means through which climate justice can be achieved. Thank you. I will give the floor to the chair. Ma'am, I can't hear. Yeah.
Thank you, Vidya.
Thank you, sir.
Over to you, ma'am.
Yeah. I'm not on mute, but she is not able to hear me. I do not know why. Why is it that so? Are you able to hear me, Vidya?
Yes, ma'am, I can hear you now.
Good enough. What I am asking you, or maybe observing at this point of time, is that first of all, let me congratulate you that you have taken altogether a different area for analyzing the role of restorative justice. And this is really relevant in today's context, wherein we are generally talking about the general environmental degradation and the resultant impact on humanity. I have just two quick points. One is just a remark that you clubbed disabled along with transgenders. I would have a reservation to that. I would not wish to call transgenders as disabled. They are the other, but they are not the disabled ones. And secondly, when you are thinking on the lines of restorative justice strategies for delivering climate justice, can you just inform us of one or two from maybe New Zealand, which has helped in restoring the climatic equity? Because you said that they are the leaders and they happen to have, in 2002, they have come up with the law and 33 environmental crimes have been resolved. So I would just want to be informed about one or two strategies or mechanisms like we have in criminal justice. Generally, we think on the lines of compensation, etc., etc. With reference to climate justice, what is that the industries who are the pollutant, who are indulging in environmental degradation, or the state agencies who are doing it, or for that matter, private individuals who are doing, what kind of RJs we can visualize? Just sketch me name of one or two.
Ma'am, to answer your first question, the definition of disabled that I took was from the UN Convention on Disability, where they said that any person who is not having a voice, so it is not just physical. That is why I refer to transgender. I'm so sorry if I got it wrong, but that is from where I have taken
Now they have a voice.
Yes, ma'am. Now there is, but that is how I connected to climate victims. With regard to your second question, ma'am, in New Zealand, what has happened is from 2002 till 2020, most of it are environmental crimes which have been addressed. But in Garrett versus Williams, which was a restorative justice successfully with regard to protection of Aborigines people and their cultural habitat. So that there, the state and the industry who had caused displacement of these people were made to come in and help in that particular state. And I feel in India we have a lot of these kind of projects also. For example, thermal power plants which is causing displacement and also resulting in the movement of tribal community who are the keepers of environment, so they know secrets of how to reduce the emission. And when you're going to push them out to a displaced position, there is we are also losing those traditional knowledge. So it's in that context that I have put across this point, ma'am.
Thank you. Wonderful.
Thank you so much.
Have that relation with RJ.
Thank you so much for the opportunity.
Thank you, Vidya. It was nice listening to your paper.
Thank you, sir. Thank you.
I'll read the paper again and get back to you.
Sure, sir. I'll look forward. Thank you, sir. Thank you.
Honorable Chair, we have one request. The next presenter, Mr. Santosh Kumar Sharma, is not available because of some health conditions and unavoidable reasons. So in that case, we can do the next presenter. That is Mr. Dr. Alok.
Otherwise, is okay with Dr. Santosh?
He's okay. He has some problem in his kidney, that is stone problem.
Okay. All right. I was just wondering in this particular context, contemporary one gets panicky. Anyway,
yes.
Over to the next speaker, Dr. Alok Kumar, Justice Through Tribunals and Alternative Argument for Restorative Justice.
Good evening, ma'am. Good evening, everyone. Ma'am, I just what I perceive in my paper while preparing that is still in the nascent stage. That restorative justice, what I perceive is just undoing and repair the harm caused to any person wrongfully. But what I feel, ma'am, that unless it is timely and less expensive, it would not serve the ideas of justice. So the regular court system, what I feel that due to their procedural bounding to the procedural laws and different other mechanism which they are bound to, they are not serving this end, particularly the time and cost effective justice. So tribunal in this way, ma'am, come forward to restore the idea of justice to the person on whom the wrong has been caused and restore the original position by providing in time and cost effective justice. Particularly, ma'am, in this segment, I try to refer one new tribunal in this regard, that is the Maintenance and Welfare of Parent and Senior Citizen Tribunal. This tribunal, ma'am, because the provisions were already existent in CRPC under section 125 to 128, which talk about the maintenance of the parents and the children and women. But senior citizens were also covered under this Act, Maintenance and Welfare of Senior Citizen and Parents Act 2007. So this, despite the provision in the procedural law and the traditional court system, it was not effectively done to the damage which has been caused to the parents and senior citizens. The tribunal is perfectly doing the role in this regard, protecting the rights of the parents and senior citizens. Along with that, ma'am, various tribunal has been established, keeping in mind this theme, the speedy and cost-effective justice. Either it is a National Green Tribunal, as far as India is concerned, a Central Administrative Tribunal for Civil Matters, Armed Forces Tribunal, and various other tribunal, particularly Consumer Tribunal as well, which known as Consumer Forums and Commissions. They try to restore the position of the customers in case of deficiency and defect in goods and efficiency in service. So what I see, ma'am, in future, that the role of tribunal may be more vital while restoring the original position of the sufferers who got some damage and harm wrongfully. This was my suggestion in this topic, ma'am, which I am developing still. Thank you, ma'am.
Couple of points that I wish to make.
Yes, ma'am,
when you're talking about the role of tribunals, justice through tribunals, an alternative argument for restorative justice. Now, is it in the context of specifically criminal law that we are thinking on the lines of tribunals, or we are thinking on the lines of tribunals even with reference to civil matters? You need to focus and find out for yourself as to what is the argument that you are intending to develop. Secondly,
Yes,
we are thinking on the lines of tribunals as an alternative to courts. We do agree that tribunals perhaps are delivering expeditious decisions, but I do not know whether they are delivering justice. As far as consumer courts are concerned, the legal framework, consumer tribunals are concerned, the legal framework does talk about deficiency in service and doing good through compensation, so that you have the component of restorative justice built into the Consumer Protection Act 1986 and then 2019. My observation would be that when we are talking about the usage or creation of tribunals in the place of criminal courts or other courts for expeditious delivery of justice, even if it is justice delivery. Do you think that expeditious delivery of justice amounts to restorative justice? First point of clarity that we need to have, that when we are talking about restorative justice, it is not thinking on the lines of expeditious delivery. It is in fact thinking on the lines of bringing undoing the harm which has been done. So expeditious justice, it's the same argument which is being highlighted with the reference to plea bargaining. We do have plea bargaining, an explicit chapter in CRPC which has got long drawn provisions, but ultimately what we are hearing and getting to know from people in the field, I believe, yes, there are so many people who are from the police background and prison background here attending. that plea bargaining has failed miserably because there is a temptation. There is a temptation to agree for a particular offense in exchange for a lesser penalty. But that is not the essence and focus of plea bargaining. Plea bargaining was that you are voluntarily making somebody to come to terms with the fact, and plea bargaining then has a restorative justice object and it can lead to justice ultimately. But what is happening is plea bargaining instead has boomeranged at the lower level. So my observation here is, and some just thinking aloud with you, because you said that this is still in the nascent stage and you're developing it, whether we can suggest that speedier trial, speedier justice through tribunals would be necessarily a component or can be seen as a restorative justice mechanism. More so because we have got lot many tribunals already existing, and there is a murmur around in the administrative circles that all these tribunals are generally managed. Generally, there are the retired judges who are placed there as chairpersons. And even if there are not the judicial people, there are people from the law background who are there, whether we can do away with the procedural safeguards which are invariably there in the regular criminal justice administration. So these are the points that would want you to take into consideration when you are developing your paper.
Thank you, ma'am, for the suggestion. I will incorporate the things on this line what you have raised in my full paper.
Thank you. Dr. Amit, if you wish
Dr.
to.
Alok, as usual, we have always been having these snippets of conversations around the idea of tribunals and administrative law. Although I am
that is the area of interest.
so I'll talk to you over a cup of tea.
Thank you, Dr. Amit.
And the tea would be on you for sure.
Definitely, of course.
And
Thanks.
do we have the last speaker for the day, Dr. Upneet Lalli, or she would be presenting? She would be there in the plenary section.
I think, ma'am, Dr. Seema would be presenting.
Okay. Okay. Then I call upon Ms. Seema Deswal, along with on behalf of Dr. Upneet Lalli, and if Ms. Paramjit Kaur is also there, for role of restorative justice. Just a second. Role of restorative justice in repairing the harm caused by hate crimes. So it should be somewhere complementary to what Dr. Girjesh was talking about. So over to you, Ms. Seema, and I would suggest and wish we are already beyond the time limit. So please take 5 minutes to be very precise and come up with the crux of your paper.
Yes, ma'am. Very good evening, everyone. It's been pleasure listening to you all of since morning. Everything and most of the part of restorative justice and some part of the hate crimes already have been discussed. So I would like to summarize primarily. I'm Seema Deswal from
Seema, please, can I ask you to speak comparatively nearer to the mic so that we can hear you loud and clear?
I'm audible now,
Yeah.
ma'am?
Thank you.
Okay. I'm Seema Deswal from Institute of Correctional Administration. There are three authors of this paper. I'm presenting on behalf of my supervisor, Dr. Upneet Lalli, and co-author Paramjit Kaur. So in this paper, the aim of the paper is availability of restorative justice and why do we need restorative justice in cases of hate crime. We have, while writing paper, 3 points have been analyzed which focuses on the need of restorative justice. The first point that we have found is restorative hate crimes cause severe long-lasting emotional trauma to the victim and affected community. The second point, hate crimes involves repetitive victimization. And thirdly, there is no particular legislation in India to deal with hate crimes. NCR publishes a report on crime in India annually, but it has no mention of hate crimes category in the annual report of NCR. So based on these factors, we have analyzed there is dire need of restorative justice to reduce the incidences of hate crime and to repair the harm that hate crime caused to the victims and the affected community. Uh, hate crime, however, restoration is possible, though, but it has certain challenges in application of the restorative justice. These challenges may be applicable to the other crimes also, the ordinary crimes. The first challenge has been analyzed. There is no guarantee of honest dialogue from the side of offender. The second apart from honest dialogue, there is no guarantee of the alteration in the mindset of offender that he or she will not commit the offense again after going through the process of RJ. The second challenge has been analyzed on the part of victim and offender both in the participation of RJ practices in our Indian context. And the third challenge is victim may feel apprehensive in encountering the offender at the time of RJ. So we need restorative justice to overcome to reduce the prejudice in the community, and this reduction of prejudice in the community not only reduce the hate crimes, it will affect, it will control the social conflict in all respects and establish social peace in the society. I would like to conclude with what Justice Mohan in the morning panel discussion
Seema,
session.
are you concluding, or Ms. Paramjit Kaur also wants to? Okay, she's also there. She also wants to say something?
Because of, yes, ma'am, because of time paucity, I'm concluding.
Okay.
Ma'am, I will speak just one line in the end. Okay. In India, we need to start considering restorative justice for dealing with social conflicts. Then only we can establish peace and harmony in the society.
Thank you, Seema and Paramjit. What I would certainly want to hear from you in a line or two is that, having identified that these are the impacts of hate crimes on individuals, what is it that you're suggesting on the basis of which we think that this method or this tool or this particular practice, which is restoring in nature, would bring about a change in attitude? Because when Paramjit was saying a one-liner that we need to reduce social conflict, if we have got deep-rooted biases, and that is what Dr. Girjesh also was highlighting, if we have got deep-rooted biases, how do we undo them? It needs a great concerted effort. What is it that you are visualizing, that on the basis of which you are suggesting that even with reference to hate crimes, RJ is possible?
So I would like to answer your question with repeating the lines of Justice Mohan sir, that to get the potential outcome of restorative justice that it can deliver to society, there is need of efforts, resources, and the techniques. Particularly, if you are asking, I can't talk about the techniques. That work would be better conducted by the facilitators, RJ well-trained practitioners. At the theoretical level, I understand that committed effort required to execute the restorative justice. Mere ritualized light practice of RJ cannot give the desired results that RJ can give to the society.
If I might ask you a question, are you doing a research or what?
Yes, ma'am. I'm a research scholar presently at Punjabi Sociology Department and working under Dr. Upneet Lalli as well.
Thank you, Seema, for that information and input, that you are a research scholar. A sincere advice. When you are saying something, it has got an implication and an impact. When I asked you for specific tools or method or strategies or practices, you said that I cannot say what can be the technique, but then you went on to say that we need to have committed facilitators. That is a technique, my dear. Okay. So when you are saying something, be confident in yourself that yes, this is something which we have visualized for the time being, and this is still a path that has to be made. So We need to think on the lines of having a committed facilitator. We need to have other additional resources, facilitators, instructors. And when we are talking about reducing social conflict, somewhere we need to have counselors. So it's all there within your mind, and you have spoken that, but we have in the beginning just put that on the ground, saying that I cannot comment. Okay, yes. Thank you. Thank you. And I believe we'll take note of that in your presentation.
Being naive, I took a precautionary path.
No, but at times this precautionary path can boomerang and it can be fatal.
Yes.
Okay, thank you. Thank you.
Okay, thank you.
Dr. Ahmed, the floor is all yours, or for that matter, the
Thank you, ma'am. This is Chanchal. I would like to thank Honorable Chair, Dr. Anjali Valiteku, ma'am, for such an enlightened session filled with feedback and fruitful comment for our presenters. I would also like to thank Dr. Amit, co-chair of this session, for his early effort to make this session successful. Now I'll speak one or two points about interest of organizers. All participants, the papers presented today, the 28 papers in both the sessions, I would advise to take note of all suggestions that has come, comments from chair given, and incorporate in the paper. We would be sending some draft guidelines how to develop each of these papers so that these papers can be published in the form of a book. That would be a kind of its own first in India on restorative justice by an NLU university. So by Monday, that is 27th, we will be sending some guidelines how to revise. If there is any need of assistance, all participants, all authors can write directly to either Dr. Amit or me. We will be also available for providing literature if available with us, and sharing literature and from other resource persons. Of course, Anju ma'am is there to help us in this endeavor so that we can take this conference or exercise to its logical conclusion, and the real product of any conference or exercise of conference resulting into contribution in the form of some meaningful publication. Thank you, ma'am. Thank you, Dr. Amit. We have plenary session scheduled sharply at 6:30. The same link will continue, and there are legal luminaries from abroad, including Dr. Lisa Rea, Jeffrey Mark Deskovic, Dr. KP Singh. You have already seen the program schedule. So after the short break, the link will continue at the same link. Do not log out. We will continue at 6:30 plenary session. Thank you.
Wait, I have a question. I want.
Please do join us.
I have a question.
Session, I'm sure.
Can anybody hear me?
Yes.
Okay, so my question is that I would like to show a few slides, a few photos which coincide and enhance my presentation, but I'm not sure how I would do that.
Dear Jeffrey, you can share it with us. Either you send it to Amit's email ID, Dr. Amit's email ID, or my email ID, Chanchal's email ID. We will be running your PPT simultaneously when you are present speaking. So that will be a problem, sir.
Sure. Okay. But when I'm ready for the first photo to be shown, I will just verbally indicate that. I'll just say, let me show this slide, and when I'm ready for the next one, I'll say, go to next slide, please.
Or there is another option, Jeffrey. You can present directly from your end. We will make you presenter in the software. You might find it.
Okay. Oh, okay. That's where it says share, right? It
we can work. Whatever is convenient, we will decide accordingly.
All right. So I'm going to just share it myself through the share, or my email. Okay. Very good.
For the safer side, I would suggest you also share the PPT with us. If you are not able to run, we will run as you speak.
Sure, but the main thing though, that's fine. I'll send it to you also as a backup. And honestly, it's less for me to do, so it doesn't matter if you do it. The main point though is that I would like whoever's doing that to wait for my verbal cue to show the picture. I don't want the slides to be running while I'm talking when the portion of my presentation doesn't have anything to do with that photo. That would be distracting
That's right. We will
for the
take care of
audience.
it. That's right.
Okay, very good. Okay, I'll what's your email address also?
I'm just texting it. Amit? Amit, it's Chaturvedi. Jeffrey, have you got the email ID?
Yes, yes, I have it.
hpnlu.ac.in.
I do have it. Thank you very much.
Thank you very much. We will start sharply at 6:30. 18:30.
One last question. I'll let you go. Just I don't want to hold anyone. Just so I guess for people to have participated, they would have registered already, or is there's a link or something, or if somebody that hasn't registered yet would like to watch, is that possible, or it is not?
Yes. Is it very well possible? I'm sharing the link with you, and you can forward it to anyone you want.
Okay, I can post on social media as well. That's okay?
Yes. Sure.
Very good. Thank you.
It's here, Jeffrey. I just shared it.
Okay, very good. I see it. Thank you.
Yeah. Thank you. Okay. So, dear all, we will meet again at 6:30. 18:30 HRS IST.
सर एक बार बच्चों को ग्रुप पे लिंक भेज दीजिए ना। किसी पे भी 2-3 ग्रुप पे भेज दीजिए ना, कुछ तो बच्चे आ जाए। 10 भी आ जाएंगे तो अपना 60 पहुंच जाएगा। बढ़िया है, दिस इज वेरी गुड नंबर। हम भेज देते सर, हम व्हाट्सएप यूज नहीं कर रहे अभी इसीलिए।
This is Lisa Rea of Restorative Justice.
David.
I'm sorry, this is going to present very shortly. I'm on the last second. I'm speaking at a restorative conference in India. I'm doing a virtual justice. The reason I'm calling you is I'm about to send them over my PowerPoint, and I'm really glad I received that. Bottom line is, I need a photo, and I need to actually show it into my slide, and the students.
हेलो चंचल, चंचल जी।
हाँ जी चंचल।
गुड इवनिंग मैम।
हाँ बेटा, you ready for the show?
We are ready. We are ready मैम।
कनेक्ट करके देख लिया जो हमारी है 2 स्पीकर्स बाहर से?
Yeah, they all are connected.
Oh good.
नमस्कार मैम।
जी चलो शुक्र है आप घर तो पहुंचे।
चंचल से परमिशन, स्पेशल परमिशन।
तो आज तो चंचल से ही लेनी थी परमिशन, मैंने कल ही ले ली थी।
जी
ठीक है ना चंचल?
ना यस
दोनों का परमिशन कल दे दी थी चंचल ने।
मैम we have still 3 minutes to go.
नहीं ठीक है।
देवनाथ जी स्क्रीनशॉट रखे हैं ना?
तो भी होगी। जब पार्टिसिपेट करेगी। टेक्निकल सेशन होगा।
Good evening, ma'am.
Must be in high spirit.
Has been a great day, ma'am.
You had a great, I think technical sessions went well.
Very well, ma'am, and it was better than expected received.
Good. Okay.
Tile में now it's done. All are here. I haven't got pictures. You have to open it first, then we will start. Yes. In that case, again भेज दीजिए. I haven't received this document. Right in email. क्योंकि अभी कंप्यूटर पे नहीं है. Chat option.
Okay. Good evening.
Good evening. And Ji, good evening, Ji.
One announcement, our distinguished speaker, Jeffrey, please, we haven't received your PPT. The email ID I sent. Jeffrey, can you hear me? Hello?
Yes, I'm sending right now. I'm sorry.
Okay. We haven't received yet. Noise. Jeffrey's not responding. Jeffrey responds.
Yeah, I just emailed you. Received? Hello.
Yes, we are checking it. Jeffrey, we are checking it. It might take 1 or 2 minutes to receive it. Till then, we can begin the plenary session.
Okay, so I should start. I should present that.
I welcome a very warm good evening to all of you. I welcome all distinguished speakers and participants to the very important, the most important session of this international conference, that is plenary session of this conference. The distinguished speakers in this session are Professor Nishtha Jaswal, Vice Chancellor, Himachal Pradesh National Law University, Lisa Rea, President Restorative Justice International, Jeffrey Mark Deskovic, MAJD, Director, Deskovic Foundation for Justice, Dr. K.P. Singh former Director General of Police, Haryana, Dr. Upneet Lalli, Deputy Director, Institute of Correctional Administration, Chandigarh. I welcome all distinguished guests. Without taking further time, I will invite Professor Anishtha Jaswal to speak in the session. Over to you, ma'am.
Thank you, Mr. Chanchal. I'm going to speak from where I left in the morning because we are very short of time. A very, very important issue of restorative justice, which means restoring justice. Restoring justice to whom? To the victim. It's not merely the victim because the offense, the crime is committed against the state. The state which is responsible for law and order. So this is restoring justice to the state also as well as to the community. The premise of justice system changed from punishment to restorative justice, traveling from civil liability of damages and compensation, passing through exemplary cost and compensation, crossing the threshold of criminal liability, ultimately falls in the lap of the victim. It's not something very new. Of course, it has taken its wings after 1990. If we turn back the pages of history, we find in Israel, there was restitution for property crimes. In Sumeria, the Code of Namu in 2060 BC required restitution for offenses of violence. In Babylon, the Code of Hammurabi prescribes restitution as a sanction for property offenses. In Rome, the 12 tables, that is in 449 BC, ordered convicted thieves to pay double the value of stolen goods. Germany, tribal laws promulgated called for restitution sanctions for both violent and non-violent offenses. England also, the laws included detailed restitution schedules. India never lagged behind. We often find such kind of discourses in the old king's way of justice system. And even in the starting from after independence also, the role of panchayats had been very, very important, reconciling the small petty issues. But it is not always taken in a very good taste. If I just refer to recent developments, the role being played by Khap panchayats. In their own view, they are restoring justice, but I don't feel honor killing can be taken as a restoration of justice. New wings of restorative justice are there, keeping forward from where we started. In fact, in India, when we talk about upliftment of weaker sections, it may be subject to criticism when we refer to the topic of reservation, but again, if we turn back the pages of history, the kind of treatment given to the weaker sections, the Brahmanism's impact, this is nothing but a kind of restorative justice. But excess of everything is bad. So that is why it is subject to criticism. Impact of this restorative justice, and certain questions immediately come into mind. But just reading some news item which appeared in 2019, one girl of the age of 13 years residing in US, she ran away from home, stayed for some days with her teacher. Her teacher took her to her parents back, and there was a round table conference, a dialogue between the family members and the daughter. Daughter initially hesitated. She was panic stricken, and ultimately what came into light was that for years her father was sexually abusing her. That is why she ran away. The dialogue, there was no such sexual abuse, and the father fell sick and died after 3 years. I can I have not met any such person to whom justice was restored or who was in favor of restoration of justice. I read only in books. I can just mention one book, Restorative Justice in Practice by Thomas Shepland, Robinson, and Angela Sorsby. Number of case studies are mentioned in this book. In one case, one girl was assaulted and even robbery was committed. The question was of restoring justice. There was a meeting, there was a dialogue. The family members of the girl who committed the crime were also present. The girl felt repentance, remorse, and the parents informed that they were the bad parents. That is why their daughter fell into bad company. She became drug addict, and because of drug addiction, she resorted to such kinds of crimes. That accused tried to take the victim's hand in her hands and trying to promise. Now, this was kind of restorative justice. Now, I'm just inclined to talk about the other side of the picture also. The accused committed robbery again, twice. Now, no option. Even though we say we don't want a tooth for tooth, a nail for nail, eye for eye. We want to give opportunity to the offenders to be reformed. But where repetitive offenses are committed, fourth, to give a signal to the society that ultimately, consequentially, the people will take a casual approach, pay, escape the punishment. Now here, the case study I am mentioning, here she was sent to prison after that. There are a number of case studies where even petty offenses are committed. Now I can quote one decision in 2020 by the Supreme Court, Virendra Kumar versus State of Himachal Pradesh. Justice Naveen Sinha really rightly stated, criminal jurisprudence mandates balancing the rights of the accused and the prosecution. Absolutely right. Now, this is what restorative justice is, where we have to look from the angle of the victim, from the angle of the offender, from the angle of the community, and then through a meeting, through a dialogue, for repairing the relationship, this is required. Now, if I raise certain questions, now those questions we have to think of. Whether this restorative justice system is victim-oriented, or what do we mean by victim-oriented? Whether victim's consent is there, or some kind of force, maybe by the police, maybe by the family members. So that has to be ensured. Whether, if compensation is paid, can she be rehabilitated? Can, to some extent, a status quo be granted? A status quo. A broken person, a person shocked, living in trauma after what happened to him or her. Unexpectedly, without any reason, without any fault. Now, this is what happens, especially in the sexual offenses against girls and women. Now, here we have to rehabilitate. Rehabilitation does not merely mean financial rehabilitation. Can compensation revive the emotional state, the mental state? And we have the studies, if we discuss with psychologists, that if any sex crime is committed in the childhood, especially when the close relatives like father, uncle, brother, they sexually abuse, the impact is onset of any mental disorder later in life. Now, so the question is, now can we repair? Can we pay for that loss? It is not always possible. Another question from the victim-oriented point of view, we have to take care of safety of the victim. Because hypocrisy has a place everywhere. False promises are made for self-interest. So we must take into account long run risk, because after a few years, the victim will be lost in oblivion. Even the police doesn't remember, society doesn't remember, and one day the news item comes, the same accused who expressed remorse, repentance, realization, committed offense against the same victim, just to take vengeance. Another very important thing is, because once a wrong is done to anybody, to me, I will feel like that justice must be done. The person who has committed it must be punished. Under certain circumstances, I may convince myself the person who has committed offense is also a human being. Circumstances forced him. He never intended to commit this crime, but it was committed inadvertently, without any intention, without any motive. But whether my family will support me, whether the society will accept me, we can go and ask any rape victim how much stigma is caused. And nowadays, it's a fashion to cast aspersions on anybody on social media. We talk about a fundamental right to be forgotten, to forget. But can this fundamental right be enforced in the real sense? Can we wash out something from the memories of the people? That's very, very important. In fact, in the morning, in the inaugural session, even Justice Mohan Pieris, as well as Mr. Sanjay Kundu, DGP Himachal Pradesh, talked in these terms. So that is why we have to classify the offenses, where we can think of restorative justice and where we cannot. Of course, we can think of in certain cases, like small family disputes, some marital wrongs, or petty cases of theft, we can think of. Or even in cases of like simple cases where we are too sensitive to find it as defamatory. Now here, accountabilities have to be fixed. Now accountability may be personal accountability, maybe financial accountability, maybe political accountability. Political accountability in the sense that has to be ultimately implemented. We have the news items, what happened during COVID-19 pandemic crisis throughout the country. So that is why another question comes, whether racism, casteism, communalism, regional biases, these affect restorative justice. Because in certain situations, we always believe in rivalries. And lip promises not sufficient for that. Actually, implementation has to be done. Now here I would just like to refer to one news item in Spectrum News today only, 22nd October 2020, and a statement of officer from US, I quote what he says, I quote, right now in our punitive justice system, accountability is assumed to mean punishment. But in a restorative model, accountability is a much more nuanced process that involves acknowledging and understanding the harm that has happened, working to repair that harm and making a change so that harm isn't repeated. It's very, very important. Further, it is stated, when they were able to share the experience that they had of being harmed by a police. But this was a situation. Those who were harmed by police only. Police was there to protect. Now here some officers had this realization. They contacted them. Now the same process as we follow in the restorative justice system, apologized on behalf of police. It had the healing effect. Even though status quo cannot be granted, but at least some kind of assurance has to be there that whatever harm is there, the wounds on the heart or the wounds on the body will be healed ultimately. This is very, very important. Now, in the present scenario, when we are talking about alternative dispute resolution system is a very good system for the administration of justice, for the speedy trial of cases, because ultimately speedy decision will be there once somebody mediates and there is conciliation and reconciliation. Now, in one case of 2007, Delhi High Court in Anupam Sharma versus NCT Delhi very rightly said, restorative justice may be used as a synonym for mediation. The object and nature of restorative justice aims at restoring the interest of the victim. Involvement of the victim in the settlement process is welcome in the process of restorative justice. It is a process of voluntary negotiation and concentration, directly or indirectly, between the offender and the victim. Now, in fact, this is a positive step. We are passing through the journey, and we may give a final shape to this restorative justice. Need is for framing of policies where we can frame certain rules that which have to be followed for the safety of the victim, even for giving the offender the chance of rehabilitation. So I can just quote a decision in 2015, State of Punjab versus Saurabh Bakshi. Justice Deepak Mishra observed, referring to a statement of Sophocles, said when it was said, law can never be enforced unless fear supports them. Now, this is centuries old mindset that we can have proper law and order if the signal goes, if you commit a wrong, you will be punished. Now, answer to this is given by Justice Deepak Mishra. I quote, though the aforesaid statement was made centuries back, it has the pertinence in a way with enormous vigor in today's society. The purpose of just punishment is designed so that the individual in the society, which ultimately constitute the collective, do not suffer time and again for such crimes. It cannot be said as a proposition of law that whenever an accused offers acceptance, compensation for rehabilitation of a victim, there can be reduction of sentence. Even in another case of Union of India versus Madan Lal, there was a restorative justice process. Compensation was paid, but there was no reduction of the punishment. Now, I can refer to, because here we concentrate on not only on the victim, but offender as well as the community. I quote Justice Cardozo when he said, I quote, justice so due to the accused is due to the accuser too, I unquote. But this is very, very important when we make a shift from the system of punishment and we want to concentrate on reforming the offender rehabilitating the victim and creating such an environment where the community finds that it is safe to live in, and the victim as well as the offender has right to be rehabilitated. There is no dearth of decisions. Even before we talked about restorative justice, where the victims have been compensated. The judicial activism is very, very strong in India. I may refer to the case of Rudra Shah versus State of Bihar of 1983, or Delhi Domestic Working Women's versus Union of India of 1995, or Chairman Railway Board versus Chandrima Das of 2000, or Bodhisattva Gautam versus Shubhra Chakravarti of 1996, Saheli, a Women's Resource Center versus Commissioner of Police Delhi of 1990, or Neelabati Behra's case of 1990. No, there are number of decisions on this point. And I would like to quote Abdul Rashid versus State of Odisha, 2014 by the Supreme Court. Question for consideration is whether the responsibility of the state ends merely by registering a case, conducting investigation, and initiating prosecution, and whether apart from taking these steps, the state has further responsibility to the victim, whether the court performs all these responsibilities, whether there's a change from this retribution to restorative justice. Answer we found even in the legislative role in India by adding after section 357, section 357A in the CRPC, not only the responsibility of the offender to pay compensation, the fine imposed on the offender can be taken as compensation, but at the same time, because this is another question which has to be taken into account. If the offender doesn't have the financial capacity to pay the compensation, who will pay the compensation? Then comes the role of the state, which is a welfare. This is what 357A talks about, where the offender fails to or unable to pay the compensation, or where there is acquittal. Then, after all, objective is to rehabilitate the victim. In fact, what I feel is that we cannot make this restorative justice system as a rule, just as in the adversary system of justice, we talk about alternative dispute resolution mechanism. Similarly, we can refer to this restorative justice in today's administration of justice system. Thank you, and God bless all of you.
Thank you, ma'am, for such an enlightened speech, tracing the journey and route of idea or movement of restorative justice from Rome till now, from sentiment to human empathy, and from individual to social connection. Thank you very much, ma'am. Now I would like to request our next distinguished speaker, Ms. Lisa Rea, President Restorative Justice International. Can you hear me, Ms. Lisa? Lisa? Lisa, can you hear us? Are you with us? No, we are not getting any sound.
She was around, but she has just left. Maybe some technical issue. She was around.
Yeah, I mean, she is still here. I think she's not able to hear us.
She is not around.
Just
She'll be back.
Dr. Lisa, are we audible to you? We have the PowerPoint ready.
She is here. She is here.
She's here, yes. Dr. Lisa, are we audible to you?
Can somebody call her maybe? Send a WhatsApp text? The WhatsApp text?
Yes, ma'am.
Yeah, I'm just messaging her. I'm just messaging her.
Right.
There may be some issue. Maybe we can start with Jeff. He's already joined us.
All right, ma'am. That's
Let's not time is
yes. Dear participants, there is some technical problem with in joining Dr. Lisa to this. Let us start with Dr. Jeffrey's presentation and speech. Dr. Jeffrey, can...
Yes, can you hear me?
Yes. You are audible to us very well.
Okay, well, I sent the PowerPoint, but I'm not ready yet for the first slide.
It's being presented. Just a second.
Yes, I'm not ready for the first slide to be shown yet, though.
It's being presented. Yes. Are you able to see the slide? First slide?
No, not yet. I'll let you know. Can I start? Just I don't want everyone to see all the photos at the same time before I'm ready. Okay, I can start now.
I would request you to kindly switch on your video camera.
Yeah. Oh, yes, of course. Yes. Yes. Okay. I'm trying to. Oh, come on, please. Okay, hold on. Okay. Okay. Here. Can you all see me?
Yes.
Okay. Thank you. Good morning, everyone. For me, anyway, at the different time zone, Eastern Standard Time. Wrongful conviction and restorative justice. What is the connection? I spent 16 years in prison. I was arrested at age 16, as this slide shows my mugshot. I was arrested for a murder and rape, which I did not commit in New York, which is a state in the United States of America. I got bailed out and I turned 17 before the trial started. And I was ultimately wrongfully convicted of a murder and rape, despite a negative pretrial DNA test result, based upon a coerced false confession, prosecutorial misconduct, fraud by the medical examiner, a terrible public defender. Let me unpack that a little bit. In terms of the coerced false confession, many people think that an innocent person would never confess, but in fact, that it is the cause of wrongful conviction in 25% of the DNA-proven wrongful convictions. While adults have given coerced false confessions, particularly vulnerable populations also are people with mental health issues and youth. So I went to the police station for this lie detector test. The police tricked me into taking a lie detector test. They had pretended for 6 weeks that they needed my help to solve the crime, and half the time they would talk to me as if I was a suspect, and the other half the time they would pretend like they needed my help to solve the crime. As soon as they got me frightened enough talking to me as a suspect, that's when they would throw me off balance emotionally by playing up the theme of Jeff is the junior detective helper. They would tell me that these classmates, because the victim was a classmate in the high school, they would tell me that the kids wouldn't talk freely around them, but they would around me. And, let us know if you hear any rumors. They would ask me my opinion and congratulate me that my opinions were correct. Before I was a teenager, I actually wanted to be a police officer. So this unexpected early opportunity, along with my age, 16, was how they were able to throw the wool over my eyes. That's the absurdity that a 16-year-old could help in an active homicide investigation. So after tricking me into agreeing to take this test, the next day I went to the police station for the test rather than the high school. Because it was a school day, neither my mother or grandmother with whom I lived, they thought I was in school, and therefore they did not call around looking for me. They drove me to the town of Brewster, which is in Putnam County. So it was a county away, 40 minutes away by car, which meant that I was no longer able to leave on my own. I was instead dependent upon the police. There were 3 officers who came there with me from Peekskill, but then there was also the polygraphist, who was a Putnam County Sheriff's investigator, who was dressed as a civilian, and he was pretending not to be a police officer. He never read me my rights. I did not have a lawyer present. I was not given anything to eat the entire time that I was there. They gave me a 4-page brochure which detailed how the polygraph worked, but it had a lot of big words in it that I didn't understand. But then I thought, since I was there to help the police, what did it matter? Let's just get on with it. So from there, they put me in a small room and they gave me countless cups of coffee to get me nervous, to get me wired up. And right after that, they literally wired me up to the polygraph machine. And so now I was immobile. I was able to stand up, but that's it, in a very small room. And that's when this polygraphist launched into his 3rd-degree tactics. So he raised his voice at me. He invaded my personal space. He kept asking me the same questions over and over again. As each hour passed, so too did my fear increase in proportion to the time. Towards the end of the interrogation, which he kept up for 6.5 to 7 hours, he said to me, "What do you mean you didn't do it? You just told me through the polygraph test that you did. We just want you to verbally confirm it." When he said that to me, that really shot my fear through the roof. At that point, this officer, who had been pretending to be my friend, came in the room and told me that the other officers were going to harm me, but that he had been holding them off but could not do so any longer. "You have to help yourself here, you understand." Well, considering that I had maintained my innocence for the previous 6.5 to 7 hours, it was pretty clear what they meant by that. They wanted me to confess. When he added that if I did as they wanted, they would stop what they were doing and that I could go home afterwards, that I was not going to be arrested, being young, naive, frightened, 16 years old, not thinking about the long term, only being concerned with my safety in the moment. I was in fear of my life. The fact that I didn't know where I was and that nobody else knew where I was either loomed very large in my mind. I was overwhelmed emotionally and psychologically. And on top of that, there was the push-pull dynamic, because on one hand, the possibility of harm had been thrown in the air, and on the other, he had thrown me this false life preserver, telling me that I would not be arrested. By the time everything was said and done, I collapsed onto the floor in a fetal position, crying uncontrollably. Needless to say, I was arrested. I was charged with a murder and rape. A DNA test came in from the FBI lab before the trial that showed that the semen in the victim didn't match me. But instead of acknowledging they made a mistake, they instead continued to prosecute full speed ahead. The prosecutor got the medical examiner to commit perjury, to commit fraud. He claimed after the DNA didn't match me, which was 6 months after originally doing this autopsy, hundreds of autopsies later, he suddenly remembers that he forgot to document medical evidence, which he said showed that the victim, a 15-year-old immigrant from Colombia, who had been in the country for a year and a half, leading a very sheltered life. She never went anywhere unless she was accompanied by her older sister or her parents. He claimed that he found medical evidence that she had been sleeping around, which is what allowed the prosecutor to argue that it didn't matter that the DNA didn't come from me. That didn't mean that I was innocent. There was yet another person that she must have slept with before I murdered and raped her. So in order to wrongfully convict me, the prosecutor was willing to trash the reputation of the victim. Taking it a step further, he also mentioned another youth by name that he claimed had this sexual encounter with the victim. But he never set the proper evidentiary foundation for that. He never tried to prove that. He never asked this other youth, not yet, please go back to the first slide. Please go back to the first slide. Please, yeah, thank you. He never tried to prove that. He never asked for a DNA sample for this other youth. He never even called him as a witness. He simply made the unsupported argument to the jury. At the same time, my public defender essentially didn't defend me. He rarely met with me. He did not call my alibi witness in the trial, which I was playing wiffle ball when the crime happened. He never tried to discredit this medical examiner. He never explained to the jury what the DNA not matching me meant, what the significance of that was. He didn't use that to argue that that proved the confession was coerced and false. He never confronted the confession against me. Half the time, sometimes he was arguing that the confession never happened, and at other times he argued that it did happen, but that it was coerced and false. This type of scattershot approach, no doubt left him with no credibility in front of the jury. Lastly, my interrogation was not videotaped, audio taped. There was no signed confession. It was just the officer's word for it. So as a result of that, they were able to lie. They were able to leave the threat and false promise out of their story. I wanted to testify as to the crucial facts, but my lawyer wouldn't allow me to. He said it wasn't up to him to prove that I was innocent. It was up to the other side to prove that I was guilty, and he didn't think that that had happened. That's a very naive way to practice law, since there's an 80% conviction rate in cases that feature a confession. You have to confront that confession. You have to explain that confession. You have to show 5 ways to Sunday how it's false, or your client runs a very good risk of being wrongfully convicted, because the public, which is what the jury is made of, simply don't believe that an innocent person would falsely confess. But he didn't do any of that. Instead, I was wrongfully convicted and given a 15 to life sentence. I would like to share the next photo, please. Please show the next slide. This is what I looked like in the courtroom when it was announced that the jury had reached a verdict, but before the decision was made clear. Please show the next slide. This is what I looked like in the courtroom when I was given a 15 to life sentence. I had been charged as an adult, and therefore I was sentenced as an adult, and I therefore was sent to a men's maximum security prison. Please share the next slide. This is what I looked like shortly after being sent to Elmira Correctional Facility, a very dangerous place where there was 3 or 4 stabbings or cuttings every day, no shortage of other violence that did not involve weapons, and plenty of gang activity. There were many times in the course of my incarceration that I was beat up, one time in which I never lost my life. So far as the prisoners were concerned, I was a rapist, and it was their job to administer vigilante justice. I appealed my case 7 times. I lost 7 appeals, even though my lawyers were arguing that I was innocent based upon the DNA, and that my 5th Amendment rights had been violated, that the way I was questioned by law enforcement violated my rights. But the courts rejected all of those challenges. One time, when I challenged my conviction in federal court, because my lawyer was given the wrong information by the court clerk, my paperwork arrived for 4 days too late, which the district attorney argued that the court should simply rule that I was late and not even look at it. And that's what happened. And then the next 3 legal proceedings upheld that ruling. I then went to the parole board, where I maintained my innocence rather than expressing remorse and taking responsibility. But then the price that I paid for this ethical decision was that I was denied parole, and so my already unjust incarceration was extended. All told, I spent 16 years in prison, from age 17 to 32, before further DNA testing through the DNA data bank not only reaffirmed my innocence, but also identified the actual perpetrator, whose DNA was only in the data bank because, left free while I was doing time for his crime, he killed a second victim 3.5 years later, who was a school teacher and who had 2 children. On September 22nd, 2006, my conviction was overturned and I was released. I reported back to court November 2nd, 2006, at which point all of the charges were dismissed against me on actual innocence grounds. I would like to share a few more slides. Let's go to the next slide, please. Here is when I was released. This next slide, please show. This is my first hug with my mother. moments after being released, my first as a free man. Please change the slide. My mission in life is to fight wrongful conviction, to free people that this has happened to, and to prevent it from happening to other people. That's how I make sense of everything. So I received some financial compensation. I took some of the money and I started the Jeffrey Deskovic Foundation for Justice, whose purpose is to free other wrongfully convicted people. For context, the National Registry of Exonerations, as of this morning, lists from, this is from 1989 forward, 2,678 exonerations that have happened throughout the U.S. To illustrate the frequency of wrongful conviction, looking at the people in the slide, in the red tie is Fernando Bermudez, who did 18 years in prison prior to being exonerated. To my left is Jabbar Collins, who did 16 years prior to being exonerated. To his left, you might recognize Raymond Santana from the Central Park 5 fame. Change slides, please. So in our years of existence, we have been able to free 7 wrongfully convicted people, and we have been able to pass 3 laws aimed at wrongful conviction. The first person we exonerated is the man in this slide, William Lopez, who did 23.5 years in a shotgun murder in Brooklyn. His daughter was 1.5 at the time William was wrongfully convicted. By the time he came back out, she was 25. Mr. Lopez's entire adult life was stolen from him because he passed away after living just 1.5 years as a free man. But I take comfort, at least he died free. He died with the world knowing he was innocent. Let me see the next slide, please. The next person to my left the next person in the slide to my left is William Hawhey, who did 8 years and 4 months in an arson wrongful conviction case that was actually an electrical fire. In this case, we got the district attorney to stipulate that he was in fact actually innocent. Let me see the next slide, please. So this is another one of the foundation's clients, the same polygraphist who forced the confession out of me, did the same thing to Andrew. I will make an announcement here live, which has not come out yet in the US, but will in a day or two. Mr. Krivak's conviction, which has been overturned, that's been known. And then the prosecution appealed and the reversal was upheld. The prosecution has just announced that they will agree to Mr. Krivak being bailed out. So he will be bailed out after being in prison for 23.5 years. So he will be released on Friday or Monday. You heard it here first. Next slide, please. This is Michael DeLoe, another foundation client. He was wrongfully convicted, child molestation, even though there was a partial DNA found on the outside of the underwear not matched to him. Here, the foundation has been able to assist Mr. DeLoe in his quest for exoneration by hiring numerous experts to support the work that the lawyers, which the foundation was able to bring in, have done. Let me see the next slide, please. In doing advocacy work, I felt it important to pursue formal education. So this is a photo of when I got the master's degree with my thesis written on wrongful conviction causes and reform. Next slide, please. I got tired of sitting in the courtroom in the front row. Even if I had collaborated and worked with the lawyer, I could not sit at the desk. I could not directly address the judge or representative of the clients. I got tired of that. And so I made a foray into law school. And so this past May of 2019, I graduated law school. You heard it here first. I'm going to be sworn in Monday to receive the law license to be able to represent people myself. I want to share a story. When the actual perpetrator was sentenced, the victim of the crime came into court and she made a victim impact statement, and she said a couple of things powerful in the courtroom. She was critical of the actual perpetrator, who remained silent while I did time for his crime. And then she said, that she invited everybody who was involved in my wrongful conviction. She invited all of them to bow their heads in shame. About a month, we had a cheerful reunion outside of the courtroom, and we exchanged cell phone numbers. About a month later, they called me, and at their request, I spent a pair of weekends with them at their house. It was very cathartic. They empathized with me. I could relate with them. Many of them, for many years, thought I was guilty. Some of them hated me because I was responsible. They thought I was responsible for the murder and rape of their family member. On my end of it, I was able to explain how the police were able to coerce the false confession out of me. You know, crime victims and people who are wrongfully convicted, we're not opponents. We're actually on the same side because we're all victims of injustice. And I think that there's a lot of healing. There's working together on wrongful conviction prevention. For example, beyond the foundation, I'm also sit on the Global Advisory Council of Restorative Justice International. You'll hear later on from Lisa Rea, the president of that organization. Lisa and I, as an example of restorative justice and wrongful conviction and crime victims working with exonerees, we worked together in passing the first in this country, the Commission on Prosecutor Conduct in New York, where Restorative Justice interviewed me on podcasts, and they wrote memo of support in an op-ed that was published. And the memo went to the governor, and we were able to persuade the governor to sign that law. So that's an example. There's a lot of healing, and there's also camaraderie and warmth, healing that both populations need deeply. I want to talk about application of restorative justice and wrongful conviction. Well, the first level is between the exoneree and society. So it's very important that society pay compensation. My life was very, very difficult for the first 5 years because I was released with nothing. I lacked stability of housing. I nearly ended up in a homeless shelter. That I was unable to obtain gainful employment. So society giving compensation is extremely important. That's part of that reconciliation that's critical. So too is the immediate providal of immediate assistance in reentry. Society should automatically provide all exonerees immediately with housing, cost of living expenses, doctor and dental care, mental health services, access to public transportation, job training, job placement, classes on technology. In addition, it's extremely important for the district attorney or a governmental official to apologize to the exoneree. That acknowledgement that a wrongdoing happened, that affirmation of innocence is very healing. While I received a symbolic apology from the judge and the prosecutor, neither of them were their counterparts originally involved into my wrongful conviction. I was denied that apology that I so need even now. Another level of restorative justice and wrongful convictions between the exoneree and the crime victim family. My story with the Rea family is an illustration of that. The next level is between the exoneree and law enforcement. The people involved in the wrongful conviction, directly or indirectly, should apologize. There's a place for restorative justice in law enforcement coming to reconciliation with the second victim's family. So, for example, the law enforcement, before I was released, law enforcement, they met with the victim's family, and they explained to them that it would be on the news that I had been innocent, that they had arrested the wrong person. So law enforcement owes crime victims apology for having that scab ripped off because their original actions caused injustice to happen in the first place, and those feelings of dislike and sometimes hate. That's attributed to the feat of law enforcement. There's room for law enforcement and to apologize, make amends, engage in restorative justice with second victims' families, meaning that in my case, In my case, the second victim was killed because the actual perpetrator was left free to strike again. So law enforcement really should have sought out that second crime victim family and apologized to them. There's a level of restorative justice, there's an application of it between the exoneree's family and the exoneree. When I originally used to meet with my members of my extended family, it was very awkward because they had never come to see me. Or if they had, it was only a handful of them and a handful of times. There was collective guilt on their end because they had not maintained moral support with me. They had not engaged in coming to visit me, taking phone calls, writing a letter, anything. So they felt guilt on their end. On my end, I did feel a resentment. So we did have touching conversations, and healing was able to take place. My crazy dream with me, all of you, people listening now, secondary audience, leader. I started my organization with a 7-figure donation from the compensation I received because I wanted to reach back to the men and women that I metaphorically left behind. I can't forget about them. So I made 7-figure donation. My crazy dream is this. I imagine, what if 25,000 people, for the simple price of a cup of coffee, $3, or if it's $5, what if everybody could afford to, and everybody can, what if people sacrificed that in order to help free wrongfully convicted people by becoming recurring monthly donors on the Patreon campaign? If we've been able to free 7 people, if we're able to have 11 active cases, if we're about to have somebody come home now, imagine if we were really armed for bear. Imagine the lawyers and paralegals and investigators and other essential personnel which would allow us to free more people. Imagine the policy work and passing 3 laws and then passing another 3, working in It Could Happen to You coalition, partner with Restorative Justice International. We had the oversight board for the prosecutors. Imagine what we could do. So I've put the chat, and in the chat, a link to the Patreon campaign, our crowdfunding site. Please share it virtually. I need to make it go far and wide, far outside of my network. It's not about me. I'm free. I've never taken a dime from my organization and I never will, but I can't forget the people left behind. I can't do it all myself. Amazon has a program called Amazon Smile, by which if people register for the Amazon Smile program, they donate small percentage to the organization without it costing anything to the consumer. I have the link also in the chat, and I encourage you to register for that program and to share it. It's a way to help free innocent people. And the last point that I will make is that there is a documentary short about me, which is available on Amazon Prime. It's entitled Conviction. It's about my advocacy work, it's about my life, and it's about my story. Please take a moment to watch it if you have not. Again, I have the link in the chat. I feel very honored to have been able to present on the topic of wrongful conviction and restorative justice here in this international forum in India. Wrongful conviction is not simply a U.S. problem. It is a worldwide problem. In the countries that we are not hearing about wrongful conviction and exonerations, it is not because the wrongful convictions are not taking place. What happens is no one is working. No one is working to free people. That's what's happening. So my dream is to one day have a chapter, my organization, in every country, not just every state in the US, but every country. But to do that, I need capacity. For that, I need people for whom this cause is real, who can contribute, who can donate, who can help in other ways, who can spread the Patreon link. I can't do it myself, by myself. I'm sorry. Thank you for this chance to present here in India. I feel very honored that my story and my work have reached important people in India that were aware of it and that I could be given an invitation. It happened to me. And it can happen to anybody. We all need to step up and step forward and help to whatever extent we can. Thank you for opportunity.
Thank you, Dr. Zafri. It has been really a journey for all of us participants and persons, people present here to hear your story. And your story has, I believe, moved every participant how to think about restorative justice. Without that empathy and motive and sentiment, this movement has little future. It's really enlightening to hear your first-hand experience with this traditional legal system and judicial process, where the judicial process itself becomes an end, not the justice or society or social sentiment. Thank you, sir. I would like Dr. Lisa has joined us. I welcome Dr. Lisa. Can I invite you to start your presentation and speech?
So you're talking to me? Okay. You're okay?
We can hear you very well, ma'am.
Great. Thank you so much. And I know Jeff went ahead and I listened to some of his speech. So I would like to thank the HP National Law University for inviting Restorative Justice International to participate. And I also want to thank my colleague, Dr. Upneet Lalli, who sits on our Global Advisory Council. And because of her, I know that both Jeff and myself are here today. So thank you. So let's go ahead with my PowerPoint. If we can.
Yes, Dr. Lisa, we are beginning the presentation.
Okay.
Share option. Dr. Lisa, you have the share right, making presentation right. You can start your presentation from your end.
Okay, I think you're doing it on that end. You should be able to start it yourselves there, and I'll
just give us a moment. Please give us a moment. We are starting it. We're starting in a second.
Great. Okay, and yeah, there you go. Okay, perfect. I'm going to shut this so you don't see me. And I'll come back. Okay, so this is an introduction to Restorative Justice International. And my organization, I'm the founder and president of RJI. We were founded in 2008, actually through social media, through LinkedIn. And the organization now has over 6,000 members and affiliates. So we're national and global. And the focus of Restorative Justice International is to advocate for victims-driven restorative justice. But what we care about, though, is not just restorative justice, but systemic justice reform. RJI is an advocate. We do advocacy work for restorative justice. We provide an opportunity for criminal justice organizations and other interested parties to network around the globe. We educate about restorative justice. We do international podcasts. We've actually produced 34 podcasts. Upneet is on one of them, and so is Jeffrey Deskovic. But we take on issues related to criminal justice reform on those podcasts. And also, we care about systemic justice reform, including mass incarceration. We care about encouraging the use of alternatives to incarceration. We support humane ways of treating prisoners. We're interested in COVID-19. We've done quite a bit on that. And we care about wrongful convictions. Okay, and so there's our website. You can find out more information. So next slide, please. Next next slide, please.
Yes, it is taking time.
Okay, there you go. Actually, that's just me presenting in California. So there I am. And so the next slide, we're going to actually start a short video. Let me explain what it is. So it's a short video about Restorative Justice International. It's a little dated, but it's still, I think, very important to watch. Two crime victims tell their stories in this video, and one is Russ Turner from California, and the other is Therese Bartholomew from North Carolina. And you'll get a sense of the work that we do, especially with crime victims. So in the next slide, you should be starting the short video. There you go. You should be able to click on it. There you go. Thank you. No audio, I don't think here. There should be audio. Do we have the audio? Having problems? Okay. If there's problems, we can stop.
I think the video and the audio is not coinciding.
Okay, you can. We don't have to use it then. Should we? You want to just go back to my presentation? Would you like to just go back?
Just go back.
Okay, I think let's just go. Well, you want to just quit and not try? Sounds like it's a problem. Okay, let's just do that. Okay. Okay, yeah, sometimes that's a problem. Let me just tell you what that was in the video. So in the video, we talked to two crime victims. Both are victims of violent crime. One was Russ Turner in California, whose son was murdered. And he talks about the importance of restorative justice to him when he lost his son. He talks about the impact of crime on his family, him and his family, and Russ Turner decided to meet his offender in prison, and they met, and that actually is shown on the video. And he supports the eventual release of his offender who killed his son. The other story is Therese Bartholomew, and she's in North Carolina. Her brother was murdered inside a bar, And she chose to meet her offender in prison, and she had never gone into a prison in her life. And some of her family members did not want her to go ahead with this, but she met and she told the offender that she forgave him, and that man is free today. He was sentenced to a shorter sentence. This video, by the way, is on our website. So all you need to do is go to restorativejusticeinternational.com. And if you go inside there, you'll see the video and you should be able to use the link. Okay, so now we'll move on. There is one other video, and if we have trouble, we'll eliminate it as well. Okay, so I'll shut this now. So we'll move through here. This is, no, go back to the last one. I'm sorry. Victims-driven restorative justice. There you go. Thank you. Okay, so a definition. Some of you might not have heard of the idea of victims-driven restorative justice, but that's actually our mission and our goal to support it. Now, what is victims-driven restorative justice? So I'll just read through these points and then make some other comments. So restorative justice processes must include the victim of crime or victim's family. And we see it as, it's not restorative justice if it excludes victims or their families. And let me make a point about that. There's a lot of criminal justice reform that happens in the United States and around the world. You see quite a bit of it in the news and perhaps also in your country. But criminal justice reform in and of itself is not necessarily restorative justice. So we see it as restorative justice is not truly restorative justice unless the crime victim or family is involved. Okay, number two, it's initiated by the crime victim, ideally. So we see that it's better for restorative justice to be initiated from the crime victim himself or herself, ideally. Number three, offender accountability is key. Holding offenders accountable is something we talk about quite a bit in the work that we do. Number four, offender recidivism rates are lower and victim satisfaction rates are higher after its use. This is a very important point because Restorative Justice International supports evidence-based research in the work that we do and as we advocate for public policies based on restorative justice. And often in the criminal justice systems, in our systems around the world, experts, academics, policymakers look at offender recidivism rates or crime rates first, and they'll stop there. They'll say, well, does this program work? What are we doing to keep crime rates down, etc. But what we say is that you can look at those rates and that's very good and smart. However, we can't exclude victims. And when you look at victim satisfaction rates, with our criminal justice system, what we find is that when restorative justice is used, then victim satisfaction rates go up. So the last point is success rates are based on satisfaction of the victim or the victim's family. Okay, next slide, please. Thank you. So if you're familiar with restorative justice, you have seen these before. If you're not, perhaps these are new. But these ideas, these main tenets are taken largely from two sources. Howard Zare, Eastern Mennonite University, he's now retired, and also Dan Van Ness of Prison Fellowship International. And as you might have heard, Howard Zare is often referred to as the grandfather of restorative justice, and Dan Van Ness is called the father. And I actually work for Prison Fellowship International and Dan Van Ness. So these are the main points that are often used about restorative justice. Number one, restorative justice recognizes that crime is a violation of people and relationships. Number two, it recognizes that such a violation creates an obligation to make things right. And that's a phrase that we often use in Restorative Justice International, the idea of making things right. Number three, it requires a process that maximizes the exchange of information between the offender and the victim, and potentially the families of both. And lastly, it empowers victims in ways that promote healing while transforming the lives of offenders who participate. Next slide. Great. Okay, so this is just a little bit more information to put kind of meat on the bones. Some further guidelines for restorative justice. Restorative justice processes are more likely to involve the victim, offender, and the community as meaningful participants than to limit participation to the government as the sole active party. And in that short video that you would have seen, we talk about the fact that often the way crime is processed around the world is that crime is seen as a crime against the state and not against a victim. And so that's why this point is made, that it's wiser to involve victims, offenders, and communities in the process. So number 2, restorative justice processes are more likely to hold offenders accountable for their actions by stressing reparation to the victim. Number 3, restorative processes are more likely to emphasize the responsibilities of the offender to make things right. And restorative justice processes are more likely to be considered complete when victims and offenders are reintegrated into their communities rather than when legal obligations alone are met. And that's very important, because restorative justice injures or harms victims. They need to be reintegrated. Often we don't consider that fact, but they're harmed, they're injured, and they need to be reintegrated. But as we know, offenders, if they do time in jail or prison, they need to be reintegrated, and that's very critical after restorative justice processes where they're participating in them. Next slide. Okay, these are some simple examples of restorative justice, and the first one is probably considered the most typical example of restorative justice that most people know about, and it's victim-offender dialogue. So that's when the victim and the offender meet, often with a trained facilitator. But that is probably the most typical example in what the public sees as restorative justice. Number 2, family group conferencing and circles. So that's when the victim and their family and an offender and their family meet in a conference with a trained facilitator. And that's often also referred to now, especially around the world, as circles. Number 3, in-prison restorative justice programs. This is something Restorative Justice International really supports. I'll be talking about that a little bit later too, but we're in strong support of in-prison restorative programs. So that's bringing victims into a prison to meet with offenders. Number 4, community service. That's where the offender is sentenced to community service as part of their, quote, punishment, but where they do some kind of service in the community, and hopefully it's directly related to the crime that that offender committed and that it involves the victim in some way. Number 5, victim impact statements. That was mentioned by actually by Jeffrey, where the victim goes before the court and talks about the impact the crime has had on himself or herself. Number 6, restitution, where the offender pays restitution and ideally to the victim. And I learned a little bit earlier from another speaker mentioning the offender's ability to pay, and this is important, that the offender, it needs to be worked out in a restorative justice manner where the offender is able to pay, excuse me, their victim. So often that's agreed upon between the victim and the offender, something that makes sense and that allows that offender to pay over time. 7, drug courts. That's often where what's taken into account is that the offender is addicted and needs treatment, and that's important. And 8, citizen accountability boards, where communities or citizens are more involved in the criminal justice system locally and have a say. Next slide. Okay, this is the Sycamore Tree Project. Hold on one second, please. Pardon me. Okay, Sycamore Tree Project. This is an in-prison restorative project that I mentioned in the last couple slides. So this is one program where I was actually the director of a model restorative justice project. It was first tested in the state of Texas in 1998, and that program was a model. So we were testing it and it had never been used before. It brought crime victims into a medium security prison outside of Houston, Texas, and those crime victims were part of small groups meeting with offenders. So So these were surrogate victims, real victims, real offenders, but unrelated cases. And they met for 8 weeks, and we had a very detailed curriculum that was used by trained facilitators who I trained, and those facilitators facilitated conversations between offenders and victims to talk about these subjects that you're saying. So that's 8 weeks of content, and this project is a project of Prison Fellowship International, and it's been used in Texas and then also now around the world. But these topics that you see, what is crime was the first week. We talked about something that as simple as what is crime, but also domestic violence was discussed because often offenders had committed domestic violence crimes. The second week had victims of crime that weren't participating in the program telling their stories to both the offenders and the victim participants. This had a great effect on all participants because they heard real stories, and it was unrelated to the curriculum, but it had a very strong impact on all the people that were there. The third week was talking about accountability. So how offenders could take accountability, take responsibility for their crimes. 4, a discussion about confession. Now, let me point out too that this particular program was a faith-based program. So some of these topics you're seeing are spiritual in nature, and this project was actually considered a faith-based project, and it was Christian. However, all participants were not people of faith necessarily, but we touched on issues like this that are spiritual in nature. Confession. The next week was repentance, and so we'd be looking at source material where that subject was discussed, which was kind of tricky, but at the same time it was very deep, actually deep conversations. The next week was forgiveness. This was particularly difficult because the victims that were involved in the project were victims of violent crime, excuse me, and they didn't necessarily forgive at that hour, but we had a discussion about the importance of forgiveness in the lives of victims and offenders regardless. It showed a lot of fruit that came from it. The next week we talked about restitution and how offenders could make restitution, whether it was through monetary compensation to the victim or the family, or in some other way that might be meaningful to the victim. And in that week, I remember the victims that were participating would share with these offenders other ways that the offender could make restitution kind of symbolically to themselves or their families. And the last week was a week discussing the potential of reconciliation between a victim and an offender. And that was really the last week. And so it was the closing week. And at that time, the participants shared about the importance of the whole project, and they got up and gave their own testimony about what the project meant. Now, when I went into this project, I had never directed an in-prison program in my life because I have a public policy background. I actually did get into this at the start. So my background is I've worked in restorative justice for 25 years, but I've worked in public policy for many, many years in California. I worked in the state legislature for 3 members of the legislature. So my background is public policy, and I had never directed a program in prison. In fact, I thought they had the wrong person when I was asked to do this by Dan Van Ness. But this project had great meaning to my work because I could see then how to bring restorative justice into a prison and the impact that it had for victims and offenders, and also those who were watching. And it had the support of the Department of Corrections in the state of Texas, which was unusual. And after this project occurred, one of the victim participants, John Sage, actually started his own organization called Bridges to Life, which is still active in Texas and is actually being run throughout the system there. So I'm a big fan of this organization. Okay, next slide. Okay, this is just talking about working with crime victims. And I'm going to flip this up for you. Sorry, I'm not showing myself. So this is working with crime victims, and it's the importance of how do you work with crime victims if you never have? And there are many organizations that are criminal justice organizations, I think, in the United States and around the world that don't work with crime victims. And often they'll say to us, well, why do you? And we really started working with crime victims because we realized how important they were to be advocates for restorative justice on one hand, in public policy circles, but also because crime victims came to us and they had stories to tell and they supported restorative justice. So it's important for you to listen to crime victims and specifically to ask them about their stories and to tell us your story. And crime victims will tell you their stories. Number two, just showing respect to the crime victims, what they've gone through, and just having that kind of relationship with a crime victim. It's important to involve them, obviously contact those crime victims and say, will you be involved in our work? How can we meet your needs? What needs do you have? Number four, obviously ask questions. And let me point out this too, RJI supports a legal position of a victim's right to restorative justice. So we believe that that should be a right for victims to actually have restorative justice, that it should be presented to them as an option by the criminal justice system. Often that's through district attorneys, but we think it needs to be codified. It needs to be in our laws. Number five, offer assistance. Victims have needs and often they're material needs. And so it's important that we offer assistance, and the criminal justice system needs to do so. And lastly, it's important to work with victims organizations and their networks and to educate them. Okay, yeah, there is a video. I'm not sure if you can run that one. We can try. So go back to what you were on. It shows no, go back. I'm sorry. Should show a video. So you have to go back. Okay, let's see if we can show this one. Let me, before you try, let me just set it up. And if it doesn't work, I can explain it. So this is a short video from the UK. It's from an organization called Why Me? And it's a story of a career criminal named Peter Wolf. And it's his story and how restorative justice impacted his life. Okay, you want to try that video? You need to go back. Yes, the gentleman, number 10. Okay, and go right into it without the rest. Yeah, if you can. You should go right into the center and press play, and it should. Have,
Give us one moment. We're trying to play it.
okay.
Yeah, Lisa, maybe we can just you describing about.
Okay. Okay, it sounds like it won't work. Okay, I'll tell you the story. I actually just sent a message to everyone about this. Boy, we're sorry about these videos. They are available online. So let me just tell you, this is the story of Peter Wolf. And Peter was a criminal all his life. He, let's just keep his face on there. So Peter had a really rough life. Just go back to his face and we'll stay on that shot. Okay, so he he was brought up in a very poor part of London, and he had a rough upbringing. I'm not sure his father was present. He became pretty much drug addicted and heroin and alcohol addicted, and he entered a world of crime as a young man. And he thought nothing of committing crime day and night. That's what he says. Are we gonna try? It's a little hard to understand. It's a heavy accent. Just the audio. Oh, okay. If you think the audio won't work, I'll just continue to speak over it.
Yeah, Lisa, just be brief because I think we are running out of time.
Yes. Okay. Okay. Go ahead and you can stop the video. So the bottom line was, yeah, you could stop the video. The bottom line is that nothing affected the life of Peter Wolf until he met with one victim, and that's Will Riley. And he was in and out of prison all his life. He thought it was normal. He thought it was the best thing for himself. He didn't really care. And he didn't see those that he victimized and hurt as human beings. He just said he felt nothing. But then he burglarized an apartment in London, and it was the house of Will Riley. And Will Riley learned, and that's Will Riley right there. He learned about restorative justice, and he was asked, would you be willing to meet your offender? Okay, you can pause it. You can pause it.
Dr. Lisa, I think the sound of video is going.
Yeah, we can go on to the next. Let's just go on to the next slide. Yeah, pause it and I'll complete that. Okay, just end that. Okay, you can go to the next slide. I'm getting to the end of my presentation. Let's go to the next slide, please. Okay, let me just wrap up and say that the only thing that made a difference in Peter Wolf's life was meeting with one offender, and it changed his entire life because he saw his victims then as real human beings, and he said nothing came through until he had that meeting. And it was meaningful for Will Riley, the victim, and it changed Peter's life. He's now crime-free and has been crime-free for over 20 years. So it's a wonderful testament. Okay, and we'll just move on here, just a couple more. Just this is a little redundant, but the importance of offender accountability to crime victims. So it's important for offenders to take direct responsibility. That's best and best for a victim, and we think for the justice system. And two, it's important to take personal responsibility for the offender to do so. And number three, making things right with the victim and the community. It's important not just to make things right with the victim, but also the community that's injured. And victims care about the future intentions of offenders. That's important to them to know that the offender is not going to target them again if they're released from prison. So they want to know that the offender stays crime-free. Okay, and then the last slide. And this is just a picture of a conference in North Carolina These are all victims that are sitting with me as a victim impact panel. And each of these victims are victims of violent crime who support restorative justice. I'll just tell the story of the gentleman on the far left. His name is Stephen Watt. He was a law enforcement officer in Wyoming. He was actually in his squad car out on a rural route, and he was pursuing a bank robber. That bank robber he apprehended. The man shot Steve through the eye. He lost his eye here, and through his back. He was shot 7 times. And Steve reached out to me and said, I have a story to tell. And he told the story of how he wanted to see the death penalty in this case. He wanted his offender to die because his livelihood was taken away after this crime. He no longer could be a police officer, and he was severely disabled. But he had a change of mind. He actually, through his faith, he was told that he needed to forgive this man, and he did do so. And he actually then wanted to see the offender, and he went into prison to meet him. And after that, he actually supported the release of the offender, who got a very steep sentence. He wants to see him out, but the state of Wyoming will not let him out. But his offender's still here today. And the other 2 individuals are also victims of violent crime that support restorative justice. Okay, and last slide is the end, and I'll take your questions if there's time, Upneet.
Dr. Lisa, can we have a question or session after the speech of Honorable Dr. KP Singh?
Okay.
He's the distinguished speaker, so we'll take together all questions with respect to respective speakers. Thank
Great.
you.
Great, thank you.
Dr. Lisa, for such a enlightened and robust model of victim-driven restorative justice exercise that the scholars and administrators need to develop. Thank you. Now, I would like to invite Honorable Dr. KP Singh, former Director General of Police, Haryana. Over to you, sir.
Thank you, Dr. Chanchal Kumar Singh, and thank you, Himachal Pradesh National Law University, for giving us this opportunity to be this evening. I start from where my revered teacher, Professor Lisa and Jeffrey has left. I'll speak about the Indian criminal justice system and scope of restorative justice in that. In fact, I start with a statement that restorative justice principles have not yet established in Indian laws and rules. The criminal justice to laws and procedures. It does not recognize personal, emotional, and societal concerns. Perhaps this is the reason the idol of justice is imagined to be blindfolded. Justice is not mere adjudication of disputes. It is more than that. Doing justice calls for looking beyond. Mahatma Gandhi said, a criminal is a sick person. He needs repair of his thoughts, emotions, and mindset. He needs restoration of his status in the society. He needs without offending the emotions of the victims. Therefore, in order to do complete justice, all the stakeholders, in the police and the prosecutors in the criminal justice system, should be given freedom to participate in it. Without satisfaction of all the stakeholders, including the victims of crime, the community at large, family members of both the victims as well as the offender, would remain on papers only. I served as prison administrator for 5 long years. I found that more than 50% of the prison population do not deserve to be there. If the prisoners are asked, how many of you feel you have been wrongly convicted? As Jeffrey has already stated, 50% of the prisoners inside jail, they raise their hands. This is the level of false prosecution and conviction in India. My experience of 30 years in police department made me believe that 70% of the arrests which we are doing are unwarranted. We are resorting to indiscriminate arrest in mechanical way, both legal and illegal, merely because the police has power to do so. Unfortunately, the trend to fix responsibility of police officers for illegal arrests has not yet started in India. Madam Mr. Jaswal have mentioned few cases, but that is only very minuscule of the whole problem. False implications of innocent people in criminal cases in order to settle their social, economic, and political scores is rampant. You may be surprised to note that incidence of false implication of all the arrestees is more than 60%. These cases are registered in India under the Indian Penal Code every year. 70% of them are petty offenses. They are not even classified, they are unclassified offenses. And 7 million people are arrested in those cases every year. And more than 5% of the arrests are in those 70% cases which are of petty nature. The conviction rate in all the cases ranges between 25 to 30%. And mind it, a ground reality, 1/3 of all these cases are informally resolved outside the courts in the absence of a suitable legal mechanism which we understand as restorative justice. The criminal justice system has become a tool for oppression and suppression with little concern for the society and no concern for the human resources in the form of offenders. This is high time. We must evolve effective principles and establish them in our laws. Somebody said journey of justice must not end by sending the offenders. If I am right, Professor Mr. Jaswal has said so. Journey lies in addressing the concern of all these stakeholders. Crime is not mere disobedience of law. It results into financial loss to the affected parties and the government as well. It is an onslaught on the emotions of the victims. It is trauma for the families of both the victim and the offenders. At times, even the offender suffers from guilt after having committed the crime, and he needs safety valve to express remorse and get solace. Crimes also affect the secondary and tertiary victims of crime as well. It has negative bearing on community environment. Sometimes it has ill effect on environment as well as on wildlife too. We must not forget that offender is also a human being. It's not a happy situation for most of the offenders of law. Sometimes a person is fixed in situations and is forced to commit crime. Crime is fundamentally violation of people and interpersonal relationships in the community. And we all know that each violation should create obligations, liabilities, and responsibilities in an ideal legal system. Each damage needs to be repaired. Everything should be restored back to the prime crime situation. In any sound criminal justice system, complete justice would combine offenders' liabilities, responsibility of the state, obligation of the community, and mutual willingness of the stakeholders to repair. Van Ness in 1977 in an article said, "Crime hurts, justice should heal." Therefore, government should be responsible to preserve order and establish peace and tranquility in the society by bringing the offenders to justice. State ensure socio-economic rehabilitation of the victims and the offender, as well as the family of the members of both the victims and the offenders. Offenders should make the loss good to the victims and make up their emotional insecurity. Community should give an opportunity to the offender to express repentance and remorse, which Professor Nishta Jaswal has very rightly mentioned. All stakeholders should bear the responsibility to ensure a secure and safe social environment in the community. Let us not confuse restorative justice with ADR. I was listening in the presentation session before this session, and it was being discussed. Let us not confuse restorative justice with ADR. Restorative justice is different from ADR. In fact, it is much more than that. ADR seeks to address only legally relevant issues and protect interests of both the parties, whereas restorative justice seeks to extend the boundaries of law to address the concern of all the stakeholders. Restorative justice is a balance between the therapeutic and retributive model of justice. It recognizes rights of the offender and need of the victims. It caters to the need of rehabilitation and restoration of offenders and the duty to protect the public. And mind it, no stage is too early to start the process of restorative justice, especially in a country like India, where innocent are sent to jail just for whims and fancies of the complainant and the police. Ideally, restorative justice systems should come into operation immediately after a crime is reported. It must provide answers to multiple questions, including how to prevent false implication, how to reduce unnecessary arrest and pre-trial detentions, how to prohibit charge-sheeting innocent persons, how to do away with robotic justice. What Jeffrey was referring, it was nothing but example of robotic justice. How to minimize incarceration of those who are found guilty. How to restore the offenders back to the society as a reformed person. How to cut on recidivism and guarantee order in the society. How to cater to the socio-economic and emotional needs of the victim's family, as well as family of the offenders. How to restore peace and harmony among the parties to the conflict. How to uphold the majesty and magnanimity of law. How to reduce the expenditure of the state on unwarranted trials. An ideal restorative justice concept, therefore, must entail pre-registration counseling before registration of petty cases. I'm talking about petty cases, all those 70% cases which are of petty nature, which are not even classified by title in the National Crime Record Bureau's statistics book. Counseling and negotiation during investigation. Negotiation during trial, and in our Indian criminal justice system, compounding and plea bargaining are two concepts which are gaining ground. But have no hesitation in saying that both these provisions are redundant provisions of the Criminal Procedure Code in India. The provisions of plea bargaining are impractical, and I have not seen even a single case in the last 10-12 years when plea bargaining was introduced in the CRPC, which was settled through plea bargaining. Compounding of offense again is impractical. So we need to take care of these concepts if we really want these concepts to establish in our criminal procedures. parlays before sentence to explore non-custodial sentencing options, exploring options to minimize the period of incarceration, post-release rehabilitation schemes for the offender to prevent relapse and recidivism, compensation to the victims of crime by state for their rehab. These are some of the issues which need to be taken care of if we really want to establish restorative justice principles in our criminal justice system. Time is already too late. I conclude by saying that every revenge has a life. Every outrage is bound to die. Every injury has to heal. Every damage has a wheel. Every criminal had a past to forget, and every prisoner has a future to regret. Let us be votary of restorative justice, because the goddess of justice cannot afford to remain blindfolded anymore. The goddess of justice has to be Ardhanarishwar. Ardhanarishwar means combination of Shanti and Shakti, Purush and Prakriti, body and mind. It is not merely mind which should decide the cases, which should adjudicate upon the cases. It should also combine body and mind. That is, the emotional aspect should equally be taken care of, and emotional aspects for all the stakeholders. Let us evolve sound and wholesome principles for restorative justice and codify them in laws and procedures. Life is God's gift. Let us make every life count. I again thank the Himachal Pradesh National Law University for giving me this opportunity to be with you today evening. Thank you. Thank you very much.
Thank you very much, sir, for such an enlightened speech highlighting the status of restorative justice and its movement in India, and how far it is a goal for us in India as scholars as well as administrator and boy of justice. How far the goal of Ardhanarishwar is still to be pursued. Thank you, sir. With the permission of Honorable Vice Chancellor and Dr. Upneet, we would like to open the session for questions from participants. The participants may put their questions to respective speakers by unmuting themselves or by texting us in the chat box. Yes, dear participants. One question on the chat box. Dear participants, you are all invited to raise your questions before the distinguished panel speakers.
Let me just make a slight comment, before anyone asks.
Yes, ma'am. Sure.
Jeff, your story really resonates so powerfully with the Indian audience out here, because we have, as Dr. KP Singh mentioned, numerous number of arrests happening. And Lisa, like you mentioned, in terms of balancing both the victims and the offenders, and the powerful impact that meetings have. What is the main concern of the person, of the victim, while meeting the offender? Jeff, could you share something? What is the main concern?
When a victim meets the offender, well, I mean, what type of emotional reaction that there's going to be? Is it really going to be something of warmth, or is it going to result in further injury, bitter words? exchanged, I would imagine maybe there's a slight apprehension to safety, and I think that all kind of thoughts come through people's minds. So it's natural that may be a minor concern, but really, I mean, the chances of something violent happening, I think, are extremely minuscule. I think in terms of victim family members meeting with someone who's been wrongfully convicted, I mean, the same type of trepidation that people naturally feel when you're seeing somebody for the first time after you've done something wrong to them, so I think that crime victim family members, they are worried that they may be blamed, have bad feelings held towards them by the exoneree. And on the exoneree's end of it, I mean, a big concern is my innocence going to be accepted, or do they still believe that I'm guilty? Do they think that I'm somehow home on some kind of technicality, not that I'm innocent? So that's where I think that there is a big role for restorative justice facilitators to step in the middle and talk to both sides and assure each side after talking to the other that this meeting is wanted.
Thank you, Jeff. I think this question I put to Lisa, can restorative justice be applicable to hardcore criminals?
Yes,
and that's
absolutely.
a question that only gets raised.
Yes, thank you, Upneet, and for the question. Well, we got a lot of feedback on here. I hope you can hear me.
Somebody needs to mute. Somebody needs to mute themselves. There's a lot of echo coming.
Yes. Okay. The video that you would have seen by the organization Why Me in the UK. So it's Why Me ? They're online, and that video about the life of Peter Wolf is an example. That's the answer to the question whether restorative justice can be applied to hardcore criminals. He was such a criminal, and he said he had so many victims he couldn't count them, and most of his offenses were violent acts. So until he participated in restorative justice, he said he did not see the victim as a human being. And just that one meeting that he was reluctant to participate in, by the way, changed his life. So it's, the other point is that evidence-based research that we've seen around the world, a lot of it it's really coming from many, many places, but I'd cite the UK, I'd cite Ireland. There are so many places. It shows that restorative justice is actually more effective with offenders who committed violent offenses. Now, some people, especially public policy makers, might say, well, I don't see that. I see it working with juveniles who are nonviolent offenders. Well, the evidence says just the opposite. So what we argue at RJI is that you need to apply it to all offenders, all offenses. Because what it does is, and many of you have made this point, it humanizes both sides. So the victim sees the offender as a human being, where he or she never did before, and the offender sees, I didn't commit this crime against the state, but against a real human being, and I need to make things right.
Yeah, since that was one of the points that was there in the morning as well. And I recall, another powerful movie is The Meeting of Alden Griffith as well. So just, mention about that.
Yes, let me mention that. So we support two individuals in Ireland, and one is a victim of violent crime named Albie Griffith. And she was violently raped. And she later in her life chose restorative justice. In Ireland, she barely knew that restorative justice existed until somebody came to her and said, you might be interested in this. And her life had been so traumatized after this very violent act against her that she really could not continue on with life. She said she lost a lot of weight. She couldn't really work anymore, and she was a young woman. But she went to an individual named Dr. Marie Keenan, and she's with the University of Dublin. and Marie Keenan does a lot of restorative justice with victims. So she walked her through it and said, you know, maybe this is something you want to consider. Now that the meeting is a film about Albie Griffith meeting her offender, and it's actually, it was made for a movie where the real offender is not in the movie. But anyway, the meeting occurred, and what's very interesting about it is that when I saw the film and talked to the victim, I didn't think the offender came to a point of remorse. Not for me watching it, but for the victim, it was important for her to be able to take her life back, as she said, and empowered her to be able to ask the offender questions. He was willing to meet with her, but like I said, I didn't see the kind of remorse that I thought was meaningful. But it doesn't matter what I think or what the justice system thinks. It's what the victim thinks. If there was healing for her, if she saw some kind of accountability, if she was able to tell her story and let the offender know the impact that violent act had on her, then it's meaningful.
Now there's another question that has come. Would it affect the legitimacy of the state as it would take away the position of power from the state, and therefore how would the state respond?
I don't think that it would take away from the legitimacy of the state. I mean, if you think about it, I mean, the crime victim is the one victimized in the first instance, you know, first, second, and last. And you know, is there a secondary societal injury? You know, that the laws were violated and it threatens the security and safety of everybody. Yeah, sure, but that's secondary, and therefore I think that putting crime victims up first in the state, you know, representing them, that keeps the crime victim first, which is what the position is that they should be.
Can I respond to that?
Yeah, sure.
Just add on to Jeffrey's comment. I guess I see it just a little bit differently, just a little bit. So I've been doing this work for 25 years, and I've done it in California, nationally, and globally. And this is just a little kind of viewpoint, almost a political, personal position. So prosecutors often, especially in the United States, and I think it's true in many places around the world, you know, they're the first part of the justice system to work with a crime victim, the district attorney, the prosecutor. And often it's seen by the community that they are representing the crime victim. What we found, though, is in the work that I did in the California legislature when I was advocating for restorative justice in the 1990s, what I found is that district attorneys often did not support restorative justice. Now, I was surprised by that in the 1990s, but I was still learning about how the criminal justice system worked, really, in California and elsewhere. But what I saw is that district attorneys would use the crime victim to get a conviction. So the needs of the crime victim outside of getting that conviction were often, in my opinion, ignored. Now, that might not be fair for all district attorneys and prosecutors, that they don't care, but I would just say and make the case that they need to support restorative justice. They need to understand that there needs to be more healing in the life of that crime victim, and that it's not just about a conviction. And so I have worked with Jeffrey Deskovic and others around this country and around the world to start supporting prosecutors who support restorative justice, that they need to learn what it is. And we actually, as an organization, have endorsed candidates in the United States who were saying, okay, now I understand restorative justice is something different. It's about healing in the victim. It's about accountability. And at times, as you were saying, you know, it doesn't mean it's necessarily a prison sentence. It could be that it's something else, because it has to be meaningful for the crime victim. But anyway, look at the system that way, and especially through the eyes of prosecutors, we need to educate them so they understand what restorative justice is, and that it brings a new kind of justice with a new kind of vision for what justice is.
I just would like to add a comment just on a different point, but intersecting with the question. Victims also have a right that the best practices will be utilized by law enforcement to maximize the chance that the actual person is arrested and not the wrong person. Quickly, the cause of wrongful conviction, misidentification in 75% of the DNA proven wrongful convictions, and false confessions causing wrongful conviction in 25% of the cases, and lying informants in 15. There is a powerful documentary by 60 Minutes referencing Jennifer Thompson Canino, who was raped. And because the police used totally inadequate identification procedures, she ended up misidentifying Ronald Cotton. And Ronald did like 11 years prior to DNA exonerating him. And, I've been a lot of Jennifer's public talks, she references the importance of identification best practices being used, because in a lot of ways that re-victimized her. So I think, those reforms to maximize chance victims have a right to that. We don't want to re-victimize them. And again, to build on our theme of, exoneree and crime victim, family, et cetera, reconciliation through restorative justice. I mean, in a lot of ways, the dynamic between Ronald and Jennifer are illustrative of restorative justice. I mean, they met, they had a healing conversation, they're friends. They actually wrote a book together called Picking Cotton, and they've done quite a bit of presentations around the country and other types of advocacy together. And Jennifer's a very avid advocate on wrongful conviction. So again, another role for victims within criminal justice reform in harmony on the same side as people who've been wrongfully convicted.
Thank you, Jeff and Lisa.
I had a question.
We have another question for our restorative justice. Is the role of psychoanalysis, especially in the case of the offender suffering from neurosis?
Upneet, who are you addressing that to?
Maybe you could answer that, because I mean, from the point of view, we don't have any. We really don't have any psychologists being associated with the criminal justice system at any. So I guess it's from that viewpoint as well, and we'll again work with like different dimensions of mental health issues.
Yes, let me actually mention one of our colleagues. On our Global Advisory Council that Upneet sits on, there are 12 representatives from 12 different countries, and one of the countries represented is Brazil. And we have Dr. Paulo Moratelli, who sits on our council. He's a psychologist. So actually, as that question reads, he would be able to talk about that. But the question is, for restorative justice, is there any role for psychoanalysis, especially in the cases of the offender suffering from neuroses? Well, that's kind of, as they say, that gets into the weeds. I'm not sure that the criminal justice system looks at that issue. I guess it's a question of does an offender and a victim need to be prepared before they meet? If there's a meeting, let me give you an example. So one of the cases actually with a photo that I showed was Jane Bishop, and I didn't explain who she was. She was in the photo with me. Her sister and her unborn child and her brother-in-law were murdered outside of Chicago, Illinois. It was brutal. It was a neighbor that they knew. The man, I think, is a sociopath. The family did not want to see the death penalty in his case, but he's in for life. The family makes the case that he's clearly psychotic. One sister met with the offender in prison, and I believe what her conclusion was is he could not show remorse. He didn't come to a point of remorse, and I don't think he has that understanding. So a meeting occurred with one victim, family member, but there you have it. He's behind bars. The family believes he should never be released.
I just want to weigh in, in terms of psychoanalysis. I mean, I'm not conversant in, I do have a behavioral science degree, a bachelor's. But I'm not going to speak specifically to psychoanalysis, but I do just want to briefly mention therapy and be within the mental health general realm. And so, often there's psychological after effects or people who are wrongfully imprisoned. It's common for people to have post-traumatic stress disorder, panic attacks, anxiety. I mentioned working through feelings with regards to, crime victims or also family members of the wrongfully convicted who, didn't visit and or weren't supportive. So within that therapeutic process, I think that there's a role for mental health professionals of any discipline, and whether using psychoanalysis or any type of therapy, to at some point during the healing phase and treatment phase of that, to point out there is a such thing called restorative justice, and that can help you come to terms with other people as well as even within yourself. And so I do think that there's a role for restorative justice in that application. And I would add that that same line of reasoning applies as to people who are guilty. I mean, they often have after effects of being incarcerated, and when they're dealing with feelings of their guilt or readjustment and the emotions and everything that come with that, I think that it would be very helpful at some point for the therapist to do like a brief introduction of restorative justice and ask the person, their patient, to consider utilizing restorative justice.
Thank you, Dr. Jeffrey. The next question and comment is from Dr. Anju Ali Tiku. Ma'am, can you hear us? Kindly unmute yourself.
Oh, am I supposed to ask, or you are going to ask on my behalf?
You wanted to speak something, ma'am?
Yeah. First of all, thank you, Chanchal and HPNLU team, Professor Nishtha Jaswal, for giving me that opportunity to address the panelists. Thank you very much, Jeffrey and Lisa. It was really heart-wrenching and giving altogether goosebumps to hear from first-hand experience of an individual who has been violated, and how wrongful prosecutions can have an impact on individuals. We do understand in Indian jurisdiction, currently there is that narrative gaining momentum that yes, we are accepting that wrongful prosecutions are happening and wrongful convictions are also resulting. So how can we think and utilize this restorative justice is a new angle which had not occurred to me earlier. Thank you very much, Jeff, for that. As far as your organization is concerned, both of you, I understand that you have founded and voluntarily carrying on those functions. I was just keen to understand and know that whether you get any support from the state agencies, more so, Lisa, because you were saying that there are a lot many prosecutors who are not aware and conscious about restorative justice practices, though they are the restorative justice councils, but they are reluctant. So does it not take your energies majorly to convince them and bring them around the corner? And what kind of resistance and to what extent you get a support from the state agency so that you are meaningfully able to discharge your functions? That was a query, and certainly from Upneet, I would certainly wish to hear what is the Indian perspective. We heard the global perspectives. In the correctional administration, what are we doing with reference to children specifically, or whatever you are doing? I would certainly love to hear that. Thank you very much.
Okay, should I go ahead in response? Yes. It's a very good question. So let's see, there are a number of parts of that question. So Restorative Justice International is an association and a network. So we, as I said, we have over 6,000 members and affiliates. We don't receive support from the state per se. We don't take monies from states or from the federal government in the U.S. or anywhere else. So we work independently. We're actually not an NGO per se. But anyway, we don't get state funding, whether it's in the United States or from any other states. But we work with governments around the world. Here's an example. I've been asked to, for the third time, to present testimony in Australia on legislation relating to clergy abuse of individuals in restorative justice. This is the third time we'll be testifying and virtually on that subject. So we're asked to come in many places and to share our knowledge with governments, and we then try to bring in experts like Upneet Lalli and others on our council and others that we work with to provide expert witness. So the question about district attorneys, yes, it's very difficult. I mean, I think what we have to see globally, both in India there and around the world with the United States and others, is that we're going against the grain. So it's, like I said, I've been doing this work for 25 years. When I think of that, it seems like a very long time. It is a long time. And, you know, are we in a better place now than when I started this work? When I started working in it in 1992? Yes, we are. We've made a lot of progress, but, you know, it's a political issue, isn't it? Crime. And that it's often used by politicians to get elected and stay in office. And so what we try to do is we try to change the conversation. We need to talk about how can we be safer? How do we keep crime victims? How do we allow them to heal and be safe? And how can we change the life of offenders? And we know that around the world that we're incarcerating too many people. Mass incarceration isn't something that just happens in the US. It happens everywhere. And so restorative justice is a real alternative to mass incarceration. And it, you know, it's not a therapeutic process. What it is it's a new way of looking at justice. And it's a justice that heals, and it's cost effective. But it also, you know, speaking with Jeff, you know, wrongful convictions is something that's on our agenda. It's not the only thing, but it comes in because it's an injustice. And so restorative justice is a way of providing a vision to the world in all our states and all our countries that shows what justice can be. And that when we look at the injustices that occur, we need to take those on. And our organization has increasingly taken on issues that we feel that need to be addressed, whether it's COVID-19 and the fact that we're ignoring that COVID-19 is spreading through our prisons around the world. Upneet has been on a Global Advisory Council Zoom video where members of our council have talked about the impact of COVID around the world in prisons. And we've taken a strong position saying we must address this because you can't ignore the impact in prisons. So anyway, there's so many applications of how we take the knowledge of restorative justice and the principles and apply it to our systems.
I just would like to quickly add, I think that it's important for people that are, you know, advocates, you know, that are working in restorative justice to, you know, encourage, you know, district attorneys, law enforcement to apply, you know, restorative justice, and even getting people to commit to that while they're still candidates. I mean, Lisa and I have been doing that here in the U.S. and, you know, we've had some good success. And, you know, a lot of district attorneys, you know, they're interested in crime prevention, and that means successful reentry, and that intersects with the application of restorative justice to people. In terms of whether restorative justice can help in recidivism, I mean, for sure, I think that when they come to terms with themselves and then identify with their crime victims, you can see a transformative process take place. So I think 100%.
And can I add to that question? Yes.
Yeah.
So let me just say that to answer the question that Jeff just mentioned too, will restorative justice help in reducing recidivism? Absolutely. In fact, let me cite a study. There's an excellent study out of the UK and conducted by two professors named Sherman and Strain. And if you contact us and contact Restorative Justice International through our portal, we can provide that document to you. But what it showed was that recidivism rates drop sharply when restorative justice is used in cases of violent offenses. And not just that, but as I said earlier in my presentation, that not only are recidivism rates lower, but victim satisfaction rates are higher. And so that's why it's such an important part of your advocacy for restorative justice to public policy makers and the community, because it's a win-win. You know, victims are satisfied, which often they are not with the criminal justice system, and offenders are changed. So it's a win-win.
Thank you, Dr. Lisa and Dr. Jeffrey. We will take the last question, and I'll take organizer's privilege. Dr. Amit, I would put a last question to Dr. KP Singh and Honorable Vice Chancellor, Professor Mr. Joshua.
It's a question befacing any young scholar of my ilk. So we've just started with a new batch, and in roughly 4 decades of professional experience, both as an academics, I'm referring to my Vice Chancellor, and Dr. KP Singh as a professional police person, Chief Director General of Police. How do we revisit, in pedagogical terms, the classic divide between theory and practice? Is there a new way out of it, ma'am? For how long will we be telling our students that theory is something else, practice is something else, try merging the two? Is there a fresh perspective that I can have from this conference from both of you?
Dr. Amit, there is a vicious circle which is formed by theory and practice. Sometimes the thinkers, the jurists, they innovate theories on a theoretical basis only, reviewing the existing literature, reviewing the existing experience. And when we proceed, otherwise also in research, when we proceed, we have to see the reliability and validity of that theory, whether that can be applied to the present circumstances or as we proceed to the future in the future. And if we are not able to, then because if there is some gap between theory and practice, then of course again we have to frame new theories. Now that is very true about when we talk about theories of punishment. How as the needs of the social fabric changed with the passage of time. Now how we traveled from all this deterrence, retribution to reformation, ultimately not merely reforming the offender, not concentrating on the rights of the accused, we are concentrating now conclusions. If we have to I can simply say that no doubt there are many experiences shared by Jeff, by Lisa, Sanjay, even Justice Mohan Peris, Dr. KP Singh, even in the restorative justice. And what we need because of the innocent whom we call as accused, we need for the sake of victim. But still certain doubts are just going in my mind. I understand, Upneet also said in the morning that a rape victim can ask the rapist, why did you do it to me? I understand that, but still we cannot reach the conclusions that ultimately justice will be restored. I have still doubts may not be in my mind. I understand the theories, I understand the practice, but in my heart, being a female especially, it's very, very difficult to pardon somebody. It's very, very difficult to accept, especially I can talk from the angle of Hindu philosophy, that where is justice? Where is the fruit of karmas? How can I see the next birth that the person who did wrong to me got fruit? The result of his karma, his deeds. But at the same time, being an academician, after listening to so many discourses, I can conclude that yes, we have to trod this path of restorative justice, but cautiously. Because I made one statement, I'll repeat that statement. We should not give a signal of a casual attitude in the society that say sorry, pay money, and escape the penalty. In fact, whosoever mediates for this restorative justice or our criminal justice system, which is bound by, as Dr. KP Singh said, bound by the norms, the rules, the laws, has to think twice before talking of bringing conciliation between the victim and the offender. In fact, I still remember 2015, there was a news that a rape victim accepted the compensation and there was conciliation. I'm frank enough, I'm blunt enough to say that I was just shocked, and it was very, very difficult for me to digest, because I understand in many situations the underprivileged who have no godfather, no godmother, they are the victims of sex offenses. And any person from upper strata of the society can purchase the victim. Now, this is the bitter and practical reality of life. We have to see this issue of restorative justice from all corners of the pictures, 3D, 4D, 5D. I don't confine to merely a photograph. See every angle of it. And it will still take time, because this is a very, very important issue of academics, of research, of practice. I think Dr. KP Singh can add more to it. Thank you.
Thank you, ma'am.
And what Professor Jaswal has said, Dr. Amit asked why there is difference between theory and practice, and how we should convince our students that this gap is there. The answer is simply lack of research on these issues. Before acting a particular law, we have research data from the field. We do not know what actually we require, what is the need of the system. For example, plea bargain. But imposed it in our condition which we laid here by imposing it in our system. What in America, we attach the stigma of conviction in. We restricted its scope only in cases. Perpetrator of crime, they are bail within 30. So he has no incentive to go for plea bargaining. If he would have been in jail, he would have some incentive to go for plea bargaining. In the system where you can easily purchase witnesses, you will rather go for earning acquittal rather than getting a tag of conviction and then go for plea bargaining. So in fact, when we make a particular law or make a change in law, we do not go for and proper research as per our situations. We just import a concept from the Western countries or from foreign countries and just try to impose it on us without understanding whether it will be relevant in our system or not. And for that, you academicians have to take a lead. You have to lead what the public mood is, where the change is required. This is how you can convince your students.
Thank you so much, sir. Valuable words.
Thank you, sir. Thank you, ma'am. Now I would invite Dr. Upneet Lalli for offering concluding remarks of the conference. Over to you, ma'am.
Thank you, Chanchal. I think it's been one hell of a day in terms of from the morning to the session. We've had a range of speakers and we've had divergent views. Most important of all, today there has been, we've heard different voices, different perspectives, ranging from Australia to America to India. And what we have, and Sri Lanka. So it's something fantastic we have initiated today is also looking at the way we are dealing with we are responding or reacting to crime. In India, what is happening is we have started reacting. We've started reacting in terms of asking for harsher penalties, and there comes in the question, let us look at research. What has worked in other countries? Has capital punishment deterred? Has greater punishments enhanced? How many wrongful convictions are happening in our country? So all those questions that are arising in the mind, and I think most important of all is also to understand what restorative justice is and what restorative justice is not. Now, restorative justice is not forgiveness. It does not mean that forgiveness happens. We have the forgiveness project not be there. But what is important is that we hear different voices, a dialogue. It's important for victim stories to be heard. And I'll just mention, you know, for me, it was an eye-opener. We were doing this, I interviewed an acid attack victim. And the acid was thrown by a husband. And as a psychologist, I assumed that there would be a lot of trauma, and she would ask for definitely a harsher punishment for the person who's done this to her, because her face was absolutely ruined and a lot of expenditure involved on a plastic surgery. And I was really left stunned, because she did not want the man to be, for her, the punishment was a secondary option. She did not want that punishment. But the system, our criminal justice system, did not listen to her. We were giving her something that she did not want. So does the justice system respond to the needs of crime victims? And what are those needs? And I think we'll have to begin in India with looking at those needs of victims. Do they get heard in the police thana? Do they get heard in terms of their complaint being lodged, in terms of being believed, or do they get re-traumatized? And that re-traumatization that happens is so much more damaging that even compensation does not undo that bit. So what we've done today is we've heard what different aspects, but I think for all of the participants today, it's important to mull over that what it is not. And of course, we've had various aspects of where it can be introduced, what type of offenses can we use it? Is it for lesser offenses like juvenile crimes or crimes like theft or motor accident cases? In fact, Mothers Against Drunken Driving started with that campaign, and Mr. Sanjay Kundu, the DGP, mentioned about that, yes, it's possible out there. And you know, it's something that's occurring in India, that we are wanting people to be put into prison as if prison is the only solution. Now, I visit prison, and so many offenders, like Dr. KP Singh mentioned, 50% of them will say they've been wrongly convicted and that they're spending time. Even though we may punish, but is there a realization of what you have done? Is there a realization? Is there accountability? And that's where we need to begin. So it's from the first to the last end of the criminal justice system that this whole process, this whole journey that has to be there. This journey is not ending in just the first stage. It has to be right at the last stage as well. It's also important that how we are going to, and I think for India, it's important that should not just be imposed from the top, like we've done in our laws, that they're all imposed as well. So whether it was plea bargaining, as mentioned by Dr. KP Singh, it's something we transport from the West and try and replicate it in our country. It would not work. We need to look back. We need to look at our roots, at our own culture, and what fits in our culture. And in India, each state has its own different needs. So like Madhya Pradesh, I know that, yes, you know, what kind of people that you have, and we need to respond to those. So this, what Jeff and what Lisa and Dr. KP Singh and Manish Jaswal have touched upon is something very important if we are to look at the whole dimension of justice. And I would say, again, say it's something that gets perceived, that gets felt differently. It's something that, because time is short, but I think I would just say that we are where the other countries were about 30 years before, we are at that stage now. We are critiquing our system. We are realizing that it does not work. We are also understanding that, yes, we need to look at different aspects. And it's another area of concern is that we need to look at our practices, scientific investigation. When Jeff was mentioning about DNA and the other bit, we don't have those aspects really in focus. So right from the first stage of the police to the prosecution to the judiciary to the prison authorities, each wing will have to be convinced, and our policymakers will have to be, and advocacy of restorative justice will have to be a constant process in this journey while we are to initiate restorative justice. Why do we need to do that? We need to convince the public.
I just want to piggyback off the point.
Yeah, so it's, I'm just, so this whole day, what we've discussed is that it is restorative justice. We may have different views where it can be introduced, what type of offenses it can be introduced, but I would say we need to move. We don't need to be stagnant where we are and think that all is well. We need to start, we need to begin somewhere. Let us begin this journey with one single step at a time, or maybe more steps at a time. And this journey that would be there, we have the guidance, we have the United Nations framework in place where it can be used in criminal justice matters. So let's not reinvent the wheel. Let us use those principles. Those restorative justice values are going to be very important. They are very important that we have respect and dignity for all the parties concerned. When we respect, we listen. It's important for each person to be heard. And I think it's another bit about it that this whole movement of restorative justice, it's an evolving concept. It's something that evolves over time. It's something that we learn and we respond and we change accordingly. What works well in one country may not work in another country. We need to ask questions and offer assistance of all kinds, and not just monetary assistance. Even psychological assistance is very important for crime as well as for offenders. And that's the stage that we have to establish as well. A psychomotory project is something similar that we could initiate in our prisons out here. I not responded to the question that I was asked because of the time constraints, but that's something maybe for another time that I can respond to the question that was directed at me. But what I've seen is that this restorative justice and retributive justice and therapeutic justice and procedural justice, all these issues can be balanced, and we need to have a balance between all these aspects and balance between the interests of both the victims, offenders, and the community at large. That itself would be healing for the whole society. Calling for just one aspect of a justice system would be unfair, because there are different needs as well. Today, this last session and the first session, I think the last session ended with what we began with. So it's answered. We've had divergent views, and that's very important that you hear different viewpoints and decide on wherein lies the middle ground. And like our chief guest in the morning, from the former Chief Justice from Sri Lanka mentioned about the middle ground, and how even in Sri Lanka, I mean, the conflict that had been there. So we are seeing the different instances that, yes, it's working in those particular cultures, it's working everywhere, that we need to have a look at how justice is being done and whether it is being done or not. So I thank our panelists, I thank the speakers who were there in this wonderful discussion. You've touched, And more than that, I think you've also convinced that, yes, when you hear direct stories, it's important. So listening becomes very important. So thank you, Jeff. Thank you, Lisa, for sharing so much of your experience with us. Thank you, Dr. KP Singh, for sparing your time. And thank you, Ma'am Nishta Jaswal, for being such a wonderful guide and such a wonderful patron for this conference. And initiating the Law University students, I think we begin with young minds. We begin with them. We begin looking at and raising questions. I formally thank all the participants as well as the prison officers as well who have participated in today's proceedings. And I'm sure we are all enriched with the tremendous amount of inputs and brainstorming that has happened today. Thank you so much. And thank you, Chanchal. Yeah.
I hand it over to you, my colleague, Chanchal. The proceedings.
A formal vote of thanks is in order. First of all, I would like to offer sincere and deep thanks from my deepest corner of heart to our beloved Vice Chancellor, who combines not only ethics and jurisprudence of care, but also from her experience of more than 40 years, pragmatism, both in administration as well as in academics. I recollect, just a sec, I'll take some moment. When ma'am asked me to organize this conference last month, I was hesitant. I said, ma'am, this is too short a notice to organize international conference and have papers also. But ma'am said, you go ahead with it. And I sincerely thank you, ma'am. I'm able to realize that how much these sessions, these conversations, these debates were necessary so that we can start, at least our participants, at least as far as I'm concerned, my colleagues are concerned. Thank you very much, ma'am. Next, I would like to thank our collaborator, Dr. Upneet Lalli, Deputy Director, Institute of Correctional Administration, Chandigarh. Without your support, this an immense encouragement at every moment. We reached out to you and we asked you for any help, any sort of, be it concept note, be it schedule, program schedule, and anything. You are already there. But most of all, I thank you for bringing Dr. Jeff and Dr. Lisa to this conference, whereby our participants, now this is so important, the participants are patiently listening, participating from 9 o'clock till 9 o'clock, and we have crossed 9 o'clock here at Indian Standard Times in the evening. That simply highlights how important this topic and the subject and this area is, and at least every participant must have some realization, and therefore that the traditional system of justice dispensation has something wrong with respect to individuals' connection to society and others, and that has motivated them to sit for more than 12 hours in one stretch. Thank you, Dr. Lisa and Dr. Jeff, for sharing your first-hand inside story, both personal as well as a traditional judicial system with us. And last but not least, I would like to offer sincere thanks to Dr. KP Singh, former Director General of Police, Haryana, who is a prolific writer and researcher in not only in respect of legal system laws and legal concept, but also in literary area. Thank you so much, sir, for being with us and sparing time to be with us. I would also like to thank our first-year students, especially all our students, but first-year students especially, who have been throughout with us in this conference. I would also like to offer thanks to all officers of central jails of more than 6 states, I believe, and police departments in the state of Haryana, UP, Punjab, Himachal Pradesh, Jammu and Kashmir, Rajasthan. They have been very patient and they have listened very patiently so far. And least, I would like to thank my non-teaching colleagues and our technical team, Mr. Arun, Assistant Librarian, HPNLU Shimla, Mr. Hemraj, Computer Technician, HPNLU Shimla, for being with us right from morning till now. Thank you, everyone. I would hand over to Amit to offer conference.
I think the conference has already been very well summarized by Dr. Lalli and also the concluding remarks from the Vice Chancellor. So I think I need some time to come to a more compact version of what has transpired. Instead of doing that, I've been overwhelmed by the cooperation we have received from, of course, our worthy registrar, Professor S.S. Cheswal, who also happened to chair the technical session in the afternoon, for which I am extremely grateful. I'm also grateful to our professor from Delhi University, Dr. Ranju Tiku. Once again, we thank you for your very insightful comments, detailed views on each paper that came across, and to my valued colleague, Dr. Shukla, who co-chaired the session in the afternoon. With these words of thankfulness and gratitude, I would seek permission from my Vice Chancellor to announce the conclusion of this very great, very significant event in the career of a fledgling institution like Himachal Pradesh National Law University.
Dr. Amit, we never conclude. We don't take anything as ending. It's always...
Hi, ma'am. I'm not audible, ma'am.
It's always beginning. Amit, there's no ending, there's no conclusion. And in fact, today's international conference on such a burning topic, it will not end unless and until we find a place of humanity in criminal justice system. Humanity for offender as well as victim. So God bless all of us. And good night.
Thank you. Good night. Thank you. Thank you very much.
Thanks,
Thank you. This is the journey, that journey must move on. We are just moving. This is the beginning for National University Shimla. Second National Conference we organize, and we will go longer way. Thank you all of you for your cooperation, please. All the faculty members and the panelists with us today. Thank you, one and all, please. Thank you.
Thank you.
In fact, special thanks for Dr. KP Singh and Upneet. Upneet, it's a matter of pride for me. Both the students sitting together. And no, my very good friends.
And thank you, Brian Steels has also joined us. He was really
I was just seeing it. His name.
Yes.
Thank you, Brian. I hope you are feeling all right now. I think he has left.
He is still with us, ma'am. Might not be able to hear us.
He's still awake.
He's still awake.
Thank you, Lisa and Jeff. And we must remain in touch.
Thanks, Lisa. We'll be in touch. Thank you. Thank you. Bye.
I can hear you.
Yes, Dr. Brian is here.
Yes, I have been listening for the last, probably the last hour. I caught the end of Lisa's discussion and talk, and was very happy to join you all today. It's been a very long day for you all, and thank you so much.
Thank you. Coffee time. I will have coffee time.
Thank you, ma'am. Thank you, sir.
Thank you, beta.
Thank you, ma'am. Good night.
Thank you,
Good night to everyone.
Thank you, Ayush. God bless you. You have really worked
Good
very
night, sir.
hard.
Good night,
Proud of
Upneet
you.
ma'am. Okay, ma'am. Good night. Take care.
Thank you, Arun.
Arun ji भी आ गए.
Arun, Hemraj,
Thank
I
you,
can
Arun
see
ji.
you. God bless you. बेटा अब घर जाओ. अब घर की responsibility पूरी करो.
Okay, ma'am. Bye.
Okay, bye bye.